Hello, sir. Court officer.
Madam, ಹೇಳಿ.
Am I audible? I'm from Bengaluru, sir.
Ha, madam, you are audible.
Thank you, ma'am.
Calling it.
Court officer.
Yes, madam.
Ma'am, Bangalore matters, when will it be taken up?
Madam, ಸಾಹೇಬರು ಬಂದ ತಕ್ಷಣ ಕೇಳ್ತೀನಿ ಯಾವ ಲಿಸ್ಟ್ ತಗೊಳ್ರಿ ಅಂತಾರೋ ಅದನ್ನ ತಗೊಳ್ತೀನಿ.
Okay, thank you, ma'am.
Okay.
हमारा डाइवोर्स हो चुका है। अंडरस्टैंड दैट? कब से हुआ? कुछ दिन पहले ही उसकी बेटी बहुत बीमार थी और उसे किडनी ट्रांसप्लांट की जरूरत थी और डॉक्टर थी तो उसे किडनी भी मिल जाती है। आदमी को लगता है कि उसकी बीवी ने उनकी बेटी के लिए किडनी लाई है। बेटी त्रिशा के पास देखिए सिर्फ कुछ टीवी ऐप पर है। आज ही शुरू करें। Hi, this is Bhavya from Retail Farm. Today I'll explain you how processed oil is extracted at our factory. Process method is the process of oil extraction. Now, I will show you. घर के हर इलेक्ट्रिक बोर्ड में सेफ्टी होनी चाहिए, इसीलिए आपको यूज करने चाहिए ये बेबी सेफ्टी सॉकेट का। तुम यहाँ क्या कर रहे हो? तुम्हारी जॉब इंटरव्यू यहाँ है? नहीं। हाँ,
Field number 1, Srivatsa S. Hegde, base Kamte.
My lords, I seek adjournment, my lords. Counsel on record as instructed, my lords.
Counsel on record?
My lords, due to some inconvenience, my lords.
2013, madam.
But I also made some investigation. Lord, I can.
What investigation? It's allowed straight.
I got
When inquiry ಮಾಡಿದ್ರೆ? What inquiry have you done?
Some judgments. Lord,
Judgments?
Lord, I will do it. Next
inquiry.
Next week. Anyway, my lord, my
Shiva,
lord.
we have not seen.
My lords, I don't have any instruction, my lords. I'm not there.
See, counsel.
Yes, ma'am.
ಅದೇ ನನಗೂ ಹೇಳಿದ್ರು ಅವರು. I think some inconvenience ಅಂತ ಹೇಳಿದ್ರು.
All right. List the matter on 18th in the fresh matters list, 19th in the fresh matters list as the last chance. Made clear no further adjournment to be granted in the matter.
But I have made some investigation also, my lord, because.
Investigation.
ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, my lord, shortage of materials, my lord, I think.
Inquiry, sir. Hold an inquiry and
Of course,
punish.
of course.
Without an inquiry, how can you? Yes.
Please.
Right, my lords.
Bill number 2.
My lord, I'm sorry, my lord, to interrupt. Can I just make one submission, my lord? From,
Yes.
my lord, serial number 26, my lord, that KIDB matter, Bangalore bench, my lord. Will it be taken at 2:30, my lord?
I'll take it at 2:30 or I'll, 27th I'll be sitting there. I'll take it on 27th.
My
there.
lord, we have already come to Dharwad, my lord.
Oh, you're here, then I'll take
Yes,
it.
my lord,
Yes,
we are
come,
on
come.
the way, my lord. We are on the way.
Anytime you come, we'll take it. Yes.
Grateful, my lord, grateful, my lord.
Well, it's one matter for Monday, my lords. Tender matter.
Monday I'm not sitting. You should move the,
Tuesday, my lords. Tuesdays also.
Monday and Tuesday both.
Wednesday, well,
Then
Wednesday.
no problem. Why you, other courts are there.
In fact, my lords, it needs to be heard. There are another 4 petitions.
All right.
So,
Wednesday.
please.
Serial number 2. Venkatagiri Ramchandra.
My lord, I am appearing for the petitioner
Ah,
seeking the relief under a Senior Citizen Act.
correct. You are a senior citizen, notice madu.
That is,
Yes, I'll take instructions, my lords. The authorities have written a letter to the jurisdictional police to take action. That is,
ಏನ್ ಮಾಡಿದ್ದೀರಾ? The learned AGA,
please.
notice ಆಗಿದೆಯಲ್ಲ?
ಇಲ್ಲ, first time.
First time. Learned AGA is directed to accept notice for the respondents to secure instructions as to what has become of the complaint stroke representation submitted by the petitioner alleging harassment by the children, the respondents 2 and 3. List the matter on 19th in the
my
fresh
lord,
matter.
my lord, 19 months ಆಗಿದೆ. ಏನು 19 months?
19th ಒಳಗೆ ಮಾಡದೆ ಹೋದ್ರೆ ಆಮೇಲೆ we will take. First time ಬರ್ತಾರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಅಲ್ವಾ? Yes. List on 19th.
Please.
Serial
Fresh
number 3.
matters.
Rakesh Sathikatigi.
Your GST matter, my lord. Petitioner's appeal has been dismissed.
They have 4 days.
Please, my lord.
Yes. The Girish Holdman ಯಾರು? Central GST. Girish ಇದ್ರವ ಇಲ್ಲ? Girish Holdman. Learned Counsel Girish Holdman is directed to accept notice for all the respondents. List the matter on 19th in fresh matters list.
Please, my lord.
Petitioner to serve set of papers upon the aforesaid council will dispose it on that day.
Please, my lord.
Bill number 4. Vitalis Teli.
Please, my lords.
Lok Adalat.
My lords, this matter, Lok Adalat, my lords, the caveat has been filed. Parties have settled the matter at the intervention of the elders.
P.
Then-
Patil.
ಈ ಇಂಟರ್ವೆನ್ಷನ್ ಯಾರ್ದಾದ್ರೆ ಸೆಟ್ಲ್ ಆಗಿದೆ ಹೇಳಿ ಸಾಕು. Yes.
I may request
The
next week any date, my
council
lords.
Learned Counsel appearing for the petitioner submits that the matter has been settled between the parties and would report such settlement on the next date. List the matter on 17th at 2:30 PM to report such settlement. Next.
Please, please, please.
Number 5. HR Kabiyawar.
And for the petitioner, my lord.
ಡಿಲೇನಾ?
Delay ಇದೆ.
ಮತ್ತೇನೇನಿದೆ?
Short issue ಮಾಡಿದ್ರೆ
Short issue.
pre GST, 4 GST issue, your lordship.
Announcement ಇದು ಮಾಡ್ಲಿಲ್ವಲ್ಲ? ಹೇಳ್ಬೇಕು ನಾನು. First.
Your lordship, there was a batch matter.
ಒಂದು ನಿಮಿಷ. Pronounce. ನೋಡಿಲ್ವ ನೀವು? ಮತ್ತೆ ಹೇಳ್ಬೇಕು ತಾನೆ ನನಗೆ. ಕೊಡಿ. Wait, some pronouncements I'll finish it. ಶುರು ಮಾಡಕ್ ಮುಂಚೆ ಹೇಳ್ಬೇಕಲ್ಲ ಮೇಡಮ್.
Matter pertains to principal bench. Pronouncement of order serial number 1. Sridevi Bhosle.
ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಸಂತೆಗೆ ಕೊಡಿ. ಕೊಡಿ. Allowed.
Number 2. Radha R.
Please, my lord, for the response.
The writ petition is allowed in part. The impugned order so and so stands quashed. The matter is remitted back to the hands of the concerned court to consider the application filed in Order 7 Rule 10 CPC afresh, bearing in mind the observations made in the course of the order.
Grateful.
Serial number 3, Aditya Narayan.
Allowed, quashed.
Serial number 4, Vardarajan.
I appear for petitioner.
Writ petitions allowed. The impugned order so and so stands. Impugned order date 15/12/2023 passed on IA 7 under Order 6 Rule 17 stands quashed. It is made clear that the observations made in the course of the order is only for the purpose of consideration in the case of the petitioner defendant number 13, que application IA 7 filed by defendants 1 and 3, and same will not be binding or can take advantage of in any pending proceedings. In the pending proceedings. Next.
Serial number 5, Mayur D.
Appearing for the petitioner, my lords.
Allowed, quashed.
Deeply obliged, my lords. Grateful, my lords.
Yes.
Serial number 6, Parmesh Kumar.
Dismissed.
Serial number 7, Lochana S.
Appearing for the petitioner.
Petition is allowed. The impugned deficiency memos dated 25/20/2015 and 21 so and so stands quashed. The petitioner becomes entitled to consequential relief that would flow from the quashment of the deficiency memos.
Much obliged.
Serial number 8, Angad Kamath.
My lords, I appear for the petitioners in the
Writ petition 19133 of 2025 is allowed. The order dated 19/6/2025, insofar as it allows the application filed by the first respondent is set aside. The application filed by the plaintiff stands rejected. Writ petition 17889 of 2025 stands rejected.
Obliged.
Yes.
Obliged, my lords.
Yes, continue now.
Matter pertains to Dharwad bench. Serial number 5, HR Kambiava.
My lord, pre-GST, post-GST turnover is also involved, my lord. It's
in pre-GST VAT regime,
adu ide.
VAT regime registration itta?
Ha ide.
Transpose agilva?
ನಮ್ದು ಅಲಾಟ್ ಆಗಿದ್ದ 15-16 ದಲ್ಲಿ ರಿಯಲೈಸ್ ಆಗಿದ್ದು 18-19 ದಲ್ಲಿ ಅದು ಇದೆ. ಲೆಟ್ ಹಿಮ್ ಟೇಕ್ ನೋಟಿಸ್. ಲೆಟ್ ಹಿಮ್ ವೆರಿಫೈ.
ನಾನು ಹೇಳ್ತೀನಿ, ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
ಅಲ್ಲ, ವೆರಿಫೈ ಮಾಡಕ್ಕೆ ಹೇಳಿ.
Learned AG is directed to accept notice for the respondents petitioner to serve set of papers upon the learned AGA forthwith if not already served. List the matter on 21st in 20th in the fresh matters list. Yes, next.
Serial number 6,
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿದ್ರ
Next week.
ಗುರುವಾರ. ಮಲ್ಲಾಡ್
ಅದರ next week ಬರಲಿ ಬಿಡಿ.
ಹಾ
ಏನ್ ಹಾ
ಅಲ್ಲ 1 2 3 AG.
ಹಾ
ಗೋ 1 to 4 ಅವರು ಗವರ್ಮೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾ MB ಕನ್ವೆ
5 MB ಕಣಿವೆ ಮಾಡಿ. 1 to 4 AGA.
ಪ್ಲೀಸ್.
Serial number 6, Atul K.
ಐ ವಿಲ್ ಫಾರ್ವರ್ಡ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಫಾರ್ವರ್ಡ್
ಅಲ್ಲ, ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತೇನೆ.
ಯಾರಿಗೆ?
ಇಲ್ಲಿ ಕೊಡ್ತೀನಿ.
ಕೊಡಿ.
ನಿಮ್ಗೂ
ನನಗೆ ಹಾಕ್ಬೇಕು, ಕೊಡಿ. ನೀವು ನನಗೆ ಫಾರ್ವರ್ಡ್ ಮಾಡಬೇಡಿ, ವಾಟ್ಸ್ಆಪ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಬಿಡಿ. ಎಸ್. Still number
6. My lord, he is a service contractor, my lord.
Learned Eurer Sestet. Who appears?
Union of India.
MB, ಇದು ಗಿರೀಶ್ ಹುಳ್ಮನ್. ಸೆಂಟ್ರಲ್ ಎಕ್ಸೈಸ್ ಯಾರು ಮಾಡಿ? ಗಿರೀಶ್, ಸೆಂಟ್ರಲ್ ಎಕ್ಸೈಸ್.
Central Access, my lords.
Learned AGA is Learned Counsel Girish Hulmani is directed to accept notice for respondents 2 and 3. 1 MB Kanvi. Petitioner to serve set of papers upon the aforesaid counsel 20th fresh matters.
Much.
Serial number 7,
ಇವೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡೋ ಇದು ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆರ್ ಡಿಲೇ ಎರಡೇ ಇರೋದು. Yes.
For the petitioner.
ಯಾವುದು? 7
Please.
Your Lordship,
For the
submission, Your
petitioner.
Lordship. The last
This
occasion, this honorable court has directed to produce the proceedings of before the government, Your Lordship. Actually, the file is submitted before age is appearing in the
law
this-
officers.
Yes.
Please,
Yes,
Your Lordship,
ADGP.
appointment of ADGP. Alla, Vijay Kumar age is appearing.
Correct,
in,
ಹೌದು.
those
Pass over 230. Get him.
papers submitted
madam.
before this.
Yes.
Please, Your Lordship.
Ask him to come.
Serial number 8, Srinivas Nayak. JV Bharmagowda.
Office bearer selection have been deferred twice. Now, Lord Administrator is been appointed.
Who appears respondent?
I'm appearing for
R1
the
Lord is the
respondent.
returning officer who has to conduct the elections. Lord, your Lordship may kindly see, Lord, by order dated 3/11, administrator is now been appointed.
Government is not a party?
Government Lord is a
Administrator ಯಾರು ಮಾಡ್ತಾರೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿರೋದು?
government not.
ಮತ್ತೆ? Government is not a party.
Subsequently filing of the writ petition.
So, amend, implement the government.
Subsequently, that is subsequently. If returning officer comes forward to hold the election, then Lord automatically board it to.
Why is it deferred, sir? Who hope is Baramgowda?
Please.
Baramgowda.
Why is it deferred?
My lord, the returning officer has issued the endorsement annexure.
Okay, he doesn't like the candidates that are there. Why has he deferred it twice?
My lord, the returning officer, first respondent, he has published the calendar of events on 21st, my lord. 21st, 23/10/2025, my lord. On the same date, again the returning officer has published the fresh calendar of events.
Why? ಈಗ ಯಾವ್ದ್ರಲ್ಲಿ ಎಲೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ ಹೇಳಿ? ಈಗ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್
ಮಾಡಿದ್ದಾರೆ. If Sunday, Lord, if elections are Lord to be held to the Lord office bearers.
ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಯಾವಾಗ ಆಗಿರೋದು?
3/11 ಗೆ ಆಗಿದೆ. Subsequent to the filing of writ petition. 31 is the
election
ಆಗ್ಬೇಕು. Election ಆದ್ರೆ automatically that Lord board
implement ಮಾಡಿ first. Copy ಕೊಡಿ ಇವ್ರಿಗೆ. AG is directed to accept notice for the third respondent. AG Ramesh, instruction ತಗೊಂಬಿಟ್ಟು ಮಧ್ಯಾಹ್ನ ಹೇಳಿ 2:30. Copy ಈಗಲೇ ಕೊಡಿ and you implement.
Lord, I'll do it.
ನಿಮ್ ಕೊಲಿಗ್ ಅಲ್ವಾ ಅವರು?
ಹೌದು ಮಾಡ್ತಾರೆ.
ಮತ್ತೆ ಎಸ್ ಊರ್ ಕಲಿಯೋದು ಯಾವಾಗ?
Number 9, Vidyavati M. Kotur Shetter.
Appeared for the petitioner's counsel.
But I appear for the
ಬಂದಿದ್ದಾರೆ. ನೀವು ಯಾರಿಗೆ ಸರ್? ರವಿಶಂಕರ್ ಸರ್ is here.
for the impleading. But I am appearing
petitioner.
Impleading respondent.
They have filed an impleading.
All right.
I will file an objection for impleading.
Of course, my lord.
He used to be the director of the
even keeping the impleading applicant also, my lord, they have, of course, not that we are allowing it to be admitted or anything. Urgency pleaded is a meeting is required to be held for the purpose of electing a delegate to be sent to Karnataka for the election of KMF. According to them, 17th would be last date. As far as petitioner is concerned, if petitioner as president is allowed, I will call for the meeting. Impleading applicant appears to be an aspirant. Let them contest.
So whatever happens, let it happen. Make it subject to the result of the petition.
Please.
And I'll take it on.
Will be subject to the result of the petition.
Yes.
Can I? I think but there is one.
If they are objecting on the grounds that petitioner should not participate, then my lord, matter requires to be heard. I am ready.
By operation of law, my lord, he used to be director on 5/1/2025, my lord. He has no right to
see.
That's a matter to be considered.
Our case is that, my lord, he has no legal right to be represented in the society.
Legal right, whatever it is. Now if the elections are to be held on 7, Ravishankar sir, one nimisha. If elections are to be held on 17th or 18th.
Before that, my lord, we should send a delegation before 17th.
We'll keep it subject to the result of the petition. Let him also participate in it. But not on.
Yes, please, ma'am.
Lords, can I just bring this to your lordship's notice, my lords?
Yes, sir.
Lord, there is an illegal embargo for the petitioner to pursue this writ petition because on 2/6/2025 there is an order of disqualification. This order of disqualification has become final, not challenged.
Please.
He
has been disqualified by operation of law, and also the express order passed by the deputy commissioner. He has been already disqualified. And that order has been, I will demonstrate. That order has been questioned before the DR. There is no stay order. Till today, he is
There is a stay order by the DRC.
No, I will kindly pass on order. This is an order of disqualification.
This disqualified order is stayed by the DRC.
No, I will produce the original record. Kindly pass over, my lord. I will produce the original records. There is no stay for this order.
There is a stay
Pass
order.
over.
Kindly pass over.
I'll take it at 2:30.
Please.
Lordships, please.
If it is stayed, we will permit everything to go.
He has no stay.
If there is no stay, then we will pass appropriate.
Please.
Lordships.
Even that will not matter, my lord. Even that will not matter. What my learned
Fact
friend
ಏನು
is.
stay ಆಗಿದೆ ಅಲ್ವಾ?
I will
They
That is the
can
only thing which matters.
fact verify madli. The interim order there will not be of any consequence.
That's the only thing which matters.
Please, madam. I'm ready. We are concerned. From our side, we are ready. Anytime, your lordship.
230, yes.
Please, my lords.
Cell number 10, MB Hiremat.
May be connected with this case now. With kind permission.
Why 15 ವರ್ಷ?
Kind permission. There is a last date of hearing, this honorable court has directed to connect this matter along with this writ petition, but it is not connected. There is a serial number 9 also, sorry.
ಈಗ ಆಗಿದ್ದ?
Serial number 9.
ಏನ್ connected?
First petition, there is a stay order. Because of the stay order, my lord, this honorable court has pleased to stay this order, my lord. So it may be
Stay order.
first there is a, in the first writ petition number 104391, my lord.
ಮಧ್ಯಾಹ್ನ ನೋಡಿ.
Please.
ಈಗ ಎಲ್ಲಿ ಕನೆಕ್ಟ್ ಮಾಡ್ತಾ ಕೂತ್ಕೊಂಡು? ಮಧ್ಯಾಹ್ನ ನೋಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಅಡ್ಜಾನಲ್ಲಿ ಟ್ಯಾಗ್ ಮಾಡಿ. 10.
Please.
ಗಿರೀಶ್ ಯಾರು?
11 minutes. 11, please.
Number 10,
10.
MB Hiremat. Cell number 10, MB Hiremat.
Yes, I take notice for.
Learned AG is directed to accept notice. School bus ತೊಂದರೆ ಮಾಡಬೇಡಿ, ಮಕ್ಕಳಿಗೆ ತೊಂದರೆ ಆಗಬಾರದು. Learned AG is directed to accept notice for the respondents. Petitioner to serve set of papers upon the said council if not already served. List the matter on 25th.
Yes.
There shall be an interim order of stay as prayed for till the next date of hearing.
Yes.
Cell number 11, Girish Yadva.
Please.
Your lordship, it is state appeal.
State appeal?
No.
Yes, your lordship.
Madam, Bangalore bench ಅಲ್ಲ, wait.
Bangalore, ಎಲ್ಲಿಂದ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ?
ಇದರದೇನ? State appeal?
ಹೌದು. Writ petition, petitioner counsel gets been served on E9, your lordship.
ನೀವು government advocate.
The government
AG
advocate is appearing. AG is appearing on behalf of the state.
ನಿಮ್ ಟರ್ನ್ ಬಂದಾಗ ಬನ್ನಿ ಮೇಡಮ್, ಧಾರವಾಡ ಲಿಸ್ಟ್ ಇದು.
My apology, lordship.
All right, yes.
Petitioner, my lord, has been removed as a member of the respondent bar association.
ಬೆಳಗಾಮ?
Attorney bar association.
ಯಾಕೆ?
He had filed a writ petition during the election, my lord, alleging that there was dual voting going on in two bar associations. Maybe that is the, my lord, reason. But this impugned resolution has been later on inserted. It can be clearly seen. No notice, my lord, no hearing.
No notice, no hearing, no quorum.
No quorum.
ಯಾರು ಅಪೀರ್ ಆಗ್ತಾರೆ?
Previously, Prashant Kardev appeared, my lord, but I don't know if he is on the panel. My lords may direct me to take hand summons.
Learned petitioner to serve the respondent by way of hand summons. The petitioner, a practicing advocate in Athini Bar, is at the doors of this court on the score that he has been disqualified, stopped, ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Removed as a member of the bar association.
Removed as a member of the bar, contrary to law. The learned counsel for the petitioner submits that prior to such removal, which has serious economic and civil and economic consequences, has not been issued with a notice prior to such removal, and therefore there has been violation of principles of natural justice. The learned counsel would further take this court through the documents appended to the petition to demonstrate, albeit prima facie, that the subject is inserted at a later point in time into the resolution, as on the said date there was no quorum.
And no subject regarding removal.
There was no quorum nor a subject regarding the removal of the petitioner. Iden elladrallu nodta ideni. This Belgaum district, every case, I think this is 6th or 7th case. No subject, nothing, removed.
Yes.
Become law unto themselves, we'll see. Yes. So and so. In that light, the order dated 23/7/2025 passed by the Bar Association and any steps taken further thereto prejudicial to the interests of the petitioner shall remain stayed.
Instead of order, my lords may say resolution.
Resolution.
My lord said order.
Resolution. resolution dated 23/7/2025 and any action taken pursuant thereto, judicial bada, any action taken pursuant thereto shall remain state till the next date of hearing, list on 20th in fresh matters list.
Please.
ಇದು ಬೆಳಗಾಂ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಸುಮಾರು ಇದೆ. KL ಪಾಟೀಲ್ ಅವರು ಒಂದು ಐ ಥಿಂಕ್ 4-5 ಹಾಕಿದ್ದಾರೆ. ಎಲ್ಲ ಒಟ್ಟಿಗೆ
Please.
ಆಸ್ಕಿಂಗ್
Along with my lord, hand summons notice along with hand.
Respondent ಬರ್ಕೊಳ್ಳಿ. Emergent notice to the respondent apart from taking out steps to serve the respondent by way of taking out steps to serve the respondent, petitioner is at liberty to serve the respondent by way of hand summons.
Please.
Till number 12, Sharna Baswarat C.
Matter pertain to appointment of Anganwadi helper, my lord.
Anganwadi helper.
Helper, my lord. The petitioner has claimed the reservation.
23/9/2025 ಆಗೋಗಿದೆ ಸಬ್ಜೆಕ್ಟ್ ಟು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿದೆಯಲ್ವಾ ಈಗ?
ಆಗಿದೆ. 8/10/20.
Appointment agila sobe. Final list.
Final list has been declared. Your Lordship.
Final list has been published.
Not issue. Final list is what date?
8/10/25, Your Lordship.
8/10/25. Then yes, the petitioner is before this court calling in question the final select list insofar as it notifies the sixth respondent as a selected candidate for the post of Anganwadi helper. The learned counsel for the petitioner submits that the selected candidate does not belong to the Tandana.
No, my lordship. My candidature has been rejected based on I have not submitted the caste certificate, my lordship. Instead of RD number of caste certificate, my lordship, I have uploaded the RD number of income certificate.
All right. The learned counsel for the petitioner submits that the candidature of the petitioner is not considered, while the sixth respondent is considered solely on the score that the petitioner did not upload the caste certificate but has uploaded the caste
income certificate.
Caste and income ಒಟ್ಟಿಗೆ ಬರೋದು. Caste
ಇಲ್ಲ,
and
ಇದರಲ್ಲಿ ಸಪರೇಟ್ ಬರುತ್ತೆ. SC category.
Income certificate. Merely because the said defect is curable and the petitioner not uploading the caste certificate on the said date would not render the petitioner not belonging to the said caste. Therefore, the final select list, therefore appointment order, if not already issued as on today, shall not be issued without the leave of the court. In the event appointment orders are issued today, issued as on today, the same shall remain subject to the result of the petition. The learned HCGP is directed to accept notice for 1 to 5.
1 to 5.
6.
I will take hand summons. I will take hand summons.
Yes, sir. 6 by way of hand summons, 17th fresh matters.
Please.
Till number 13, Anand Arkolli.
Present petition was the consumer, my lord.
Consumer.
He was purchasing the JCB. My lord?
JCB.
Yes, please, my lord. But later on, yes, the JCB was defected, my lord. He filed the consumer petition before the consumer.
JCB was defective.
Defective, my lord. Later on, the present petitioner has filed a complaint before the consumer forum, and the consumer forum has order in favor of the present petitioner, my lord, to hand over the JCB to the accused respondent person, and the order to respondent to deposit the 50% amount to the complaint for present petitioner, my lord, for within the period of 45 days. After lapse of 45 days, the present respondent didn't refund the amount of 50% to the present petitioner. Later on, he filed the execution
Petitioner to serve on the counsel represent hand summons. The petitioner shall serve the respondent by way of hand summons. List the matter on 24th in the fresh matters list. Further there shall be an interim order. Further proceedings in the execution in the execution.
It is already ordered, my lord.
There shall be an interim order of stay as spread for till the next date of hearing.
Please.
Next.
Till number 14, SC Boti.
Preparing for the
Pondicherry.
petition.
Pondicherry. Pudi. Eಲ್ಲಿದೆ judgment?
Lord, 107/471 of 2025. Disposed on, my lord, 27/10/2025.
Yes. ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
Please.
Till number 15, Girish V. Bhatt.
This is my last. Regarding
library supervisor.
Minimum was a difference amount. Annexure P for a moment, my lordship judgment. In the earlier round, my lords, at the first round of litigation, annexure G and H. All the 96 employee library supervisors approached this honorable court. Writ came to be allowed. Subsequently, in the contempt, they issued an endorsement. One person had challenged, and that endorsement was quashed, and writ was again allowed. Again, we filed a contempt. They issued a similar endorsement second time.
Again allowed.
We challenged before my lordships.
Nanda.
In Annexure P.
My order.
ಹೌದು page 108. Start from page 108.
ಏನ್ ಮಾಡಿದ್ವಿ?
Coordinated my lords, page 117.
Detail order ಬರ್ದಂಗೆ.
117. Before parting with the judgment, it is necessary to observe that a state has repeated the same endorsement despite it being quashed to get over the contempt. Such action is to be deprecated as it would amount to contempt on a face of it, as repeating the same endorsement that are quashed by this court. This court is holding its hand in not referring the matter to the contempt court solely on the ground, on the score that the petitioner is wanting his 6 months difference minimum wages.
ಇದು ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ರು ಈಗೇನ್ ಮಾಡಿದ್ರು ಮೇಲೆ ಫೈಲ್ಡ್ ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ವಿ ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟು ದಟ್ ಪಿಟಿಷನರ್ ದೇ ಮಾಡಿದ ಪೇಮೆಂಟ್ ಓನ್ಲಿ ಟು ದಟ್ ಪಿಟಿಷನರ್.
ಬೇರೆ ಬಂದಿದ್ದೀರಾ?
ಹೌದು. ರೆಸ್ಟ್ ಆಫ್ ದ ಲೆಫ್ಟ್ ಬಿಹೈಂಡ್. ಅಲ್ಲ ಫಸ್ಟ್ ರೌಂಡ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ ಎಲ್ಲರೂ ಸೇರ್ ಹಾಕಿದ್ರು.
Please, your lordship, insofar as other petitioners are concerned, other than that petitioner, your lordship, who has got
ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿ ಅವರು ಇದು ಮಾಡಿ ಎಲ್ಲ ಮಾಡ್ಬೇಕಲ್ಲ.
because as they were before he was before the court, your lordship.
ಬಂದಂಗ್ ಕೊಡ್ತೀವಿ, ಕೋರ್ಟ್ಗೆ ಬಂದಂಗ್ ಕೊಡ್ತೀವಿ. ಎಲ್ಲರನ್ನು ಕೋರ್ಟ್ ಡ್ರೈವ್ ಮಾಡಬಾರ್ದು.
ಅಲ್ಲ ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ಎಲ್ಲರೂ ಬಂದಿದ್ರು. 19,000 ಇಸ್ ದಿ ಅಮೌಂಟ್ ಮೈ ಲಾಸ್. ನಮಗೆ ಕೋರ್ಟ್ ಫೀ ಇದು ಕೊಟ್ಟಿನಿ.
I'll take notice any
ಕೋರ್ಟ್ ಫೀನಾ?
ಅಲ್ಲ 19,000 ಇಸ್ ದಿ ಅಮೌಂಟ್ ಎಲಿಜಿಬಲ್. ಐದೈದು 6 ರೌಂಡ್ ಲಿಟಿಗೇಷನ್ ಮಾಡಿಸ್ತಾ ಇದಾರೆ. ಅದು ಪೂರಾ ಇಲ್ಲೇ ಖರ್ಚು.
ಲಿಟಿಗೇಷನ್ ಕಾಸ್ಟ್ ಕೊಡುವ ಇದರಲ್ಲಿ.
ಅಲ್ಲ ಐ ಹ್ಯಾವ್ ಪೇಡ್ ಲಿಟಿಗೇಷನ್ ಕಾಸ್ಟ್.
I have paid, I will give. Yes.
I'll take notice, your lordship,
Yes,
any
madam,
date maybe.
take notice. Learned HCGP.
1 to 6.
ಎಲ್ಲರಿಗೂ ನೀವೇ.
Please.
So list the matter on ಎಷ್ಟು ದಿನ ಬೇಕು? Objections ಏನು ಹಾಕೊಂಡಿಲ್ಲ?
2 days, 18th or 19th.
17th fresh matters ಆಗುತ್ತಾ? ಇಲ್ಲ 19th ಹಾಕ್ತೀನಿ, ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು. ಬಟ್ ರೆಡಿ ಇದೆ, ಕ್ಲೋಸ್ ಅಂತೂ ಡೆಫಿನೆಟ್ ಮಾಡಿ.
ಹೌದು.
ಎಸ್
17th
fresh matters. ಈ ತರ ಪ್ರತಿಯೊಬ್ಬರನ್ನು ಮಾಡಬಾರ್ದು.
ಹೌದು.
Grateful.
ಇದರಲ್ಲಿ ವಿಲ್ ರೈಟ್ everybody should not be driven to the court. Yes.
So far as cost is concerned, madam.
ಕಾಸ್ಟ್ ಹಾಕೇನೆ ಬರಿಬೇಕು ಮೇಡಮ್ ಅವೆಲ್ಲ.
Because as the petitioner, another petitioner has came before
ಮಿನಿಮಮ್
the
ವೇಜ್
court.
ಕೇಳ್ತಾ ಇದಾರೆ. ಎಷ್ಟು? 19,000. ಆಯ್ತು.
16.
Bar Council matter. Annexure U is challenged, my lord. The petitioner had applied for enrollment certificate. Annexure U is
ಜಾಸ್ತಿ ತಗೊಂಡಿದಾರಾ?
Please.
ಎನ್ರೋಲ್ ಆಗಿಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
ಅದೇ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ.
Please. Annexure U is challenged before this honorable court.
ಎಲ್ಲರಿಗೂ ಅರ್ಚನಾ ಮಗ್ದುಮ?
Yes.
Learned counsel Srimati Archana Magdum is directed to accept notice for the respondents. Petitioner to serve set of papers upon the aforesaid counsel. List the matter on 20th in the fresh matters list.
Please.
Next.
17 SB Patil.
The covered by judgment laws will delete the name of the rowdy sheeter in the rowdy sheet.
Covered by judgment 4504 kodi. The petitioner is before this court seeking the following prayer. The the petitioner crime ಯಾವುದು ಇಲ್ವಾ?
ಏನು ಇಲ್ಲ
ಏನು
no
ಇಲ್ವಾ?
crime. ಇದೆ 2016 lordship ಒಂದು ಕೋಮಿನ ಜನಕ್ಕೆ ಒಂದು ಏನೋ ಮಾತಾಡಿದ ಅಷ್ಟೇ ಕ್ರೈಮ್ ಏನೂ ಇಲ್ಲ.
The petitioner, the name of the petitioner is drawn in the list of rowdies in the register maintained by the rowdy register maintained by the fourth respondent. The reason for drawing the name of the petitioner was that he was a threat to the surrounding. There is no criminal case pending or registered or pending against the petitioner. This being the admitted fact, the petitioner's name being in the list of rowdies undoubtedly would cause grave prejudice to his dignity. In that light, the petitioner has submitted a representation. The representation has not met its consideration, and therefore the petitioner is before this court in the subject petition. The learned AGA would submit that if reasonable time is granted, the representation of the petitioner would be considered and appropriate orders would be passed in accordance with law. The learned counsel for the petitioner submits that in identical cases, this court, following the judgment rendered by the coordinate bench, has held as follows. Para 3. In the light of the said submission, I deem it appropriate to dispose the subject petition, directing consideration of the representation of the petitioner strictly in consonance with the observations made by the coordinate bench in the judgment quoted supra, all within 3 months from the date of receipt of the copy. 3 months better. 3 months contempt ಆಗ್ತದೆ. 3 months from the date of receipt of the copy of the order, ordered accordingly. Disposed. Dispose ಮಾಡೋದು ಬೇಡವಾ?
Yes, sir.
ಮತ್ತೆ ಯಾಕೆ ನೋಡ್ತಾ ಇದೆ?
18, Vinayak SC.
Milos, this is a GST matter. My goods are detained since 4th October 2025 unlawfully.
Unlawfully?
Despite there being no discrepancies in the goods or the document, Milos.
That we will see. Who has detained?
Respondent number 2, Milos.
First time it is coming, my lords. First time it is, first time.
The petitioner is before this court on the score that his goods have been detained by respondents 2 and 3 without authority of law. Learned AGA is directed to accept notice and secure and submit as to why the goods of the petitioner are detained, which the petitioner alleges to be contrary to law on the next date of hearing, 17th. Fresh matters.
I have prayed for interim relief of release of the goods.
No, 17th, yes.
Milord, I am ready to deposit the tax in the invoice.
19th.
19,
Please,
Silma 19, Gayatri sir.
After filing of the writ petition, they have passed an order appointing the administrator. I am seeking amendment of the petition to challenge.
ಅಲ್ಲೇ ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಉಂಟಾ?
He will take charge today. The term will come to an end on 11/11/2025. 11/11/2025.
11/11/2020.
In fact, elections are over because of the interim orders passed by your lordships in a batch of matters. KDCC bank. Petitioners are elected directors whose term comes to an end on 11th. Elections are over.
But who will be holding charge now?
The body will continue unless.
I will see. List the matter on 17th in the fresh matters list. The administrator, if not already assumed charge, shall not assume charge till the next date. Amendment. The learned counsel amended petition ತಂದಿದ್ದೀರಾ?
Petition is ready.
Learned counsel for the petitioner seek for order on IA ಮಾಡಿ. For the reasons indicated in the affidavit accompanying the application, being satisfied with the same as they are subsequent events to the filing of the present petition, the amendment stands, the application stands allowed the petitioner to file an amended petition in the next, by the next date of hearing. After serving an advance copy to the respondents, list the matter on 17th in the fresh matters list. Amil Bariri, administrator, if not already assumed charge, shall not assume charge to the next date.
Please.
Silma 20, Vishwanath
Lord,
Hegde.
permit me to appear not for the petitioner.
Yes, sir.
But the society.
One more.
Not, please not.
Serial number 20, service matter.
Howd. Lord, society, Lord, the ESI corporation, Lord, we are appointed, Lord, by the third respondent. Now, Lord, the society, Lord, is formed now by respondents number 3 and 4. And Lord, they have registered the society and Lord, a bylaw, Lord, has been framed. But if not, please turn to the bylaws, Lord. My appointment orders, Lord, I'll take note, then I'll take notes of the rules. But Annexure D, Lord, this is my appointment orders, Lord. Page 42. Lord, my appointment,
Yes.
Lord, is by the government. Lord, we are all pharmacists. I am appointed, Lord, to this third respondent. Lord, my employer is the third respondent. Now, Lord, regulations are framed at Annexure A, page 21. Can I request the court?
No, you are are you on deputation from the state?
No, I am not on deputation from the state. My
Then
appointment
what?
order
How
is there.
did you go into the ESI?
Lord, it is a commissionerate, Lord. I was appointed, Lord. Kindly see, Lord, Annexure A for a moment. Sorry, Annexure D, page 42 for a moment.
Really? One, two.
Page 42.
Learned CGP is directed to
But
accept
there's
notice
one
for the
submission.
respondents. 1, 2, 3. ESI ಯಾರು ಇಲ್ಲಿ? ESI ಇಲ್ಲಿ ಯಾರ పేరు? VV Gunjal. Learned Counsel VV Gunjal is directed to accept notice for respondents 4 and 5. The ಈಗ ರಿಲೀವ್ ಆಗ್ತಿದ್ದೀರಾ ನೀವು?
Relieve ಆಗ್ತಾ ಇಲ್ಲ. I'm not, what is being done is
The
not, I'm now being
petitioners-
shown as deputation, not one
Petitioner
submission.
shall the impugned order or date ಏನು?
But these are regulations, Lord, which is, there is no date
The
for the regulation.
petitioners, if not relieved as on today, shall not be relieved from the places that they are working till the next date of hearing. 17th fresh matters.
But from not one submission, not, I'm told that not some others have filed a writ petition before the principal bench in Bangalore. But they have challenged, not the very registration is not what I'm told. But I'll also verify that, Lord, and point out to the court. Because I don't.
ತೊಂದ್ರೆ ಇಲ್ಲ.
Please.
No problem.
But deemed deputation ಅಂತ ಆಗ್ಬಾರ್ದು ಅಂತ, that is all. Because the language used is deemed deputation.
No, I have said not to relieve. I have not interpreted deputation, deemed deputation and all that. We'll see on the next date.
Very well, very well.
Yes. Copy ಕೊಡಿ. Copy ಇದೆಯಾ madam?
ಇದೆ. Sir.
Petitioner to serve set of papers upon the learned HCGP and VV Gunjal forthwith.
Matter regarding share collection, my lords, page 107, covered matter.
10?
107.
The learned counsel Sanjana Mudol appearing for the petitioner and learned AGA.
Government for 1 and 2, my lords.
1 and 2. Both the learned counsel of the petitioner and the respondent in unison would submit the issue in the list. 106?
107.
107.
My lords, date of appearance may be fixed on 24th, my lords.
24th.
24/11.
ಸ್ವಲ್ಪ we'll fix it on 27th.
1st December, my lords.
1st December. Perfect. 1st December. Yes.
Number 22, Saubhagya Swakul.
My lords, challenging the annexure N, my lords, wherein the family court has dismissed the recalling application for the attachment of warrant, my lords, for the gratuity
Husband.
amount. My lords, please.
Husband.
No, my lords, it's between the father, the parents and the son, my lords.
What's the problem?
My lords, they are having other children, my lords.
Other
But
children?
she is, yes, my lords.
So?
But she is claiming only against this petition, my lords.
ನಿಮ್ ಡ್ಯೂಟಿ ನೀವು ಮಾಡಿ ಬೇರೆಯವ್ರದ್ದು
My lords, he is retired from the service, my lords. Up to the retirement, he is paid the maintenance amount, my lords. After the retirement, he was getting only 3,920 as the pension, my lords.
ಹೌದಾ?
Yes, my lords. I have produced the annexes, my lords.
JSW ಪೆನ್ಷನ್ ಕೊಡ್ತಾರಾ?
Please, my lords.
JSW ಕೆಲಸ ಮಾಡ್ತಾ ಇರೋದಾ?
Yes, my lords. ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು.
ಅಲ್ಲಿ ಪೆನ್ಷನ್ ಕೊಡ್ತಾರಾ?
Yes, my lords.
ಹೌದಾ?
My lords, I have produced the,
ಆಮೇಲೆ
and even the, as per the section 13 of the gratuity amount, my lords. It in
ಗ್ರಾಚ್ಯುಟಿ
the,
ಕೊಡ್ತಾರೆ ಆಯ್ತು, ಪೆನ್ಷನ್ ಕೊಡ್ತಾರಾ? PF
my
and
lords,
gratuity,
annexure
yes.
H. Annexure H may kindly be seen, my lords. He was getting monthly 3,920, my lords. It is a pension
Really?
slip.
How many children are there?
My lords, three, my lords total, 2 son and 1 daughter, my lords.
No, he is one son, is it?
Yes, my lords.
What are
And
the,
the connected matter, your lordship has granted the interim order, my lords, in the month of January.
so and so, tag this petition along with so and so same order.
My lords, other 3 petitions are there, my lords.
How many children are there, madam?
No,
You said
my
only
lords.
3?
My lords,
5
same
petitions
order.
ಹೆಂಗ್ ಬಂತು?
No, my lords, recovery proceedings 5 there, my lords.
Each son and each daughter one petition, huh?
ಇಲ್ಲ, my lords, ಒಂದೇ ಮಗನ against
Litigation
5
expenses
ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲ ಅವರು ಕೊಟ್ರೆ ಸಾಕಾಗ್ತಾ ಇತ್ತು. Yes. Same order. Yes. ಓ ಎಲ್ಲ 3 ಅದೇನಾ?
No, my lords, only 2, my lords, 22, 23. Other 3 are not listed, my lords.
Which is 24?
24th is different, my lords.
Tell me 24. ಅದು 22, 23 same order ಏನಾಗಿದೆ? 24 ಏನು?
My lords, in this case, I am challenging the annexure M, my lords, wherein the petitioner is relieved from the service, my lords. She was working as the attendant, my lords, since from 2005. And under the Women's Center Studies, my lords. My lords, without annexure M may kindly be seen, my
Correct,
lords.
but relieve ಆಗಿ ಬಹಳ ದಿನ ಆಗಿದೆ.
Without any written order, oral order of the register, the petitioner was relieved from the service, my lords. Even she has not paid with the,
ಈಗ ಏನ್ ಬೇಕು?
my
Stay
lords.
ಬೇಕಾ?
Yes, my lords. I may
ಹೆಂಗಾಗುತ್ತೆ?
be permitted to.
I will also no return order, oral stay. Stay ಆಗಲ್ಲ madam, relieve ಆಗಿದೆ. The learned.
My lords, because no one is appointed, my lords, after her
We'll
relevance.
see. Learned HCGP is directed to accept notice for respondent, first respondent.
Please.
2 MB Kanavi, 3 Hampi University, Hampi Kannada University, yaar appear.
Rashikar Gunjali.
Learned Counsel Rajshekar Gunjali and accepts notice for respondents 3, 4 and 5 petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 25th in fresh.
My lords, it may be taken after 7th, my lords, 7th December.
Urgency ಅಂದ್ರೆ?
Urgency ಇದೆ, my lords.
ಏನಿಲ್ವಾ? ಸರಿ. 8th, 7th December ಆದ್ಮೇಲ?
Yes, my lords.
8th December.
Please, much obliged.
Bill number 25, Gangadhar S. Faskeri. CS Patil.
That's request, last post. That's request, but on 12th, last post. Calipri and 12th. That's click them. That's my
12th.
Please.
List the matter on 12th. Yes. 12th, Wednesday I'll be there.
Please.
Bill number 26, Chaitanya S. Viraj. Jagdish Patil.
Before the respondent, application filed for the cross-examination by way of video conference as same could be allowed. Against that, this writ petition has been filed.
So what if it is allowed?
Allowed ಆದ್ಮೇಲೆ ಅದ್ರ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ಇವರು.
And stay.
Stay ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕಾಗಿ entire proceedings have been stayed. And one more, the respondent number 2 has filed one more writ petition, that is 102146.
Tag this petition along with so and so.
102146 of 2025.
None appears for the petitioner. Heard the learned counsel appearing for the respondent.
Number 1, your Lord.
First respondent Jagdish Patil. The list the matter on 17th along with so and so. We'll dispose both on.
Yes, your Lord.
27, Vishwanath S. Bichagatti.
Post immediately after service of notice upon the 5th respondent. Entry mode with the continue mode. Next.
Bill number 28.
My lords, on submission, my lords.
Yes, sir.
Our report in submission ಮಾಡಿದಾರಲ್ಲ.
Submitted by the ADLR, my lords.
ಯಾವ್ದು? ಒಂದು ನಿಮಿಷ 27 ಕೊಡಿ. Where is the report?
Report is submitted, my lords. Already complained.
Submitted,
Yes.
What is the report now?
As per the report, my lords, page number 5 is the map and narration, my lords. Point number 8. Petitioner property is concerned is 228/3, page number 5, my lords. Map. Report
of compliance.
Wherein, my lords, 228/3 is the survey number of the petitioner, my lords. And in that regard, my lords, point number 8, ವಾದಿಗೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 228/3 ಜಮೀನಿನಲ್ಲಿ ಪ್ರಸ್ತುತ ವಸ್ತುಸ್ಥಿತಿಯಂತೆ ಕಾಲುವೆ ಮತ್ತು ರಸ್ತೆ ನಿರ್ಮಾಣವಾಗದೇ ಇರುವುದರಿಂದ ಸದರಿಯವರ ಜಮೀನು ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿರುವುದಿಲ್ಲ. And my lords, this was went in the property number 228/2.
According to you, it is acquired.
Yes, my lords. Just I am producing some documents pertaining to it, my lords, which have been uploaded by the ADLR in the Disha and Cap, my lords, which clearly states that
it is acquired.
Yes, my lords. In the sense, it clearly demarks that in section, in survey number 228.
ಹಾಕಿದಾರಾ ಏನು ಹಾಕಿದ್ದಾರೆ? Memo of compliance ಅಷ್ಟೇ.
Memo of compliance.
Not an affidavit.
Affidavit, my lords, that is.
In fact, Nigam has also issued an endorsement saying that that canal
Not
is
acquired or
passing.
acquired?
Not acquired, not utilized. Canal is constructed in the survey number 228/3 only. That canal is not passing through his land only.
My lords, page number 1, my lords. That is the.
Earlier JMC was prepared. Subsequently, it was left out. His land has been left out.
ಅವ್ರಿಗೆ ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ. We'll list it on Wednesday.
Please, my lords.
List on Wednesday in the same stage.
Please.
Yes. Next.
Bill number 28, Santosh Appasap.
Post immediately after service of notice upon the respondent. Next.
Cell number 29, Srinivas Vinayak.
Vinayak.
Rowdy sheeter against the BS Prakash Hot judgment.
Memo filed, my lords, with number of cases. 3 cases
No,
are pending.
All cases
More
have
ಇದೆ.
been Lord acquitted.
I filed a memo, my lords, kindly see, dated 29/2025.
Memo?
Memo dated 29/2025. In page number 6 is the first FIR, my lords. In page number 12, second FIR, my lords, in there 24. Thereafter, my lords.
Yeah, offense.
70.
Atrocities Act.
Under SC Act, my lords, under section 323, 143, 147.
VS Prakash, consider.
He himself is a Lord member of Lord scheduled caste. How can Lord
Report last.
acquit ಆಗಿದೆ ಎಲ್ಲ cases?
ಎಲ್ಲದರಲ್ಲೂ acquit. The petitioner is before this court seeking the following prayer. The heard so and so. The petitioner gets embroiled in 3 crimes. Owing to the fact that the petitioner has got himself embroiled in 3 crimes, the name of the petitioner is drawn in the list of rowdies maintained before the Gadag Rural Police Station. The petitioner, after acquittal in all the cases, submits a representation seeking the removal of his name from the list of rowdies. The non-removal of the name of the petitioner is what has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner would reiterate the facts and grounds set out in the petition. The learned AGA submits that there are 3 cases pending against the petitioner, and therefore the name of the petitioner cannot be removed from the list of rowdies. The learned counsel for the petitioner would join issue in clarifying that the name of the petitioner, all those 3 cases which the learned AGA seeks to project has ended in acquittal. All of them, a few of them pertain to the offences under the Atrocities Act. The offences are laid notwithstanding the fact that the petitioner himself belongs to scheduled caste. On all these scores, the learned counsel submits that the representation of the petitioner should merit consideration. In the light of the aforesaid submissions and contra submissions, I deem it appropriate to dispose the petition with a direction to the second respondent, Deputy Superintendent of Police, Gadag, to consider the representation of the
representation ಕೊಟ್ಟೇ ಇಲ್ಲ.
ಒಂದು ನಿಮಿಷ ಹಿಂಗ್ ಮಾಡಿ. I deem it appropriate to dispose the petition with a direction to the petitioner to submit a representation to the second respondent seeking the removal of his name from the list of rowdies. In the event the said representation is submitted by the petitioner, the said representation shall merit consideration at the hands of the second respondent in consonance with the law declared by the coordinate bench of this court in the case of V.S. Prakash versus State of Karnataka, WP 4504 of 2022, disposed on 22/4/2023, wherein the coordinate bench has held as follows. Adu one box ide haki madam. Yes, so in the light of the aforesaid circumstance, in the aforesaid reasons, the following order. The writ petition stands disposed. The petitioner is at liberty to submit a representation seeking his removal from the list of rowdies maintained before the third respondent police station through a representation within 4 weeks.
Yes.
Within 4 weeks from the date of receipt of the copy of the order. In the event the representation is submitted to the second respondent shall consider the same, bearing in mind the observations made in the course of the order, and pass necessary orders thereon within 8 weeks thereafter.
Only protection is, let them not call to the police station.
So 8 weeks thereafter. In the till the compliance with the aforesaid order, the petitioner without any rhyme or reason shall not be harassed.
Please. Great.
Cell number 30, Jagdish Patil.
Writ of mandamus, Your Lords, to consider my e-tender, in spite of they accepting my technical bid accepted. You're not considered regarding this. Only writ of mandamus to consider my.
Will consider the
The
request and pass
petitioner is
requisite
before
orders.
this court seeking the following prayer. you're technically qualified, huh?
Technically qualified, Your Lordship.
The petitioner is a the petitioner is a participant pursuant to a e-tender notified by the third respondent for transportation of bulk petroleum fuel from Desur depot to various parts of the state. The petitioner is said to have been declared technically qualified for the said transportation, but no steps are taken further to that, further to the said qualification. The learned counsel S.V. Angdi appearing for the respondents 2 to 4 would all of the respondents?
Yes, all
2 to 4, Your Lordship.
2 to 4 would submit that if reasonable time is granted, a representation of the petitioner would merit consideration in strict consonance with law and appropriate orders would be passed thereon. In the light of the said submission, I deem it appropriate to dispose the petition with a direction to the respondents 2 to 4 to consider the application submitted by the petitioner pursuant to the e-tender within an outer limit of
6 weeks.
with an outer limit of 8 weeks from the date of receipt of the copy of the order, if not earlier, ordered accordingly.
Number 31, Anand Kumar Ashtekar.
Lord, I appear for
Lord,
the
serial number
respondent.
31, I am appearing for the petition in this matter, my lords.
Lord, I appear for the respondent.
Yes,
Lords,
sir.
Lords, a person claiming to be a member of the cooperative society challenges the order passed by the registrar whereby he had set aside the notices for termination. Lords, he was not a party to the original proceedings under section 70. Lords, he files an application seeking leave to file the appeal. Lord, that application is allowed at page number 43. It commences from page number 42 at page 43. Lords, the last paragraph and the first paragraph, it continues, Lords, in page 44, and application is allowed. Lords, for these two contentions, insofar as service matters are concerned, Lords, a busybody like the present petitioner, he cannot pursue an appeal and seek to do this. Duryodhan Sahu's case, para 16 to paragraph 19. Lords, R.K. Jain again reiterated Tamanna's judgment, and Srinivas Reddy's case at para 51 says there is no question of locus to any person who is not directly affected by the service matters. Number 1. 2, your lords, may kindly see section 72D. Lords, what is the dispute in respect of the service matters? Section 72D specifically says dispute can be inter se between the employees themselves or employees, past employees, LRs of the employees and the cooperative society.
Now, what is the dispute between?
Lords, the dispute is, Lords, 2018 we have been regularized into the services by the resolution passed by the
Who has been regularized?
Lords, the
Yaar-
petitioner.
All right.
Lords, petitioner along with others have been regularized. 5 to 27 we have been regularized. Lords, some proceedings were undertaken for the purposes of holding that our regularization was not proper, which we had called in question before this honorable court. If you are lords so to see, lords, at page number 17, 17. The earlier orders of this honorable court dated 16 September 2019. Lords, in this honorable court said that any steps taken behind our back for our termination based on any proceedings will be affecting us seriously.
Lord, I am appearing for the complainant. Lord, what transpired in the bank without observing any rules? I am a member of the bank. They appoint somebody. I lodged a complaint to the deputy registrar. Deputy registrar submitted a report. Based on that report, my lord, the detailed action was taken against.
You are a member of the bank.
I am a member of the bank. My lord, kindly have a look at my objection statement.
Then PL jurisdiction agoita.
Pardon?
PL
PA
jurisdiction.
lagala. PA lagala.
Mata?
I am a member of the bank.
The bank ಯಾರೋ appoint ಮಾಡಿದಾರೆ cooperative society against how is 70 maintainable?
70 ನಾನು ಹಾಕಿದಲ್ಲ.
ಮತ್ತೆ
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ I made a complaint to the cooperative registrar. Registrar conducted the inspection and submitted a report saying that the entire thing is in violation of the rules, and he directed action against the board. Kindly have a look at page.
Based upon your complaint.
Based upon my complaint. Then, my lord, disqualification was ordered.
Jurisdiction.
My lord, kindly have a look at page 67. One second. They approached the tribunal, JR, Before the JR, they included me as a party. I am party respondent number 7, page 68. ನಾನು objection statement ಅಲ್ಲಿ ಇದೆ.
ಈಗ ಏನಾಗಿದೆ?
ಅಲ್ಲೇನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಔಟ್ಸೋರ್ಸಿಂಗ್ ಅಂತ ತಗೊಳ್ತಾರೆ 27 ಜನರನ್ನ. And registrar directs don't regularize them. Board says, the secretary says we cannot regularize them. In spite of that, board regularizes them. ಒಂದು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ತಾರೆ. Against which the registrar directs action against the board. Entire board was disqualified. Thereafter they approached the JR. Before the JR also I am the party. Without making me party, they go to the deputy registrar. Kindly have a look at the order of the deputy registrar, my lord. He writes the without vacancy.
ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ?
ಒಂದೇ ವರ್ಷ. ಒಂದು ವರ್ಷಕ್ಕೆ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿಬಿಟ್ಟು
ಯಾವ ಒಂದು ವರ್ಷ?
ಈಗಾಗಿದೆ, ಈಗ 15 ವರ್ಷ. ಬಿಕಾಸ್ ಐ ಆಮ್ ಫೈಟಿಂಗ್ ದ ಲಿಟಿಗೇಷನ್.
ಆಯ್ತು, ಈಗ 20 ವರ್ಷದಿಂದ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ.
ಇಲ್ಲ, 20 ವರ್ಷದಿಂದ ಕೆಲಸ 2018 ಅಪಾಯಿಂಟ್.
2002
Date of regularization.
ಅಲ್ಲ, ಅದರಲ್ಲಿ 3 ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಇದೆ. Every appointment they make like that.
It's all right. Every appointment they make like that. Today, what is the problem now?
But I have challenged those, the order of the deputy commissioner before the appellate authority. Appeal is pending. Appeal is pending. Now it has to be decided in appeal.
We will hear it. Yes.
Yes.
ಈಗ ಏನ್ ಟರ್ಮಿನೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
ಇಲ್ಲ ಇಲ್ಲ, ಅಲ್ಲಿ appeal pending ಇದೆ. Appeal proceedings stay ಮಾಡಿದೆ.
What happened? There was a notice issued seeking to terminate our services. We raised a dispute.
ನನಗೆ ಲೀವ್ ಕೊಟ್ಟಿರೋದನ್ನ ಚಾಲೆಂಜ್
set aside.
Correct.
Lord, I am a party in the original.
ಕೆಲಸ ಮಾಡ್ತಾರೆ. 20 ವರ್ಷದಿಂದ ಇವ್ರಿಗೆ what is the problem with them? How can they be terminated?
ಅಲ್ಲ, ಇಲ್ಲಿ ಏನು total recruitment continuously same thing is continued.
Continuous. You
not even one recruit.
You put a stop for the future. Now ಅದು 20 ವರ್ಷದಿಂದ ಆಗಿರೋದನ್ನೆಲ್ಲ ಕೇಳ್ತಾ first tell me who are you? A member, can a member question it? Will
definitely I can question, but I have the
will answer it. These are as you said, Duryodhan Sahu ಗೊತ್ತಲ್ಲ?
ಅಲ್ಲ, ದುರ್ಯೋಧನ್ ಸಾಹು ಅದರಲ್ಲಿ PIL, ಇದರಲ್ಲಿ PIL ಕ್ವಶನ್ ಬರೋದಿಲ್ಲ.
ಒಂದೇ ಅಲ್ಲ, ದುರ್ಯೋಧನ್ ಸಾಹು ಆದ್ಮೇಲೆ one more ಅರಿಜಿತ್ ಪ್ರಸಾದ್
RK Jain's case.
ಅಲ್ಲ, ನಾನು ಅದನ್ನು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ನೆಕ್ಸ್ಟ್.
ಅದು ಅದು PI ಒಂದೊಂದ್ಸರಿ PIL
ಅಲ್ಲ, ಇದು how they have
interest, public interest.
ಅಲ್ಲ, I agree.
Paisa interest
provided they have continued based on the interim orders. ನಾನು ತೋರಿಸ್ತೀನಿ, ನಾನು ಅದನ್ನೆಲ್ಲ ರೆಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
Lords, I just wanted to say this. Lordships, can I just pursue your Lordships to kindly have a look at page number 37. Who is this person?
37.
He is a ranked defaulter. There is a award passed against.
I am a guarantor in that loan. I will produce the entire loan document. I am not a borrower.
Busybody.
ಆ busybody ಅವರು ಹೇಳ್ತಿರೋದು. I am a member.
Pending against him.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಹಿಂದಿನ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿ. At the learned senior counsel, they are Ravi Shankar appearing for the petitioner and learned counsel are Nagendra.
ಇದೆ. ಸ್ಟೇ ಎಂಟ್ರಿ ಮಾಡೋದು ಇದೆ.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಇದೆ, ಎಂಟ್ರಿ ಮಾಡೋದು. ಹಾಗಾಗಿ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟರೆ ನಾನು ಹಳೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ನಾನೇ ಸ್ಟೇ ಕೊಟ್ಟೆ.
ತಾವೇ ಕೊಟ್ಟೆ.
Yes. ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಮಾಡ್ತೀನಿ.
Heard the learned senior counsel, they are Ravi Shankar appearing for the petitioner and the respondent are Nagendra Naik. The issue revolves around the entertainment of the complaint of the respondent.
Entertainment of the appeal before the KAT against the orders passed by the registrar.
Entertainment of the appeal before the tribunal, all on the complaint, all which have had the genesis on the complaint registered by the respondent. Which respondent?
Respondent number 1.
By the respondent number 1, which the learned senior counsel Dr. Ravi Shankar submits that the complainant is either a busybody or a meddlesome interloper. The learned counsel Nagendra Naik would dispute the position in seeking to justify or defend the action of the tribunal granting leave or tribunal taking up the issue. List the matter on ಯಾವತ್ ಬೇಕು?
10 days.
ಆಯ್ತು. List the matter on 20th
at
2:30. 20th at 2:30 ಅಲ್ಲ 21st at 2:30 p.m.
Please.
21st Friday ಬೇಡ, 20th on 2:30 p.m. Yes, next.
25th.
ಪರವಾಗಿಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು ಅಷ್ಟೇ ತಾನೇ ತೊಂದ್ರೆ. ನೀವು ಯಾರು?
ಅಲ್ಲ, ನಾನು ಯಾರು ಅಂತ ಹೇಳ್ತೀನಿ.
ಅದಕ್ಕೆ ಅದು ಹೇಳಿದ್ರೆ ಆಯ್ತು.
ವಾಟ್ ಆರ್ ದಿ ಇರ್ರೆಗ್ಯುಲರ್ ಅಲ್ಲಿ
ಇರ್ರೆಗ್ಯುಲಾರಿಟಿ ಅದು ಬಿಡಿ. ನೀವು ಯಾರು? ಆರ್ ಯು
member gain right.
Are you an employee who wanted to be regularized? Are you an employee whose service conditions are affected due to the service conditions of these? ಅದು ಬಂದ್ರೆ ಮಾತ್ರ.
ದುರ್ಯೋಧನ್ ಸಾಹು I will to
ದುರ್ಯೋಧನ್ ಸಾಹು ಅಲ್ಲ, ಬೇರೆನೂ ಇದೆ.
Please.
Yes, yes. Interim order subsisting would continue till the disposal of the petition.
Great.
Yes.
32 Raghavendra B. Hanjar, Girish Kulmani.
May it please your lordship. I'm for the petitioner in this case, your lordship. Your lordship, on the last date, notice was issued to the respondent to give the response, your lordship. The issue is squarely covered by various decisions.
Chinmay trust judgment. CBDT data.
Chinmay trust.
Please, my lords.
No, your lordship. I am before this court on a different ground, your lordship.
Then we'll have it later. List the matter on 24th.
No,
Yes,
no,
next.
issue is squarely covered, your lordship.
ಅದನ್ನೇ ಹೇಳಿದ್ದು ಚಿನ್ಮಯ ಟ್ರಸ್ಟ್
We are
ಅಂತ, ಇಲ್ಲ
seeking for
ಅಂದ್ರೆ
interim
24th.
prayer.
Next.
No,
Yes.
apart from that, your lordship, in this matter, it can be remanded back, your lordship, then. Because.
ಚಿನ್ಮಯ ಟ್ರಸ್ಟ್ will do it today. ಇಲ್ಲ ಅಂದ್ರೆ next 24th.
Please, your lordship.
ಚಿನ್ಮಯ ಟ್ರಸ್ಟ್.
They are relegated to the authorities, my lords.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Please, in terms of that.
ಸುಮಾರು ಮಾಡಿದ್ರು.
Please, my lords.
Yes.
Much.
Please.
Yes. Sudadi. Learned HCGP is directed to accept notice for.
Already notice.
ಆಗಿದೆಯಾ? ಎಲ್ಲಿದೆ? ಆಗಿಲ್ಲ.
On 9/4.
ಹಾಕಿದ್ದಾರೆ. 33 ನೇ ಗೊತ್ತು. Yes. Rest on 17th.
Please.
Yes, next.
34.
None appears. 19th. Next.
Mahantesh Hiremat.
Lords, I 6 weeks time, my lords, I copy.
Server copy 2 weeks ಬೇಕಾ?
1 week, my lords.
1 week ಬೇಕಾ? Copy
ಅವ್ರು unavailable ಇದ್ದಾರೆ ಮಾಸ್ವಾಮಿ. ಅವ್ರು ಸಿಗ್ತಾ ಇಲ್ಲ ಮಾಸ್ವಾಮಿ. ಇವತ್ತು ಸರ್ವ್ ಮಾಡಿ.
ವೀರೇಶ್ ಬುದ್ಧಿ ಹೇಳಿ ಸಿಗ್ತಾ ಇಲ್ಲ.
ಎಲ್ಲ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ಇವ್ರಿಗೆ ನಾವು ಸಿಗ್ತಾ ಇಲ್ಲ. I'll give my phone number and WhatsApp number also.
Don't do selective search. Correct ಆಗಿ ಸರ್ಚ್ ಮಾಡಿ.
ಕೊಡ್ತೀನಿ ಮಾಸ್ವಾಮಿ, ಮತ್ತೆ ಕೊಡ್ತೀನಿ.
ಸೊ 2 ವಾರದಿಂದ 1 ವಾರ, 1 ವಾರದಿಂದ ಇವತ್ತು. Petitioner shall serve set of papers upon Viresh Bodhihal during the course of the day. In the event it stands served, list the matter on 19th.
Please.
Number 35 Shiraj Valluli.
Please, lords. Lords, in this case, my land has been acquired.
As the prayer against R2 is not maintainable because the project
Prayer part 2
respond number 2, my lord. Because the project of laying the line is done by the respond number 1, who is a factory, private factory. So as the prayer as well as the petition against R2 may not be served.
R2 KPTCL.
Oh, namdalla project, the private.
Lords, my prayer is that, my lords,
what is the?
my lords, the issue is that, my lords,
you
my land has been acquired wherein the
For
feeder
by
line of
whom?
by respondent number 1 and 2, my lords.
1 and 2.
1 and 2, please, my lord.
Sakre Karkhane.
Because the land is not acquired, my lord, only the wires are passing through the land.
Lords, if your lordships.
Laid by whom?
Laid by me.
First respondent.
First respondent.
That is
The sugar factory. Please. ಅದು ಲೈನ್ ಹೋಗಿದೆ, ಅದಕ್ಕೆ ಅವರು ಕಾಂಪೆನ್ಸೇಷನ್ ಕೇಳ್ತಾರೆ. Yes. Lord, the impugned order annexure K is also been passed in the year 2017 itself. In that it is very clear that if there is any loss to the crops or trees, we have to pay compensation.
All right.
Lord, there is no any loss caused to the.
ಪ್ರಕಾರನ ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, there is no any loss caused, my lord. Only the wire is passing above the land.
No, sir. Private property do that.
Yes.
Unless you
Lord.
compensate.
Yes, please. Lord, if he is.
Crops antalla, utilization itself you have to compensate.
Please, my lord. Please, my lord.
You
If
can't
he
do
is.
without that.
True, my lord. If he is, my
Now,
lord.
who has drawn the lines?
Lord, the lines has been drawn by me in the inspection of.
KPTCL involvement ಇಲ್ಲ.
At the. They are only the inspecting authority.
KPTCL involvement ಇಲ್ವಾ?
Lords, KPT, no, my lords.
Don't beg the question.
Please, my lords.
Then how is the rate maintained?
Yes.
My lords, if your lordships may kindly come to annexure G, my lords. KPTCL has itself given an NOC wherein they have clearly stated that the line which has passed through my land, below that line, below that line, I cannot utilize that line for any purpose. If your lordships.
You claim damages from him.
Please, my lords.
Why do you want KPTCL here?
Please, my lords, if your
To
lordships may
maintain the
peruse,
writ.
if your lordships may peruse as
He
per
is-
annexure K, my lords,
He is
what
having
the order has
alternative
been passed
remedy
by
under
the deputy
16 clause
commissioner.
4 of the Indian Telegraph Act to claim compensation against me. There he should prove that how much compensation he is actually
Before whom?
before the district judge.
Lords, if, that is
Under
already,
16
my
clause
lords,
4, my lord, he is having right.
Already?
already inspection has been done by an
I
engineer.
thought person, in terms of that inspection, the court will decide and determine
yes.
compensation.
Please.
If KPTCL had done something, tell me, nothing. You produce everything there. The petitioner is before this court seeking the following
My
prayer.
senior would appear, if your lordships may have it at some other day. Please, my lords.
List
A
on
day.
17th.
Please,
Please.
highly obliged, my lords.
Please.
ಅವ್ರಿಗೆ ಯಾಕೆ ತೊಂದ್ರೆ?
Please, highly obliged.
Right.
Serial number 36, Jagdish Patel.
The petitioner filed an application to issue NOC from the Assistant Commissioner and the KIDB.
Yes, Pawan.
They have issued a this
Issued,
illa your worship. 9/9 the 8 order dated 8/9 may kindly be seen yours. 2011 they have issued under section 28 of the KIDF. Till today no further proceedings. This honorable court directed them to file an affidavit. Till today.
What is wrong with the KIDB in this area? Total lawlessness.
Since there is already,
They think it is their personal fiefdom.
since there is already
By law, sir.
endorsement issued, my lord.
What endorsement issued?
2011, 28 under section 28 only, no further
And
proceedings.
there is a notification, lords, unless they challenge that notification.
No problem. We will quash the entire thing. 10 ವರ್ಷ ಸುಮ್ಮನೆ ಲ್ಯಾಂಡ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಮಾಡಬೇಡಿ ನೀವು.
Ascertain, lords.
What will ascertain?
I am yet to receive my
List the matter on 18th.
Please.
In the fresh matters list. In the
Meantime,
event
they have
no
to file an
instruction-
affidavit, your worship.
in the event in the event no justification for the impugned action comes about, this court will be constrained to pass necessary orders.
May I request
Mulcting the board.
after 20th, lords.
20th.
Please.
ನೀವಿರಲ್ವಾ?
ಮದುವೆ ಇದೆ ಅಂತ ಹೇಳಿ.
After 20th, any
ಯಾರ್ದು ಮದುವೆ?
ನನ್ನ ಮಗಳ ಮದುವೆ ಇದೆ ಅದಕ್ಕೆ 20th ಮೇಲ್ ಬೇಡ ಅಂತ ಹೇಳಿದೆ. 18th is the last.
Some personal.
All right.
20th, lords. It may be on 20th.
ಆಯ್ತು, ಯಾವತ್ ಬೇಕು? 20th?
ಅಲ್ಲ ನನಗೆ ಆಗೋದಿಲ್ಲ. 18th ಕರೆಕ್ಟ್.
Then 24th.
Purpose is.
Please, 24th.
24th,
Please.
ಅಲ್ಲ 20.
18th,
27th is a marriage, your lords. How can I come on 24th?
ಅಲ್ಲ, he's
I told him 18th is.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ ಸರ್?
ಅಲ್ಲಿ 18th ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
18th,
ತಾವು
but
ಸಾಹೇಬ್ರು
ನಿಮ್ಗೇನ್
18th
problem?
ಹೇಳಿದ್ಮೇಲೆ ನಿಮ್ದು.
I have to receive.
ಅವ್ರ ಮದುವೆ ಅಂತ ಹೇಳಿದ್ ನಿಮ್ದಲ್ವಲ್ಲ?
ಅಲ್ಲ, I do have some personal inconvenience on 18th, lords.
Don't worry, yes.
24th is fine.
24th ಬೇಡ, 18th, yes.
Serial number 37, Chetan Munoli.
Lordship seeking for a mandamus, my lords, to the respondent bank to consider OTS, my lords, proposal.
No mandamus will be given for that.
That's on the last.
No. Supreme Court, SBI versus Arvind.
I
No
understand,
mandamus
my
for
lords.
OTS. ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಅವರೇ ಹೇಳಿದ್ರೆ ಮಾಡ್ತಾರೆ.
Lords,
Or
the
on
representation was submitted, my lords,
Representation ಕೊಟ್ಟಿದ್ರೆ ಕನ್ಸಿಡರ್
pursuant
ಮಾಡಕ್ಕೆ
to an
ಹೇಳ್ತೀನಿ
order
ಅಷ್ಟೇ.
passed in.
No mandamus for OTS. ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, ಅದ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ
Reject
ಕನ್ಸಿಡರ್
ಮಾಡಿ.
Lords, I have no instructions about.
We'll take it. First time ಬರ್ತಾರೆ, ಇಲ್ಲ.
ಇಲ್ಲ, in fact earlier writ petition was filed. They have disposed it of saying that
So on the last
they continue ಮಾಡಿದ್ರೆ
order,
ಅದು
my
ಹಂಗೆ
lords, I was
ಬೆಳ್ಕೊಂತ
given a
ಹೋಗ್ಬಿಡ್ತದೆ.
liberty,
Interest
my
will
lords,
go on
to
increasing.
submit a proposal. Lords, there are 3 loans, my lords, one submission.
OTS mandamus, no.
One submission, my lords. There are 3 loans. One is housing loan, my lords, of 10 lakhs. Another is business loan of, my lords, 2 lakhs and education loan of 3 lakhs. At least in, my lords, the business and education loan, my lords, they may be permitted, directed, my lords, to consider, my lords.
Directed ಆಗಲ್ಲ.
I will tell them orally. ನಾನು ಹೇಳ್ತೇನೆ, but let it not come on record. I will.
Correct.
Already, my lords, paid around 10 lakhs.
I'll take this on 17th. ಏನೋ 17th.
ಇಲ್ಲ, ಅವರು ಯಾವ ತರ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? He is according to him only 28 lakhs. He is saying I'll pay, give me 10 months, I'll pay 5 lakhs. ಅದೆಲ್ಲ ಆ ತರ ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟರೆ it is practically not.
For that the bank.
Please,
It
please.
becomes
Lords, may I
difficult
have it
for the
on
bank to
17th?
resist.
Please,
List on 20th, ನೋಡೋಣ.
please.
ಏನು ಆರ್ಡರ್ ಮಾಡಲ್ಲ. Yes. Next.
Commission matters, Girish Dharwad.
Covered by judgment.
Covered by? What covered by? Kudi. Page.
3 and 5 of ITP Act
You are the manager.
Yes, my lord. Last time, my lord.
ಗೊತ್ತಾಯ್ತು, ಜಡ್ಮೆಂಟ್ ಕೊಡಿ.
ಅಲ್ಲ, ಅದರಲ್ಲಿದೆ, ಫೈಲ್ ಇದೆ. CM ಜೋಶಿ ಸಾಹೇಬ್ರ ಜಡ್ಮೆಂಟ್ ಇದೆ.
ಅದೇ ಕಲಬುರ್ಗಿ ಬೆಂಚ್.
Yes. 13(2) of the act, which also cites my lord's earlier judgment.
ಕಷ್ಟ.
One more ground I am urging, my lord. That's what I said on the last occasion.
Petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that the issue in the list, the legal grounds set out in the subject petition are all answered by the coordinate bench in so and so. In the light of the coordinate bench has held as follows. The learned AGA Antanakla? The learned AGA accepts the learned AGA is not in a position to dispute the position of law as is laid down by the coordinate bench. In that light, the petition deserves to succeed as the grounds set out in the subject petition are all identical to what is rendered by the coordinate bench in the aforesaid judgment. Ordered accordingly. Yes.
39, VC Gnanaya Swami. Telecast.
Petition under section 482 of CRPC.
482 ne sir, bere.
Please. For
Amale.
Aదే, three offenses, your lordship, 307 and 427, my lord.
Correct, sir.
The petitioner, your lordship, is none other than the
None other illa, page 18 ಗೆ ಬಂದಿದೆ.
Yes, my lordship, as for my lord wound certificate, your lordship, but both, what is my submission? Both are relative, my lord.
Relative and ಜಗಳ ಆಡಬಾರ್ದು.
ಇಲ್ಲ, ಅವರು ಏನೋ ಸೆಟಲ್ ಆಗ್ತಾರೆ.
ಸೆಟಲ್ ಆಗುತ್ತಾ?
But your lord.
There is no chance
And
of
moreover, my lord, the petitioner is working in your lordship in
Moreover illa, everything over.
Indian Army, my lord.
Indian Army?
ಹೌದು. ಅದಕ್ಕೆ ಊರಿಗೆ ಬಂದಾಗ ಸ್ವಲ್ಪ ಏನೋ
ಬಂದಾಗ ಸ್ವಲ್ಪ
ಜಗಳ ಆಗಿದೆ. ಅವ್ರ ಮಿಸ್ಸಸ್ ಇವರು ಇಬ್ರು ಅಕ್ಕ ತಂಗಿ.
ಅದಕ್ಕೆ ಜಗಳ ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ಅವ್ರಿಬ್ರು ರಿಲೇಟಿವ್ ಅಂತ ಹಿಂಗೆ.
In that reason.
And moreover, your lordship, prior to filing of this present complaint, the wife of the petitioner, your lordship, has filed a complaint against the complainant, my lord. So with that anonymity, my lord, he filed a complaint. One or other reason, my lord, when he came to the, my lord, village, he pick up a quarrel and always, my lord, given troubling to the petitioner also, my lord.
He remanded back to the trial court and conduct the trial, then come to conclusion.
ಅದು ಎಲ್ಲ ಮಾಡಬಹುದು. ಅದು 482 ನೀವು ಹೇಳಲೇಬೇಡಿ. ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕಿದ್ದೀರಾ?
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ನಂಗೆ ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಟ್ರು, ಅವನು ಬರ್ತಾನೆ, ಟ್ರಯಲ್ ಕ್ಲೋಸ್ ಮಾಡಿಬಿಡ್ತೀವಿ ನಾವು.
ಸ್ಟೇ ಇಲ್ವಾ ಇಲ್ಲಿ?
ಸ್ಟೇ ಐತಿ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಡಿಸೆಂಬರ್ ವರೆಗೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಐ ಕೇಮ್ ಟು ಮೈ ಲಾರ್ಡ್.
The matter on 15th December.
Please.
On the submission of the counsel for the petitioner that the petitioner would come and settle the dispute amongst themselves. In the event no settlement is reported on the 15th of December, the petition would not merit adan bedabadi settle agala.
Nane
so and so appropriate orders would be passed subject to the aforesaid, and on the said submission interim order subsisting will continue to the next date of hearing.
Number 14, Nilendra D. Gunde.
Lordships, apologies for interference, Lordships. In serial number 37, interim order may kindly be extended.
Interim order ಇದೆಯಾ?
I have deposited the amount.
Sir,
Pursuant to the
OTS ಕೇಳಿದ್ರಲ್ಲಿ interim order. All right, sir. Yes. Interim order subsisting.
Obliged.
Bill number 40.
Not so pleased to hear. The issue, my lords, while not boarding the bus, my lords. While boarding the bus, my lords, initially, my lords, this petitioner number 2, my lords, had filed a complaint, my lords, against one Arti Nayak, my lords, alleging that, my lords, while she was about to board the bus, my lords, this Arti Nayak said that the seat is booked for some other person, my lords. Accordingly, there was case and counter case. My lords, the main issue itself, the main issue itself, seat in Sambandha stay, that is closed before this honorable.
Seat Sambandha 354.
ಅದು ಇವ್ರ ಮೇಲೆ ಅವ್ರ ಮೇಲೆ that is closed, my lords, which is at page 140.
Closed.
My lords, the one complaint filed by me against Arti Nayak and the complaint which she had filed against me, my lords, that is closed.
Which is unrepresented here.
It is, my lords, the respondent, my lords, is a police.
Complainant ಯಾರು?
Now in the, my lords, what happens is,
ನಿಮ್ದ್ರಲ್ಲಿ complainant
ಇದರಲ್ಲಿ, my lords, it is a woman PS, my lords, lady constable.
Police ಅಂತ ಹೇಳಿ ಸಾಕು.
Sorry, police.
There are 3 cases were filed on the.
We'll say interim order ಇದೆಯಲ್ಲ. List the matter on 21st. Interim order subsisting will continue to the next date of hearing. ಇರ್ಲಿ. ಮಾಡುವ.
41, Srinande Pachapure. Jairamut.
After 7 years, the charge sheet came to be filed. The offence is not in 1984 minutes. There were 37 allotment.
21st, our decide ಮಾಡ.
Please, interim order.
That 21st IO ಆದ್ರೆ ಅಷ್ಟೇ.
Please.
List on 21st IO extended.
Read.
42, Vijay Chiniva.
My lord, in this case and counter case, my lord.
Interim order ಇದೆಯಲ್ಲ?
ನಂದೊಳಗಿಲ್ಲ ಸ್ವಾಮಿ, ಅವರು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಒಳಗಿದೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್.
ಸರಿ.
My lord, in this, my lord.
Yes, government, please.
My lord, offense, my lord, 326, my lord.
326 ಅದಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ.
307, yes, my lord. ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಒಳಗೆ 307, 326 ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Even my lord, in that case, my lord, charges also framed, my lord.
Then we'll dismiss both.
Please.
Case and counter case, my lords.
So ಎರಡು go before the trial court, charge frame ಆಗಿರೋದ್ರಿಂದ.
It is my colleague matter. Have it on 21st.
My lord, ಅಲ್ಲ ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಒಂದ್ ಸೆಕೆಂಡ್, ಅವ್ರದೊಳಗೆ ಸ್ಟೇ ಇದೆ, ನಂದ್ರೊಳಗೆ ಸ್ಟೇ ಇಲ್ಲ, since from 3 months, my lord.
List the matter on 18th as a last chance. ಅವತ್ತು ಮುಗಿಸ್ಬಿಡೋಣ ಎರಡು.
ನಂದ್ರಲ್ಲಿ interim order is.
Interim order subsisting will continue with the next date of hearing. ಬಿ ಗ್ರೂಪ್ ಹೋದ್ವಾ? ಎಷ್ಟಿದೆ ಇನ್ನ? ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮುಗಿಸ.
Cell number 43, Nagendra Nayak, Harsh Desai.
Dismissal pursuant to a departmental inquiry. Employee is no more.
Benefits ಬರುತ್ತಲ್ಲ?
Benefits ಬರುತ್ತೆ ಅದಕ್ಕೆ.
No, right to sue survives.
That is, we have brought the legal on record.
You have already bought. Harsh Desai ಇದ್ರಲ್ಲಿ ಈಗ.
So either.
ಅವ್ರಿಗೆ ಕರಿಬೇಕು ಹರ್ಷ್ ದೇಸಾಯಿ.
Sorry, my lord.
Yes, sir.
Lord, I filed objections.
ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ.
Allah, really. In the first round, my lord, the matter was heard by this honorable court and page number.
In the lighter way, sir. Friday ಅಂತ ಅಷ್ಟೇ. In the lighter way ಹೇಳಿದೆ Friday.
Not this, he had fixed up for today, so I also. ಇದು ಹೋದ್ಸಲಿ ಬಂದಿತ್ತು.
ನನ್ ಮುಂದೆ ಬಂದಿತ್ತ?
It could not be heard, my lord, for want of time.
What's the allegation?
Lord, there are two allegations.
Grounds ಹೇಳ್ಬಿಡಿ ಸಾಕು. ಎಂಪ್ಲಾಯ್ ಇಲ್ಲ ಇವತ್ತು ಕೇಳಕ್ಕೆ.
ಎರಡೇ ಗ್ರೌಂಡ್ ಇದೆ ಸರ್. ಫಸ್ಟ್ ಒಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಡ್ತಾರೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಗೆ ರಿಪ್ಲೈ ಆಪ್ಷನ್ ಇಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ. They fix the inquiry.
You did not reply to
I did not reply to the charge sheet.
ಆಮೇಲೆ
Inquiry date fix ಮಾಡ್ತಾರೆ. On the date of inquiry, they say you have to appoint defense representative. ನಾನು I appoint somebody as
representative.
defense representative. Defense representative. DR ನಾನು ಅಪಾಯಿಂಟ್ ಮಾಡಿದ ತಕ್ಷಣ ಎನ್ಕ್ವೈರಿ ವಾಸ್ ಆನ್ 18th. ಅವತ್ತಿಂದ ಅವ್ರಿಗೆ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ. DR ನ. Then he is not able to come to the inquiry.
So you were rendered defenseless.
Defenseless. Then, my lord, I appear in the inquiry. I myself will cross-examine the witness in complete leading questions. Nan one witness would leading question ಕೇಳ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. And out of the 6 witnesses, the 5 witnesses are bank employees. ಅವರೆಲ್ಲರೂ ಹೇಳೋದೇನಂದ್ರೆ ನಮ್ಮ ಕಸ್ಟಮರ್ ಬಂದು ಹೇಳಿದ್ರು ಇವ್ರು ದುಡ್ಡು ಕೇಳ್ತಿದ್ರು ಮ್ಯಾನೇಜರ್ ಅಂತ ಹೇಳಿದ್ರು. And 2 customers.
Penalty of dismissal.
Dismissal.
2012.
ಏನಿಲ್ಲ ಸರ್, ಟರ್ಮಿನಲ್ ಬೆನಿಫಿಟ್ಸ್ ಬರುತ್ತೆ ಅಷ್ಟೇ.
ಎಷ್ಟು ವರ್ಷ? Which cadre?
Lord, he was one manager. Scale 3. Sorry, scale 2.
MMGS 2.
MMGS.
All right. Even while dismissal,
yes,
MMGS 2.
Yes, ma'am.
ಎಷ್ಟು ವರ್ಷ service?
Service, he was almost 30 years he had completed.
There is some history, my lord. A couple of times he was reprimanded. Annexure R4, my lord, page 41.
Benefits.
ಏನಿಲ್ಲ ಫ್ಯಾಮಿಲಿ ಪೆನ್ಷನ್ ಕೊಟ್ರೆ ಇಟ್ ಇಸ್ ಏನಪ್ಪ ಮಾಡೋದು, ಏನ್ರಿ ಬ್ಯಾಕ್ ವೇಜಸ್ ಗಿವ್ಸ್ ಏನು ಬೇಕಾಗಿಲ್ಲ, ಏನು ಬರಲ್ಲ. ಫ್ಯಾಮಿಲಿ ಪೆನ್ಷನ್ ಕೊಟ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ಟರ್ಮಿನಲ್ ಬೆನಿಫಿಟ್ಸ್ ಬಂದ್ಬಿಟ್ರೆ.
Should we write Harsh Desai? ಇಲ್ಲ any chance?
ಲಾಸ್ಟ್ ಟೈಮ್ ಸಚಿನ್ ಮಗ್ದೂಮ್ ಸಾಹೇಬ್ರು ಅದನ್ನೇ ಹೇಳಿದ್ರು, ಅವ್ರ ಬ್ಯಾಂಕ್ನವರು ದೇ ಡಿಡ್ ನಾಟ್ ಅಗ್ರಿ. ದಟ್ ಇಸ್ ವೈ ಹಂಗೆ ಮುಂದಕ್ಕೆ ಹೋಗ್ತಾವೆ.
ಅವ್ರ ಮುಂದೆ ಬಂದಿದೆ?
ಇಲ್ಲ, ಅವ್ರ ಮುಂದೆ ಬಂದಿದೆ.
ಹೌದು, ಬಂದಿದೆ 2-3 ಸರಿ, ತುಂಬಾ ಸರಿ ಬಂದಿದೆ. ಹಾಗೆ
ಇಲ್ಲ, ಅವ್ರ ಮುಂದೆ ಬಂದಿಲ್ಲ.
ಇಲ್ಲ, ಸಂಜಯ್ ಗೌಡ.
ಸಂಜಯ್ ಗೌಡ ನಮಸ್ಕಾರ.
ನೋಡಿ ಆಗಲ್ವಾ?
ಅವ್ರು ಬ್ಯಾಂಕ್ನವ್ರು ಒಪ್ಪಲ್ಲ. ನಮ್ಗೆ ಹೆಡ್ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಅಂದ್ರು, ನಾವು ಹೋಗಿ ಟ್ರೈ ಮಾಡಿದ್ವಿ.
ಪ್ರಗತಿ ಗ್ರಾಮೀಣ ಬ್ಯಾಂಕ್.
ಪ್ರಗತಿ, ನಾವು ಕರ್ನಾಟಕ ಗ್ರಾಮೀಣ
Now, my lord, amalgamated and only
Yeah,
one
so
Gramin
now
Bank.
it's KVB only,
Single bank,
Karnataka Gramin Bank.
Karnataka Gramin Bank. ಅವೇನು ಹೋಗ್ಬಿಡ್ತೀವಿ
ವಿಕಾಸ ಇಲ್ವೇ ಇಲ್ಲ.
ವಿಕಾಸ ಇಲ್ಲ ಈಗ.
2004 order.
Some serious charges also, my lord, which, and he has participated in the inquiry. And the so-called, my lord, defense representative, he never made any application. He was posted for regular
So when
service,
he
regular
chooses,
training.
one has as his defense representative, unless he has two inquiries on his hand, he can't be denied that at all. That's the regulation.
My lord, he cannot be denied, but that defense representative never came before the disciplinary authority and asked.
So he need not, because if he has sought that, illa, you should ask him to take another one.
ಅದನ್ನ ಹೇಳಿದೀವಿ. Then he himself, my lord, has participated and he has cross-examined all the
ಇಲ್ಲ ಇಲ್ಲ,
witnesses.
it is rejected. Time is rejected. ನಿಮ್ಗೆ ಡಿಆರ್ ಟ್ರೈನಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಟೈಮ್ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅವರೇ ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ, because he was under
No
training.
opportunity to submit a reply to the charge sheet cuts at the root of the matter.
Lord, Annexure R4, your lordships may kindly see page
Reply
41 of
ಕೊಟ್ಟಿದ್ದಾರಾ?
my objections. Lord, we have reference to your letter dated 7/6/2003 ಅಂತ ಅದರಲ್ಲಿ ಇದೆ. So based on this, my lord, I have said.
The 22-year-old matter, we'll see.
Yes, my lord, that is why.
ಇನ್ನೊಂದು ನಾವು ನೋಡ್ಕೊಂಡು dictate ಮಾಡ್ತೀನಿ. We'll post it on 20th. Just go through it and then dictate. Synopsis ಏನಾದ್ರು ಹಾಕಿದ್ರೆ
ಇದೆ.
ಹಾಕಿದ್ದೀರಾ?
ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿಲ್ಲ.
ಹಾಕ್ಬಿಡಿ. ಹಾಕ್ಬಿಟ್ರೆ ಅಷ್ಟು ನೋಡಿ. Becomes easier to dispose.
Please.
Law ಏನ್ ಬೇಡ. Facts ಮಾತ್ರ.
ಯಾವ ಡೇಟಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಯಾವ ಟ್ರೈನಿಂಗ್ ಆಗಿದೆ,
ಪೇಜ್ ನಂಬರ್.
ಪೇಜ್ ನಂಬರ್ಸ್ ಅಷ್ಟು ಹಾಕ್ಬೇಕು.
44 ವಿಶ್ವನಾಥ್ ಹೆಗಡೆ, ಅರವಿಂದ್ ಡಿ ಕುಲಕರ್ಣಿ.
That's IPF response.
I'm paying for the petitioner's permission.
Yes, Sarthi.
So this is a matter, Lordship has heard. With regard to extending the educator cum lecturer, they have to redesignate it also. As in terms of the MCA regulations,
We'll take it on 19th. List on 19th in the same stage. ಇಲ್ಲ preliminary hearing ಅಲ್ಲ ಹಾಕಿ ಮುಗಿಸ್ಕೊಂಡು. List on 19th in preliminary hearing.
Number 45 ವಿಜಯ್ ಕುಮಾರ್.
Order of
ವಿಜಯ್ ಕುಮಾರ್.
Order of reversion, my lord, is under challenge. Lord, the petitioners are all holders of NTC certificate issued by the National Trade and the certificate is said to be, the government has issued two government orders declaring them as equivalent to
ಮೊನ್ನೆ ಇತ್ತಲ್ಲ ಅದ?
Yes.
Government order declaring?
ಹೇಳಿ. The government has already clarified, my lord, that NTC certificate is equivalent to polytechnic diploma certificates.
Then what is the action against you now?
Now, my lord, I am being reverted on the clarification issued by the Employment and Training Department. Though DPR has issued the clarification.
Where is the DPR clarification?
Page 82, my lord.
Page?
82, my lord. 83, my lord. On the direction issued by the this court, my lord, clarification was sought from DPR whether 61 and 64 orders have been withdrawn. But they clarified that it has not been withdrawn. And they are still in force.
So LTC, what is that? NTC.
NTC, certificate, National Trade Certificate issued.
Equivalent to?
Equivalent to diploma in issued by the polytechnic colleges.
Yes, sir. ಅಷ್ಟೇ ತಾನೆ?
The impugned.
Straight away allow ಮಾಡ್ಬೇಕಷ್ಟೇ. ನೀವು ಯಾರಿಗೆ?
HDMC members.
HDMC ತೊಂದ್ರೆ ಇಲ್ಲ.
Respond number 3 who has to consider your lordship.
Consider ಏನಿಲ್ಲ. Because government has passed an order declaring equivalence. Employment training had no jurisdiction to override that. As simple as that.
Page 101 is the clarification that is issued. Last paragraph, Lord, fifth line.
ಮಾನ್ಯ ಆಯುಕ್ತರು ಕೈಗಾರಿಕಾ ತರಬೇತಿ ಮತ್ತು ಉದ್ಯೋಗ ಬೆಂಗಳೂರು ದಿನಾಂಕ 6/11/19 ಪತ್ರದಲ್ಲಿ ITI ವೃತ್ತಿ ವ್ಯಾಸಂಗ ಡಿಪ್ಲೊಮಾ ಸರ್ಟಿಫಿಕೇಟ್ಗೆ ತತ್ಸಮಾನ ಎಂದು ತಿಳಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ ಎಂದು
Reverted to what cadre now?
ವರ್ಕ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ಸ್ from cadre of junior engineer.
You joined as what?
I joined as work inspector.
But the learned
In the first petition, my lord, all the three petitioners have retired before the order of reversion was issued.
ತೀರ್ಮಾನ ಮಾಡುವ ಟೈಮ್ ಬೇಕು ಅಂತ.
Monday.
Let's the matter on Wednesday.
Wednesday, please.
ನೀವು ಇದಕ್ಕೆ ಬಂದ್ರ?
ಇಲ್ಲ.
ಬೇರೆ ಇದೆ, ಸರಿ.
My lord, one more, this one, my lord, I heard that the first petitioner in the.
No more.
That I'll file a necessary application.
Learned counsel for the petitioner Vijay Kumar Bajantri submits that the first petitioner is no more and steps would be taken to implement the legal representatives. The learned counsel Gurudev Gachinmat, appearing for the first respondent, seeks a week's time to go through the papers and make his submission. The learned counsel Vijay Kumar Bajantri, appearing for the petition, learned counsel for the petitioner submits that the petitioners who joined as work inspectors had gained promotion to the cadre of junior engineer. They have all been reverted to the post of work inspector on the solitary score that the petitioners do not have the qualification. The learned counsel submits that certificate in -NTC is declared to be equivalent to that of a diploma of a polytechnic by the state government. The Department of Employment and Training overrides the decision of the DPAR, which has declared the equivalence, and therefore the termination has come about, the reversion has come about. In the light of the DPAR declaring that it is equivalent and such declaration subsisting as on today, the reversion becomes unsustainable unless the respondent would justify the action. List the matter on 20th.
The interim order be extended.
Interim order subsisting will continue to the next date of hearing. Yes. 40?
For the regularization, you wrote that.
Yes, madam.
My lords, I appear for respondent number 3 and 4, my lords. We have also filed a statement of objection dated 8/11.
Have you recommended their?
We have recommended.
Government has to take a
Government has to
decision.
take decision.
Nodilla. 17th, fresh matters. Yes.
Please.
The fresh matters, you wrote.
Fresh matter.
Yes.
We'll close it on that day. Regularization close. Yes. ಆಯ್ತು, but it's covered by what I have written already. Yes.
47.
ನಿಮ್ಮ ಹತ್ರ ಇವ್ರದೇನಿಲ್ವಲ್ಲ, ಇವ್ರು ರೆಕಮೆಂಡ್ ಮಾಡಿದಾರೆ already. Yes, next.
Jagdish Patil.
47.
This you wrote that the petitioners whose houses were on the bank of the river, every monsoon year also there was a flood. Due to that, there was a damages to all the houses. And this honorable court directed them to reconsider this, to rehabilitate in different areas, you wrote that. In respect of that, also, I filed an application, there was a direction by this honorable court. A joint survey has been conducted without informing us and without hearing us. They say that as a temporary arrangement, they have paid some amount for the damages of our house at the time of monsoon. So we are not entitled to that. Our applications were dismissed. Let them reconsider wherever there is any properties available. Let them consider and pass appropriate order.
Consider after issuing a notice to them and will pass out.
ಅಲ್ಲ, ಈಗ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
ಈಗ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಏನಂತ ನೀವು ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ವಿ for the repairs and all. That was only as a temporary marriage.
Post it in fresh matters.
Yes, your Honor.
List on 17th in fresh matters. We'll dispose it on that day. Yes, next.
48, Kiran M. Goli.
ಇದರಲ್ಲಿ a person has been missing, my lords, 48 ಅಲ್ಲಿ since 2020, and we have made efforts to, my lords, trace him, but we could not trace that, my lords, person missing.
Missing?
ಹೌದು.
ಯಾರು missing?
Person, my lords.
My lord, in 510 in missing the person main 6/10/2020 ಅಲ್ಲೇ ಮಿಸ್ ಆಗಿರೋದು my lord. ಆಮೇಲೆ
6/10/2020 ಅಲ್ಲಿ ಮಿಸ್ ಆದ್ರ?
2020 ಅಲ್ಲಿ my lord. 31st October and 2020 ಅಲ್ಲೇ FIR ಆಗಿರೋದು my lord. ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೂ ಯಾವುದೇ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಹಾಕಿಲ್ಲ.
We have made all efforts.
ಆಮೇಲೆ ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ರು, ಅದರಲ್ಲಿ ಬರೀ ಡೆತ್ ಇದ್ದಷ್ಟೇ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು my lord. ಮತ್ತೆ ರೀ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿ ಇದ್ ಮಾಡಿದ್ರು.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಕ್ಕೆ ನಾವು ಎಲ್ಲಿದಾನಂತ ತಿಳಿತಾ ಇಲ್ಲ. ಆಮೇಲೆ ಅವನು ಮೊಬೈಲ್ ಫೋನ್ ಯೂಸ್ ಮಾಡಲ್ಲ ಸ್ವಾಮಿ.
ಹೌದಾ?
My lord, one
last report we have filed on, my lords, 36/2025.
My lord, small submission will be there, my lord.
ಯಾರು? Wife is the complainant.
Wife. ಇಲ್ಲಿ ಹೈಕೋರ್ಟಿಗೆ ಬಂದಿರೋದು ಅವ್ರ ಬ್ರದರ್, my lord. ಬಸಪ್ಪ.
ಬ್ರದರ್ ಪರವಾಗಿಲ್ಲ. Wife is the complainant.
Yes, my lord.
Missing complaint ಕೊಟ್ಟಿರೋದು wife.
ವೈಫ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆದ್ರೆ ವೈಫ್ ಈಗ ಪ್ರೆಸೆಂಟ್ ಅಬ್ನಾರ್ಮಲ್ ಆಗಿದ್ದಾರೆ, my lord. Mentally upset will be there.
Because missing ಆಗಿದ್ದಾರೆ.
Yes, my lord. So much of in searching there, anyone report no in police station ಹೋದ್ರು ಕೂಡ ಯಾವುದೇ ರೀತಿಯಿಂದ ಕೇರಿಂಗ್ ಇಲ್ಲ, my lord. ಆಮೇಲೆ ಅಲ್ಲಿ ನಾವ್ ಯಾವುದೇ ಹೇಳಿದ್ರು ಕೂಡ ಅವ್ರು ಯಾವುದೋ ಗಮನಕ್ಕೆ ತಗೊಂಡಿಲ್ಲ, my lord.
ಈಗ ಎಲ್ಲಿ ಏನಾದ್ರು ಒಂದು ರಿಪೋರ್ಟ್ ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ಮಲರ್ಸ್ kindly see.
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ ನೀವೇನು ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ಮಿಸ್ಸಿಂಗ್ ಅನ್ನಬಾರ್ದು.
ಅಲ್ಲ, we have made all efforts.
ಫೋನ್ ಇಲ್ಲ ಅಂತಂದ್ರೂ ಕೂಡ ಮಿಸ್ಸಿಂಗ್ ಆದ್ರೆ ಅವ್ರದ್ದು ಎಲ್ಲಿಯಾದ್ರೂ ಪಾಂಪ್ಲೆಟ್ ಹಚ್ಚಿದ್ರೆ ಜನರು ತಾನಾಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟೆ ಕೊಡ್ತಾರೆ.
ಟಚ್ ಅಲ್ಲಿ ಇಲ್ವಂತಲ್ಲ ಯಾರ ಜೊತೆ?
ಅಲ್ಲ, my lord. ಇವಾಗ ಯಾವುದೇ ವ್ಯಕ್ತಿ ಮಿಸ್ಸಿಂಗ್ ಆದ್ರೆ ಎಲ್ಲಾ ಕಡೆನೂ ಪೊಲೀಸರು ಸರ್ಚ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಎಲ್ಲಾ ಸ್ಟೇಷನ್ಗೂ ಒಂದಲ್ಲ ಒಂದು ಇದು ಫೋಟೋ ಅಂತೂ ಕಳಿಸಿರ್ತಾರೆ. ಆಮೇಲೆ ರಿಲೇಷನ್
ಕಳಿಸಿಲ್ವಾ ಫೋಟೋ?
ಎಲ್ಲ ಇದೆ, my lord. ಎಲ್ಲ ಕೊಟ್ಟಿದೀವಿ. ಮತ್ತೆ ರಿಟರ್ನ್ ಪ್ರೆಸೆಂಟ್ ಇರುವಂತ ಫೋಟೋನು ಕೂಡ 2-3 ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪ್ರೆಸೆಂಟ್ ಫೋಟೋ ಹೆಂಗ್ ಕೊಟ್ರಿ?
ಅಂದ್ರೆ ಮೊದ್ಲು ಅವ್ರು ಹೆಂಗಲ್ಲಿ ಇದ್ದಂತ ಫೋಟೋ ಕೊಟ್ಟಿದ್ರು, my lord, ಅವ್ರ ವೈಫ್ ಅವರು. ಆಮೇಲೆ ಏನೈತಿ ನೆಕ್ಸ್ಟ್ ಮತ್ತೆ ಇನ್ನೊಮ್ಮೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇದ್ ಮಾಡುವಾಗನು ಮತ್ತೆ ಹೋಗಿ ಅಪ್ರೋಚ್ ಆಗಿದ್ದಾರೆ, my lord. ಅವಾಗ್ಲೂ ಕೂಡ ಯಾವುದೇ ರೀತಿಯಿಂದ ಏನು ರೆಸ್ಪಾನ್ಸ್ ಇಲ್ಲ.
Serious matter. So I take my lord's filing a further status report, my lords. I pray
The learned counsel for the petitioner submits that despite the registration of the complaint by the wife that her husband has gone missing for over 5 years now, he has not been traced. It is the allegation that the petitioner has not, but the jurisdictional police have not made any effort to trace the husband and bring him back to the wife, and therefore submits that the investigation should be handed over to any other independent investigating agency. The learned AGA submits that the police despite their
earlier report was filed.
Police despite their efforts has not been able to trace the husband. He has gone missing, and would submit that further what has happened as on today in the form of a report would be placed before the court. A further report of that kind be placed before the court on 17th. List on 17th.
Yes,
49, HM Dharwad, Arvind Kulkarni.
My lordship, kindly password, my lordship.
Password.
Please, my lordship.
Please.
ಬರ್ತಾ ಇದ್ದಾರೆ.
ಎಲ್ಲಿಂದ?
ಊರಿಂದ ಬರ್ತಾ ಇದ್ದಾರೆ.
ಊರಿಂದ?
May I pass on the order?
ಕೊಡಿ.
What is the issue before this court is the compassionate appointment. Last date's order may kindly be seen by, passed by my lords on 13/10/2025. My lords had observed that it is
Please,
ಅವರು
2005
ಎಲ್ಲಿಂದ ಬರ್ತಾ ಇದ್ರೆ ಅಲ್ಲೇ ಇರಕ್ಕೆ ಹೇಳಿ ಮೇಡಮ್. ಕೇಸ್ ಇಲ್ಲ.
2005 ಅಲ್ಲೇ they have accepted the amount.
1986 death.
2005 itself they have accepted the amount. And 13/10/2025 order may kindly be seen.
Anything else, madam?
kindly password, my lordship.
23 writ petition.
ಅವರೇನೋ ಬರ್ತಾ ಇದಾರೆ ಬರ್ಲಿ.
My lords have observed.
ಹೇಳ್ಬೇಡಿ, ಬರ್ತಾ ಇದ್ದಾರೆ, ಪೆಟಿಷನ್ ಹೋಗ್ತಾ ಇರುತ್ತೆ. ಎಸ್. Pass over, madam. Pass over.
50, Shivani Shetty.
My lords, I beg to appear for the petitioner's counsel, my lords. It's a matter questioning a disciplinary inquiry lying on a very narrow compass, my lord. My lords, my colleague is just passing across a 2-page note, my lord, which will just explain the entire thing. What had happened, my lords, is that my only grouse is that under the transaction of business rules, permission is required to be taken from the chief minister before initiating any kind of disciplinary inquiry as against me. My lords may just see the note.
Why, sir? Which cadre are you in?
Group A, my lords. I am Group A officer. So therefore, my lords, that's why my lords may just take the note. It is extracted the transaction of business rules also. Now, my lords passed an order on 14th of February, wherein my lords are directed the HCGP to bring on record the necessary documents to show that the matter being placed before the chief minister or before issuance of show cause notice. My lords may kindly look at the order dated 14th of February for a minute.
My order?
Yes, my lord. My lord's order. My lords have heard the matter. Then, my lords, I request my lords to look at the order dated 30th of July.
Interim order ಇದೆಯಲ್ಲ?
Interim order, my lords, the difficulty is this, my lord, that, my lords, I was due for promotion April 2025, my lords, because of this.
Sealed
I'm
cover
sorry, my
letter.
lord.
Sealed cover letter.
Illa Swami, I am not being considered.
ಯಾಕೆ DPC ಆಗಿಲ್ವಾ?
DPC ನನ್ನ ಹೆಸರು consider ಮಾಡಿದೆ Swami, that is my instruction.
You are not in the zone of consideration?
My lords, my name is not there in the list of, my lords, kindly see an annexure S for a minute, my lords, I have produced that also.
ಅಲ್ಲ, promotion ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರಲ್ಲ, unless you are in the zone of consideration and DPC is held, your case should have been placed in sealed cover.
My lords, I am the senior most person in my department. I am in the accounts cadre. I am the senior most person in my department.
Yes.
Your Lordship, I will verify about this order, Your Lordship. and file my objections
3725,
also.
14 to 25.
Please, Your
My
Lordship.
order is detailed.
Please, Your Lordship. I'll file my objections also, Your Lordship. along.
ಇನ್ನೂ ಹಾಕಿಲ್ವಾ?
My lords, kindly see the order of 30th of July, my lords. Kindly see the order of 30th of July.
Coordinate bench, this court on 14 to 2025 had passed the following order. The coordinate bench on 3725 the following order. Objections are not filed as on, even as on date, despite the order. As a last chance, list on 18th, list on 19th.
Please.
Objections, if any, by the state by then. In the event no objections are filed, it shall be construed that there are no objections to be filed to the subject petition. List the matter on 19th.
Can I make one request, ma'am? Can it be on fresh
In the
matters?
preliminary hearing. Preliminary hearing, yes.
Obliged, members.
Next.
51, Raghavendra B. Hanjar, GS Fulmani.
In this,
Shivraj
we are
Baldi.
challenging the flow.
I'm appearing for respondent number 2, my lords.
ಹುಲ್ಮನಿಯಲ್ಲಿ ನೀವು appear ಆಗ್ತಿದ್ದೀರಾ?
No, for respondent number 2, Shivraj Baldi.
ಇದ್ದೀರಾ?
Please, we have received the paravise comments, my lords. We'll file our objections.
No, this is
maybe
your
next.
Last time's order.
This is listed for consideration of.
Last chance ಅಂತ ಹೇಳಿದ್ದೇನೆ.
Please, my lords, we have recently received the paravise.
Recently, Girish Hulmani ilva?
Sorry, my
Girish Hulmani is not there in this?
he's maybe engaged in another court.
Allah, he is not appearing, is it?
He is appearing for respondent number 1, my lords.
Nobody has filed objections. List the matter
Your
on.
Lordship, this is listed for
17th.
no consideration of interim prayer, Your Lordship.
One
Your
minute.
Lordship,
This
this is listed for consideration of interim prayer, Your Lordship.
This court on 27/10/2025 had passed the following order. In the event no objections would be filed, it was indicated that the court would be constrained to grant an interim order as sought. Even today, there is no objection, even today, no objections are filed by any of the respondents. So, in the light of the aforesaid indication, and on the sole ground that no objections are filed, there shall be an interim order as prayed for. List the matter on 25th.
Please, highly obliged.
Your Lordship, may make only one submission, Your Lordship. The matter is seized off before the apex court, Your Lordship. So it has to be listed only after disposal of the matter by the apex court, Your Lordship. There are
No interim order, list after apex court order. Yes.
no, Your Lordship. In the connected matter, stay has already been granted. I have passed on the compilation, Your Lordship.
Raghavendra, you can't ask everything. Wait. Let them file their objections.
Please. No, interim order granted, Your Lordship. It may be listed on any date.
Next.
Please. Please. Much obliged.
Rakesh Sathikatti.
Please, my lord. Buds Act in hold.
The hearing act, Buds Act.
Buds Act. Prime accused 1, 2 and.
Similar case, my lords, they reached up to Supreme Court. Supreme Court has held that the offence under the Buds Act is not maintainable. For other offence, it is maintainable.
Same order will pass.
There are 2 judgments of.
As well as 1, 2 and 4
List on 17th.
Please.
Yes. Interim order idilla?
Please.
Subsisting will continue to the next date of hearing. Yes.
53, Suresh Shettamana, CS Patil.
Put on 11th.
Final hearing. List on 21st.
For the second response.
Interim order idea?
Interim order. End out 11th, my lords, the senior.
In serial number 52, may I seek it on 20th or 20th?
20th.
20th. Grateful, my lord.
Yes, next. Either 2:30 ಇದೆ madam. go to the Bangalore list.
Matter pertains to principal bench. Serial number 9. Kariappa, N.A.
What is it?
Yes, your lordship.
Yes,
My
government.
lords. My lords.
Where is the additional SPP? Pasha sir, pass over matter, then I'll take it at 2:30.
Please, your lordship.
Yes.
Serial number 10. Manjunath is.
May I please, my lords?
Really, sir.
For R1,
My lords.
in this matter,
Lords, these
this is a submission that
two petitions, my lords.
regarding the petition, against
Lords,
Yes, sir.
just one.
these two petitions, my lords, arise out of the order, my lords. Passed, my lords, rejecting my application under Order 7 Rule 11, my lords. Where, my lords, counterclaim filed by a co-defendant, my lords, was sought to be.
Please complete.
Really?
There's some disturbance.
I don't know. You don't get disturbed. Yes.
Sorry, my lords, there's some disturbance.
You don't get
I'm
disturbed.
sorry, my
Really,
lords.
sir.
My lords, the stay was secured, my lords, on the.
May I please, my lords?
Sorry, my
It's
lords.
my.
The stay was secured on the submission that, as per the legal position,
May
my lords,
please.
a counterclaim cannot be filed against a co-defendant, my lords. But, my lords, if what was not brought.
ಏನ್ ಮಾಡಿದ್ರಿ ಎಲ್ಲಾರು ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಟ್ರ
My lords, if along with a counterclaim against
wait,
the
let him
plaintiff.
finish. Wait, sir. I'll hear you. Let him finish. Yes, come on.
Grateful,
May
my
please, my
lords. My lords, what has not.
Let him finish.
Manjunath,
Wait, sir.
Manjunath, sir, I'll just complete, please. My lords, what has not been brought to my lord's attention is the observation of the Honorable Supreme Court, my lords, in both Rajul Shah as well as an earlier decision called Rohit Singh, my lords, where it has been held that along with a counterclaim against the plaintiff, if it is also maintained against a co-defendant, then there is no bar to maintain such a counterclaim, my lords. This was, of course, suppressed, and my lords, with regard to maintainability of the CRP itself, my lords are well aware that against there's a direct bar that against orders of the on a learned commercial court, CRP not maintainable. Lords, what has happened, my difficulty is, and why I'm troubling my lords by moving the matter is, I'm the plaintiff before the lower court, my lords, before the learned commercial court. I have filed a suit both against my borrower as well as the builder, my lords. Builder is the petitioner herein.
Now, one
lords,
moment. One moment.
Please.
Which is that order that CRP is not maintainable against the arbitration thing? I have myself passed an order. Yes.
Please, my lords, I'll furnish that, my lords, as going only by the section, my
I'll
lords.
take it at 2:30. Yes. Next.
Please, very well. Grateful, my lords. Grateful.
Silver 11.
Government advocate ಬೆಳಗ್ಗೆನೇ ಬಂದಿರಲ್ಲ ಅವರು ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ರಿವ್ಯೂ yes madam
and it was served to the council who appeared in
ಮಾಡಿದ್ದೀರಾ have you served
petition. Yes, sir. It is served, Lordship. To Advocate Praveen, it is served on 8/8/8.
the learned government advocate submits that copies as directed is served upon council S Praveen registry to print the name of S Praveen as appearing
On
for
8/9,
the
your Lordship.
S Praveen is appearing for the respondent. Place the matter on 17th. Yes. Next.
Much obliged, your Lordship.
Manasa.
I appear for respondent number 1 in this case, your Lordship.
ಕೊಡಿ ಏನದು ಒಂದು ನಿಮಿಷ
My lord, I appear for the petitioner in this matter, my lord.
Yes, who appears for the petitioner?
My lord, I am for the petitioner in this matter, my lord.
Yes, sir.
My lord, I had the benefit of an interim order from, for 11 years, my lord, between 2014 and 2025. And
Yes, sir.
may I request your lordship's indulgence, my lord, to have the stay extended so that, my lord, the petitioners could approach the Honorable Supreme.
How can I stay my own order, sir? Not correct.
No, my lord, there was a stay that was granted. I had the benefit of a stay.
Yes, sir.
4
Order
weeks
on,
at least, my lord, for,
no, no,
for
sir. Order on
statute.
Day 1 of 2025. The, this heard the learned senior counsel J.L. Vishwanath appearing for the petitioner and the respondent. This court,
Your Lordship, I have
by its
objection.
order dated 25th October 2025, had rejected the subject petition with a direction to the concerned court to dispose the suit itself, as it was 23 years old, and for 11 years the matter was pending before this court. The learned senior counsel, the petitioner has now preferred an application seeking stay of the said order, stay of the said order for a period of 4 weeks, or as the court would deem fit. In the light of the rejection of the CRP by the aforesaid order, there is no warrant of entertainment of the application seeking stay of the order itself. For the petition, the application stands rejected. Yes, next.
Seal number 13, Sharad J.
May I request your lordship's indulgence to instruct the trial court not to expedite it for 4 weeks at least, even if there is no stay, my
No,
lord.
no, that's indirect stay.
No, if your
No,
lordship says,
no, sir. Yes, sir.
otherwise it will become infructuous, my lord. That's why I'm
No,
saying.
no, no, sir. That I can't. Yes, my order I can't stay like that. Yes,
Oblige, Your Lordship.
yes. Same order, really. The Perola. Learned AGA is directed to accept. Learned HCGP is directed to accept notice for the respondent state. Application to be placed before the committee in Kelta.
Please.
Petitioner to serve set of papers upon the learned HCGP forthwith. HCGP name. Yes, next.
Seal number 14, Manjunath ND. Shrikant Patil.
List on 21st.
Seal number 15, Sunil Kumar.
February. List on 14th, list on 21st. Interim order subsisting will continue in the line previous. 15th. Yes.
In 17.1 and 3, my lord, I am appearing. All arising out of same judgment, your lordship.
Yes, sir. One kodi saka. Yes, sir. Yes. On the application. Then a clubbing andralla.
Yes. Sir, application ಅಲ್ಲ ಕ್ಲಬ್ಬಿಂಗ್ ಅಲ್ಲ
ಇಲ್ಲ ಕ್ಲಬ್ಬಿಂಗ್ ಬಗ್ಗೆ ಹೇಳಿದ್ರಿ ನೀವು ನಂಗೆ ಒಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕು. Once the trial is over, did you file an application for clubbing there before the trial court? 216 application was not filed. Now you have not filed an application and the trial is over. Now after the trial getting over, can it be urged here for the first time? Clubbing can be urged here?
If the charge has to be framed in a particular manner.
Correct. Adella aitu. That we'll see. Ali clubbing vishivage. Can it be done here for the first time? While that
appellate powers, this suppose if
appellate jurisdiction, yes, but I'll kelelvara ನೀವು.
If I am able to present before your lordship that it has caused prejudice, framing of charge has caused prejudice, then my lord, Your Lordship can take a decision to order.
ಆಯ್ತು ಸರ್ ಹೇಳಿ. ಎಸ್ ಸರ್. ಅಲ್ಲ ಅದೇನ್ ಡೌಟ್ ಬಂತದ್ ಕೇಳ್ಬಿಟ್ಟೆ ಅದಕ್ಕೆ.
Three, I don't know whether I am trespassing into his.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ
ಯಾರಾದ್ರೂ
ಸರ್.
ultimately.
ಅಲ್ಲ ಯು ಆರ್ ಎಂಟೈಟಲ್ಡ್.
386 ಅಲ್ಲಿ, if I am right.
ಅಪೀಲ್ ಅಲ್ಲಿ ಎಸ್
ರಿಮಾಂಡ್ ಮಾಡಬಹುದು.
ಅದೇ ದಟ್ ಅದು ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ನಾವು ಹೇಳಿದ್ರಿ
386
ಮಾಡ್ಬೋದು.
ರಿಮಾಂಡ್ ಮಾಡಬಹುದು.
ಎಸ್.
In the event your Lordship were to come to the conclusion ultimately, my Lord,
yes,
there are certain serious and important legal issues, or there has been violation of the mandate of law, remand ಮಾಡಬಹುದು. 386 ಅಷ್ಟೇ. ಈಗ ಅದರ ಬಗ್ಗೆ ನಾನು ಒಂದಿಷ್ಟು ಹೇಳ್ಬಿಡ್ತೀನಿ. ನಾನು ಚಾರ್ಜ್ ಬೇರೆ, ಕನ್ವಿಕ್ಷನ್ ಬೇರೆ, ಸಿಂಪಲ್ ಆಗಿ ಬ್ರೀಫ್ ಆಗಿ 10 minutes ಅಲ್ಲಿ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. Because we are not on the merits of the matter.
ಹೌದು, ಕರೆಕ್ಟ್.
Let me invite your Lordship's attention.
ಇಲ್ವಾ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಿಬಿಐ?
CBI
appear for respondents.
You are there. Yes.
Yes. Well, I presume that the submissions, in the event of the same being accepted by this honorable court, would adhere to the benefit of all. I think Mr. Nagen Naik will agree with me.
Yes.
And others also, my Arab friend, Mr. Asmat Pasha, who is there, everyone would agree with me. In the event,
yes,
my Lord is persuaded to accept my submissions.
Yes.
Otherwise, no.
Yes.
Well, just little backdrop of the matter. Well, on 15th of March 2010, consequent to certain publications made in the newspapers, and also certain news items which came to be telecasted in certain television channels regarding the alleged illegal mining activity in the state of Karnataka. But the Department of Forest and would take up an issue by registering a forest offence case in number 17 of 2009. But they would also quote certain violations under the provisions of the Forest Act as well as under the rules framed thereunder. But probably they could not have registered the crime and taken up the investigation for the reason that all offences under the Forest Act are non-cognizable offences. That is why section 62 under the
379 ಬಂತು.
379. ಇಲ್ಲ ಅದು ಇಲ್ಲ 379 ಅದು ಮಾಡಿಲ್ಲ 379 ಮಾಡಿಲ್ಲ. Only for section 2 and then my Lord under rule 62, 80, 143 and 162 they do it. They don't do anything. They keep quiet because press report was there. Press publications, television channel publications and all that. Probably it looks to me, look here, we have already taken up an issue. Idu ondu public eyewash thara irli anta anbittu ashtene. Despite being fully aware that they can't do anything. But what would happen? They would go there and seize these properties. These forest department officials on 20th of March 2010. 15th was FOC and 20th March they would do it. But on the same day, after seizure, they go to the jurisdictional magistrate and obtain an order. But all these things may be irrelevant for the purpose of the points which I am going to canvass. But I am just giving you, Lordship, the bird's eye view of how things have happened. Because I am not on these issues at all. I'm totally not on this issue.
Yes.
Just for better understanding of the matter, my Lord, I'm sorry, my Lord, if I'm wasting your Lordship's time. Just for better understanding. Well, on 20th of March 2010, they would go and produce this property form requesting the learned magistrate to permit them to keep the property in their custody while seeking his permission for taking up the investigation under 155 of the CRPC. The magistrate grants both the requests. He would permit them to keep the property in their custody. But in FOC, this would be useful and important. It may look funny, which they would register on 15/3/2010. The crime is registered against the first accused in this case. Kindly note this, my Lord.
Who is A1?
My Lord, A1 is court officer.
Public servant.
They register the crime against him. Well, when they submit the property form and seek for investigation on 20th of March 2010, in the property form, they would say, we should be permitted to hand over the property to the custody of the first accused. They seize it.
And That is reason.
The allegation is against him. He is the first accused. And they would say, permit us to allow us to give the property to the custody of the first accused. It's a tragedy.
No, of course, it went there and things happened.
Not backdrop, how the issue runs. Then, my lord, what happens is they go before the jurisdictional police later. On 8/6/2010, they go before the jurisdictional police and they would file a complaint. A case in crime number 189 of 2010 came to be registered. Only for an offence under section 406 on the strength of the complaint filed by a certain official who is of the rank of an assistant conservator of forests. Only for an offence under section 406. Investigation was handed over to CID, Bangalore. Investigation was in progress. At that point of time, my lord, a litigation in the form of a public interest litigation goes before the Supreme Court. Well, the Supreme Court would constitute a committee to go into this matter and to submit a report. Well, the Central Empowered Committee, that is CEC, which came to be constituted by the Supreme Court, would submit its report on 5th of September 2012. Well, this was not in relation to this case, in this particular case. That is in relation to the alleged illegal extraction of minerals in the state of Karnataka. Well, they would submit a report saying throughout the state of Karnataka, a total quantity of around 88 lakh metric tons of iron ore has been stealthily extracted and removed, was the report of the CEC. Well, the Supreme Court would accept the report and would say, while placing reliance on the recommendation which came to be made by the CEC, that the investigation be handed over to the CBI. And they would also say, the Supreme Court would also say, that all further investigation and to be conducted by the CID Bangalore in crime number 189 of 2010 stands straight. That is how the order came to be passed. Well, what the Supreme Court would say is, they would say further investigation into the case in crime number 189 of 2010. Well, kindly mark this. They do not say register a separate case, register any number of cases you want. In the order which came to be passed by the Honorable Supreme Court, what the Supreme Court would say.
No, there is one clarification
please,
here.
please.
Now, crime number 189 of 2010 was registered by the state.
Registered by the local police.
Local police.
Or transferred to CID.
Transferred to CID.
That was under investigation.
That's all right. No. Now, Supreme Court directs CBI to take over. Now.
For that 189.
Correct. CBI to take over 189. Correct, sir. No problem. No, as a general, why I'm asking is, can the CBI investigate pursuant to any order of the apex court or this court or whatever, a crime that is registered by the state, or they will have to register a fresh crime under the CBI will have to register the fresh crime and then investigate into that matter, whether it is further or whatever it is.
They would register a fresh crime.
Allah, what is to be done? How can they investigate into a crime registered by the state? That's what.
Let's, if your lordship grants leave, may I be permitted to say something?
That's exactly the point. They have to register a new crime and then investigate fresh crime and then only investigate it.
Idರಲ್ಲಿ RC 17. RC 17
With my lord's leave, there's one aspect, my lords, to the question posed by my lords. Lords, it is not technically a fresh crime, my lords. It's called re-registration.
I only wanted whether a crime registered by the state can be taken over by CBI and continued in that, or a fresh FIR.
It is re-registered as a regular case, my lords.
That's what is.
Re-registration of the crime takes place. That's all.
Yes, sir.
Please.
CBI manual prakara they have to register it again.
Register. Illi 17A of 2010 ಮಾಡ್ತಾರೆ.
Yes.
ಮಾಡಿ. ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
Yes.
For various offences. That is, this is only a backdrop. Nothing more, nothing less. My lord, what the CEC report is, may I just request your lordship to kindly have a cursory look at the CEC report. Only for this limited.
Do we have a convenience compilation or something here? ಕೊಟ್ಟಿದ್ದೀರಾ?
No, we have only evidence.
Paper book.
Evidence and compilation ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇದು paper book.
ಇದು ಇಷ್ಟೇ, ಇದೊಂದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂಡ್ ಆರ್ಡರ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇವೆರಡೆ ಇನ್ನೇನ್ ತೋರಿಸೋದೇ ಇಲ್ಲ.
Paper book ಇದೆ ನೋಡಿ. ಬಂದಿಲ್ವಾ? ಬಂದಿರ್ಬೇಕು ನೋಡಿ. ಏನು ಈ ತರ ಇರುತ್ತೆ ಸ್ಪೈರಲ್ ಕುಡಿಯೋದು. ಪೇಪರ್ ಬುಕ್ ತರಿಸ್ಬೇಕು ಮೇಡಮ್, ಬಂದಿರುತ್ತೆ ನೋಡಿ. ಪೇಪರ್ ಬುಕ್ ಬಂದಿರುತ್ತೆ ನೋಡಿ. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಬೇರೆ? ನಿಮಗಿದೆಯಲ್ಲ? ಎಸ್ ಸರ್.
Iron ore exported from Belikere post during the period from 1/1/2009 to 31/5/2010 from Belikere post, a total quantity of 88.06 lakh metric ton of iron ore has been exported by 70 exporters. This is what I submitted to you. 88 total for the whole of state of Karnataka, 88. Well, now kindly go to, we are not concerned with the other information that is given by the committee in the report. Kindly go to the last Roman 4. The CBI may be directed to further investigate all aspects of the illegality in respect to the iron ore seized on 20th of March 2010 from Belikere post by the forest department and substantial part of which is alleged to have been illegally exported. All proceedings related to the above matter investigated by the CID Karnataka, including the proceedings in case number 189 of 2010 filed by them, may be directed to be kept in abeyance. It is the investigation or the charge sheet or the proceedings before the court.
In 189.
Yes, in 189 is directed to be kept in abeyance, while the CBI may be directed to further investigate. It is only a further investigation in relation to the case in crime number 189 of 2010. Nothing more and nothing less.
So the state's proceedings are stayed and CBI is directed to take over 189.
Supreme Court order.
So,
Well, may I just request you not
is your suggestion that it was only further investigation, but the CBI has done a reinvestigation?
It is a suggestion.
Allah, that's what CBI has done a reinvestigation.
CBI doesn't say reinvestigate. Even the Supreme Court also doesn't say reinvestigate.
Correct. But if your suggestion is that now you're telling argument is that they have done accepted. Now your submission is CBI has done a reinvestigation.
Illi, you will hear the further investigation session ಕೊಡ್ತಾರೆ. And they would also suggest, my lord, let not any proceedings be recorded either by the CID or by any court or authority pursuant to the report of the CID. It stands straight at the head there. Now, my lord, may I request you, lord, to kindly have a look at exhibit P 126.
Exhibit?
126. Have a look at the operative portion of that.
Page ಏನಾದ್ರು ಸಿಗುತ್ತಾ? ಯಾವ ಪೇಜ್ ನೇಷನ್ ಇದೆ ಅದಕ್ಕೆ? 2680.
Paragraph 16.3. ಇಲ್ಲಿ ಇದನ್ನ ಓದ್ಬಿಡುತ್ತೆ. Miller gets
Yes,
para
sir.
16.3.
Yes.
Charge it to pay.
2680 is the order of the apex court.
Order of the apex court.
ಅದರಲ್ಲಿ ಯಾವ paragraph?
ಅದರಲ್ಲಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಹೋದ್ರೆ ಸಾಕು ಅಂತ ಕಾಣುತ್ತೆ. ನಮಗೆ we are not concerned with the rest of the things.
That is 2685.
2685.
We have perused the supplementary report dated 5/9/2012. The topic is based on the recommendations made by the CEC, the Honorable Supreme
This one, Raghavan sir, 2:30 ಗೆ ತಗೊಂತೀನಿ. This will go on for some 2:30 ಆಗುತ್ತೆ. Will
ಈಗ 230ಗೆ 1000 ತಗೊಳ್ಳೋದು ನಮ್ಮದ್ ತಗೊಂಡ್ಬಿಟ್ರೆ ನಿಮ್ಮದ್ ನಡೆಯಲ್ಲ ಅಂದ್ರು. ನಾನು ಹೇಳಿದ್ರೆ ನಮ್ಮದ್ ತಗೊಂಡ್ರೆ ನಿಮ್ಮದ್ ನಡೆಯಲ್ಲ. ನೀವು 11:30ಗೆ ಬರುತ್ತೆ. ಅವ್ರೇ ಅನ್ಕೊಂಡ್ಬಿಟ್ರೆ ಎರರ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್, ನಂದು ಈಗಲೇ ಮುಗ್ದೋಗುತ್ತೆ, ಅವ್ರದ್ದು ಮುಗಿಸ್ಕೊಂಡು ಹೋಗೋಣ ಅಂತ.
ಇಲ್ಲ ಸಾಯಂಕಾಲ ಇಬ್ರು ಒಟ್ಟಿಗೆ ವಾಪಸ್ ಹೋಗಿ.
ಹೌದೌದು.
You need not wait ಅಂತ ಅಷ್ಟೇ, ಬೇರೆ. You need not wait, you can. ಅಲ್ಲೇ ಇದೆ. ಆಯ್ತು ಸರ್.
We have perused the supplementary report dated 5/9/2012. Submitted by the CEC in continuance of its earlier report on the same issue dated 27/4/2012. We accept the report, and in the light of the recommendations made, we direct the CBI to immediately institute FIRs and to investigate the cases relating to the illegal extraction of about 50.79 lakh metric tons of ore from the forest areas of Karnataka during the period of January 1 to May 2010. The illegal transport of the aforesaid quantity of iron ore, the area extraction of Belike report, and from there it's illegal export to other countries. It may be noted at this stage that out of the aforesaid quantity of 50.79 lakhs, well, kindly pause for a minute. Although the report is in relation to 88 lakhs, total is 88 lakhs. The Supreme Court would say in relation to only 50 lakhs. For the reason, in the very report itself, they would say, as against the 88 lakhs that has been extracted, 38 lakhs had a valid permit, license and transportation. So out of 88, we have got to reduce 38 lakhs. What remains is only 50 lakhs. If 50 lakhs mata order ಮಾಡ್ತಾರೆ. MTS iron ore found lying at the Belike report was actually under orders of seizure by the Forest Department authorities, and the court before it was exported in violation not only of different laws but in the teeth of the seizure of ore. The investigation of the case of illegal export over 8 lakh metric ton iron ore, while it was under the orders of seizure, is recommended at subparagraph so and so. As recommended in the report of the CEC, the CBI should institute FIRs as suggested in subparagraphs 1 and 4 at paras 12 and 14 respectively of the report, and carry out thorough and intensive investigation, including, if so required, custodial interrogation of any one of the accused. But this order is the one which came to be passed by the Supreme Court. But thereafter, what would happen is they would, on completion of investigation, they would file umpteen number of charge sheets. Further investigation in or in relation to the case in crime number 189 of 2010, they have got to register the crime, investigate, further investigate into that particular FIR. Register ಮಾಡ್ತಾರೆ. But as against this 50 lakh metric tons that has been referred to by the Supreme Court, they will register 5 separate FIRs in RC 13, 14, 15, 16 and 17. But we are only concerned with 8 lakhs in these appeals.
Out of the 50 lakhs.
Out of that, 8 lakhs. For the remaining 42 lakhs, my lord, the cases are still pending before the trial court.
Including this.
In that, this is one of the point which I'm going to ultimately submit.
For 50.
I'm surprised, 50 lakh is the whole thing. How do you segregate that and 5 lakhs first ಮಾಡ್ತೀನಿ 6 lakhs first?
ಇದರಲ್ಲಿ ರೈಸಿಂಗು, ಸ್ಟೋರೇಜು, ಸೇಲು, ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಇಷ್ಟಕ್ಕೂ ಈ 50 ಲಕ್ಷಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ರೈಸಿಂಗ್.
But 42 lakhs ಇನ್ನೂ ಪೆಂಡಿಂಗ್ ಇದ್ದಿದೆ ಹೆಂಗೆ?
Yes, my lord, that is one of the points which I am going to submit for probably what the Supreme Court has said is, if some order is passed in one case, while the other connected matter is pending there, will it not have an effect on that case? Probably that case may have an effect. If that case had been disposed of and this is pending, it will have an effect on this case. If this case is disposed of and that is pending, it will have an effect on the other case. Therefore, it shall not be done. That is what the Supreme Court has said.
ಇಲ್ಲ obviously sir.
ಅಲ್ವೇ?
ಕೆಲವು ಕ್ವಶನ್ ಪೇಪರ್ ಆನ್ಸರ್ ಬರದ್ಮೇಲೆ ಟೆಸ್ಟ್ ಆದ್ಮೇಲೆ ಅದೇ ಕ್ವಶನ್ ಪೇಪರ್ ಬೇರೆ
ಈ 5 consignment, this is added in the main case also.
8 lakhs, 3 charges are still
pending. 105 is pending.
My lord, imagine the situation, my lord. Kindly imagine the situation. In the pending cases, if it is said that the rising, storage, sale and transportation is held to be not illegal.
It's already held illegal here.
If it is held to be illegal, what should happen to this? Number one. Supposing if my lord were to say, no, it is illegal, sale is illegal, transportation is illegal, rising is illegal, storage is illegal, therefore I am going to I confirm the judgment conviction. Which
So that goes.
It will have the effect on that case.
Completely.
So that is why my lord from Mr. Nagendra Naik is seeking for
Adding to that,
setting that is one of the points. Points
Sir, permission here 6 cases they have convicted. Another 3 cases on the relating to the Belakari theft itself is pending. It is under trial. Now what is there to be tried?
Why exactly? What is there to be tried when you have already convicted?
Already convicted. And my lord, all documents are same, all witnesses are same. It is a single FIR and single Mahaja, and they split into 9 cases.
That is why my learner from Mr. Nagendra Naik has said it has got to go together. At least ಒಟ್ಟಿಗೆ ಮಾಡಿಬಿಟ್ಟಿದ್ರೆ, my lord, 219 and 220 permits that.
Correct, that permits, yes.
Well, look at the hardship.
1 year ಅಲ್ಲಿ 3 charges ಮಾಡಬಹುದು.
This 2 months period, 1.5 months period it is.
Same transaction, same place, same oro.
Same place of offense, place of year. Let us see. Yes.
Anyway, I will come to that a little later.
So the periphery itself is an error here.
ಅಲ್ಲ charge ತೋರಿಸ್ತೀನಿ ನಾನು. Charge is A. Conviction is for B. I should presently shoot your lordship. What the learned judge has done. Well, now straight away let me take your lordship. First the charge that is framed against him. Well, ಇನ್ನೊಂದು ಇದಕ್ಕಿಂತ ಮುಖ್ಯ, but 6 charge sheets are filed. Separate charge sheets. According to the prosecution, separate trial, separate evidence. I am convicted in all the 6 separate, each one of the cases. But I am asked to undergo 7 years imprisonment for one offense or the other. He did not make the sentences to run concurrently. ಇದೆಲ್ಲ ಅಮೆರಿಕಾದಲ್ಲಿ ರಷ್ಯಾದಲ್ಲಿ ಆ ಕಾನೂನಲ್ಲಿ ಆಗುತ್ತದೆ, 20 ವರ್ಷ 30 ವರ್ಷ 40 ವರ್ಷ ಆಗುತ್ತೆ. ನಮ್ಮ ಕಾನೂನಲ್ಲಿ ಆಗಲ್ಲ. ಅಲ್ಲಿಗೆ ಎಷ್ಟಾಗುತ್ತೆ ಅಂತಂದ್ರೆ 7 into 6 42 ವರ್ಷ I have got to undergo the sentence. Is it permissible?
Yes.
Probably, I don't know. He's a very, very fine judge.
Yes.
Conviction. Kindly imagine the situation. ಒಟ್ಟಿಗೆ ಹೋಗಿದ್ರೆ ಅವಾಗ ಏನಾಗ್ತಾ ಇತ್ತು ಅಂತಂದ್ರೆ,
there appears to be non-application of mind.
Total non-application of mind. Total non-application of mind. That is why my learned friend has been appealing to your lordship.
Total non-application. At every stage, I guess.
ಈಗ ಒಂದೊಂದು 2-3 ತೋರಿಸ್ತೀನಿ ನಾನೀಗ.
Done in a hurry.
ಒಂದು 2-3 ನಾನು ತೋರಿಸ್ಬಿಡ್ತೀನಿ.
ವರ್ಕ್ಲೋಡ್ ಹೆವಿ ಇದೆ. ಯೂಶುವಲ್
ವರ್ಕ್ಲೋಡ್ ಹೆವಿ ಇದೆ ಅಂತ convictions.
Well, may I now request your lordship to kindly turn to the charge. One of the charge ಏನಿದೆ ಅಂತ ನೋಡೋಣ. Have a look at the charge that is framed. Well, charges came to be framed against the accused on 11th of June 2018 first. Then, my lord, the successor court might have felt it necessary that the charges that are framed earlier is incorrect or not appropriate. Well, the successor judge would proceed to alter the charges.
Alteration.
Alter. But it is not additional charge. Additional charge is totally different from altered.
216 permits.
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. Altered charge permission ಉಂಟು. ನಾನು ತಪ್ಪು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲೇನ್ ಮಾಡೋದು?
Additional charge ಬೇಕಾದ್ರೂ ಮಾಡಬಹುದು. ಅದಕ್ಕೂ permission ಉಂಟು. But when once the charges are altered, the earlier charge goes. Means earlier is incorrect, Therefore, I am altering it. ಮೊದಲು ಸರಿಯಾಗಿ ಇತ್ತು.
So
ಮೊದಲು
then
ಸರಿಯಾಗಿ
the earlier charge and new charge both are tried after alteration. Yes.
So therefore, earlier charge goes. It is not a case of additional charge. Additional charge ಆದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಮೊದಲು ಮಾಡಿದ್ದು ಉಳಿಯುತ್ತೆ, ಅದ್ರ ಜೊತೆಗೆ ಇನ್ನೂ ಅಥವಾ ಒಂದು ಅಥವಾ ಎರಡು.
Language itself.
That's it. Altered means earlier charge has gone and the altered charge has remained on record. Same charges, but ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಾನು ತೋರಿಸ್ತೀನಿ ನಾನು.
Conviction is an earlier charge.
ಅದಕ್ಕೂ ಇಲ್ಲ. ಅದಕ್ಕೂ ಇಲ್ಲ. May I request your lordship, can you turn to the charge? First charge ನೋಡೋಣ first. ಮೇಲೆ 23 to 22.
Page.
ಮೇಲೆ page.
ಇದರಲ್ಲಿದೆಯಾ?
Yes, yes, yes.
ಅದು ಪೇಪರ್ ಬುಕ್ ಬಂದಿಲ್ಲ ಅಂತ ಅಲ್ಲಿಂದ.
ಮೇಡಮ್. Page 67.
Altered charge.
Altered charge. This is on 22, 23 to 22.
Yes.
Then earlier charge goes.
Yes.
That was framed. But first charge is against all the accused persons 1 to 6. In this charge, 120B. For the time being, I will say that I have no grievance. For the time being, because since it is not on merits of the matter. But now kindly go to the second charge that is framed. Secondly, you accused number 1, being a public servant working as conservator of port during March to May 2010 at Bedigere Port, Ankola Taluk. You were entrusted with the heap number 6 containing 27,000 metric tons of iron ore and heap number 19 containing 2,413.14 metric tons of iron ore fines, seized by the Forest Department in case number 17 of 2009 and 10, and learned JMFC Court Ankola wide order 22/3/2010 permitted to retain the seized iron ore under your safe custody. Well, kindly mark this. Secondly, you accused number 1. Here also, you accused number 1 was permitted to retain the property. Then, my lord, you accused number 1 in furtherance of criminal conspiracy hatched with accused number 2 to 6 dishonestly, fraudulently
misappropriated.
I'm sorry, madam.
ಅಲ್ಲ ಇಲ್ಲಿ ಓದ್ತದೆ ಸೇಮ್
ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಾಗ್ಲೇ you accused number 1 illegally permitted the transportation. Andre the first charge is relatable to
accused number 1,
nobody else. But no, kindly read this assumes all the importance. Dishonestly and fraudulently you accused number 1 misappropriated, causing loss to ಅಲ್ಲ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ ಅದು ಬೇರೆ ಫೈಲ್ ಇದೆ, ಇದ್ರದ್ದೆಲ್ಲ ಅದು ಕ್ವಾಂಟಿಟಿ ಮಾತ್ರ ಚೇಂಜ್ ಆಗುತ್ತೆ.
weighing 1131.65 metric ton.
ಅದು ಮಾತ್ರ ಚೇಂಜ್ ಆಗುತ್ತೆ, ಬಾಕಿ ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ. ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ dishonestly you accused number 1 in furtherance of the criminal conspiracy hatched with so and so dishonestly and fraudulently misappropriated and converted for your own use property entrusted to you. Of course, it was given to him, no doubt about that. The records would reveal, even if I were to dispute. But according to the charge that is framed, charge number 2, it is the first accused who has dishonestly and fraudulently misappropriated the property that was entrusted into his custody. Thereby, my lord, the court will proceed to frame a charge under section 409, read with section 120B against the first accused. Namme charge in the 409 no charge.
Nim 420 120B.
379
120B.
120B. 420 120B. Ili, he is the custodian. He misappropriates. Being a public servant under 409 definition under 406 and all that. ಅವನು misappropriate ಮಾಡಿಬಿಟ್ರೆ what should have been? It's only my broader thinking. ಇವ್ರು ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅಂತಂದ್ರೆ ಇಲ್ಲೇ ನಾನು ಬರ್ಬೇಕಾಗಿತ್ತು. When once he says you entered into a criminal conspiracy with
120B ಇಲ್ಲೇ ಬರ್ಬೇಕು. ನೀವು ನಿಮ್ಮ ಮೇಲೂ ಇಲ್ಲೇ ಇರ್ಬೇಕು.
not only against the first accused, but also against the rest of the accused. To you accused number 1 to 6 having entered into a criminal conspiracy.
ಅದೇ you accused number 1 ಜೊತೆಗೆ ಇರ್ಬೇಕಾಗಿತ್ತು.
ಜೊತೆಗಿರ್ಬೇಕಾಗಿತ್ತು. ಅದ್ರ ಬದಲು ಏನ್ ಮಾಡ್ಬಿಟ್ರು ಇವರು?
ಇರಲ್ಲ. 409 ಗೆ ಮಾಡಿದ್ರೆ 379 420 ಪ್ರಶ್ನೆನೇ ಬರಲ್ಲ. ಮುಂದಿನ ಯಾವುದು ಬರೋದೇ ಇಲ್ಲ.
ಅದು ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್.
409 ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್.
ಇದು ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್. So illi, that is only my loud thinking.
Yes,
I said only my loud thinking. That is where the trial court has gone wrong in proceeding to frame charges only against him for an offence under section 409. He ought to have proceeded to frame a charge with the aid and assistance of 120B, not only against first accused, but also against the rest of the accused. ಮಾಡಬೇಕಾಗಿತ್ತು. ಅದನ್ನು ಅವರು ಮಾಡಿದ್ರು. Basically, he has gone wrong there. But now kindly go to the ನಮ್ಮ ಮೇಲ್ ಚಾರ್ಜ್ ಏನಿದೆ ನೋಡೋಣ ಈಗ ನೆಕ್ಸ್ಟ್.
379 120B.
Page 71 minutes. Page 71. 420.
420 120B. 379 120B.
ಇದು ಯಾರ ಮೇಲೆ ಅಂತಂದ್ರೆ ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ 2 to 6. ಅವ್ರ ಮೇಲೆ ಇಲ್ಲ. If he has already, he is the one, a custodian. He is the one to whom the property has been entrusted. But criminal breach of trust, as my lord is aware, as defined under section 403 defines, any person to whose custody the property has been entrusted on certain terms, but
dishonest intention,
disregard to the terms of entrustment, if he were to misappropriate or convert that property into his own use, or ಅಲ್ಲಿ ಬರ್ಬೇಕಷ್ಟೇ.
According to charge 1, entrustment ಇಲ್ವೇ ಇಲ್ಲ ಬಿಡಿ. It is all entrusted to accused number 1. There is no allegation against accused number 2 to 5 that you have been entrusted with the property, dishonestly misappropriated it.
ಇನ್ನೂ ಒಂದು, but theft is defined under section 379. I'm sorry, 378, which is made penal under section 379. What I should have done was dispossess him. Dispossessing a person who is in lawful
the provision
possession.
is clear. Property belonging to someone without the knowledge.
Knowledge or consent.
Without the knowledge or consent.
I should dispossess him.
You dispossess him, you take it
Did
away.
I do it?
Then it becomes 379.
Case of theft. Did I do it? That is not the charge. ಅವಾಗ ಏನಾಗಬೇಕಾಗಿತ್ತು? either 379, 420 ಅಥವಾ 409 ಹಾಕೋ ಬದಲು ಎಲ್ರಿಗೂ 379 420 ಮಾಡಬೇಕಾಗಿತ್ತು. ಅಥವಾ ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು? 409 ಹಾಕ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ 120B ಹೇಗಿದ್ರು ಮಾಡೇ ಇದ್ದಾರೆ, 409 with 120B to all the accused ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ನಾವು ಅವಾಗ ಏನಾಗ್ತಾ ಇದ್ವಿ ಅಂತಂದ್ರೆ 120B ದಲ್ಲಿ ಬರ್ತಾ ಇದ್ವಿ ನಾವು, 409 ಡೈರೆಕ್ಟ್ ನಾವು ಬರ್ತಾನೆ ಇರಲಿಲ್ಲ ನಾವು. Have a look at 420 minute definition 415.
415, yes.
I don't come within the parameters of the definition of section 415.
From the inception, what is it?
Now minute conviction ನೋಡೋಣ ಯಾವುದಕ್ಕೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
So 415 is government is supposedly the complainant here. So government property is taken away with a dishonest intention right from the inception. Then it gets at 420 gets attracted.
ಇದು ಇನ್ಸೆಪ್ಷನ್ ಇದೆ ತಪ್ಪು ಹೋಗ್ತಾ ಇದೆ. Have a look at the sentence. ನನಗೆ ಅವರು ಇದನ್ನು
So in 386 ಅಲ್ಲಿ can send it back and redoing it.
ಬಟ್ ಇನ್ನೊಂದು ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ತೋರಿಸ್ಬೇಕಲ್ಲ
ಬೇರೆಯವರಿಗೆಲ್ಲ
ಪೂರಾ ಆಲ್ ದಿ ಎಂಟೈರ್ ಎವಿಡೆನ್ಸ್ ಕಾಮಾ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಆಗಬೇಕು.
ಅದು ಬರುತ್ತಲ್ಲ ಹಾಗೆ
ನಾನು ಚಾಟ್ ಮಾಡಿದ್ದೀನಿ including the evidence of the IO. But the Supreme Court has deprecated and come upon
humor apart, but these when you hand over convictions like this, it threatens
ಇಲ್ಲಿ ನನಗೆ
justice delivery.
409 ನನಗೆ have a look at ಫಸ್ಟ್ ಅಕ್ಯೂರ್ಗೆ ಚಾರ್ಜ್ ಇಲ್ಲ 420 and 379ಗೆ ಅವ್ರ ಕನ್ವಿಕ್ಷನ್. ಫಸ್ಟ್ ಅಕ್ಯೂರ್ಗೆ 379 ಕನ್ವಿಕ್ಷನ್, 420ಗೂ ಕನ್ವಿಕ್ಷನ್.
Charges 409.
ಇದು ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಒಂದು ಚಾರ್ಟ್ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಕಂಪೈಲೇಷನ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಯಾವ್ದ್ರಲ್ಲಿದೆ?
That is all 6 cases evidence in
Volume 2 ಅಂತ ಇದೆ.
From volume 1 to volume 5, my lord.
Volume 1 ಕೊಡಿ.
The latest judgment of the Supreme Court, my lord.
Judgment ಯಾವುದು?
Mamman. This is just last month. This is what the Supreme Court has said. May I request your lordship to kindly turn to para 16 and onwards.
Lords, may I request for the citation, my lords?
This is the case of Mamman Khan.
ಬರ್ತಾರೆ ಅನ್ಕೊಂಡಿ ಮೇಲೆ ಸರ್.
Mamman Khan versus State of Haryana.
Versus State of Haryana.
2025 INSC 1113.
Grateful.
Go to page 17 of this order. Page 17.
From the above the following prepositions.
The above the following propositions stand reiterated. Separate trial is the rule under section 218 CRPC. A joint trial may be permissible and etc. From a part of the same transaction, the conditions in section 219 to 223 CRPC are satisfied. But even then, it is a matter of judicial discretion. The decision to hold a joint or separate trial must ordinarily be taken at the outset of the proceeding and for cogent reasons. The two paramount considerations in such decision making are whether a joint trial would cause prejudice to the accused and whether it would occasion delay or wastage of judicial time. Well, this fourth one is important. Evidence recorded in one trial cannot be imported into another, which may give rise to serious procedural complications if the trial is bifurcated. And an order of conviction or acquittal cannot be set aside merely because a joint separate trial was possible. Inference is justified only where prejudice or miscarriage of justice is shown. Then para 16.2. Indeed, it reinforces that joint trials are not only permissible but preferable where offences arise from the same transaction and evidence is common, provided no demonstrable prejudice is shown. And at the next page, para 20, my lord. Third sentence. Even where multiple charge sheets are filed, if offences arise out of the same transaction, they must be tried together.
Yes.
Yes, madam.
Hello. Yes, sir. ನೀವು ಹೇಳಿದ್ದಕ್ಕೆ.
Next to page 22, para 25. The matter is remitted to the trial court with the direction to conduct a joint trial of the appellant.
Answer is here.
May I just request your lordship to kindly turn to the next judgment of the Supreme Court. This is in 2022, volume 14, SCC 392. Few paragraphs in this judgment. That is in the case of A.T. Maideen versus Assistant Commissioner of Customs. May I request your lordship to kindly turn to paragraph 36. Permit me to take your lordship to paragraphs 36 and few other paragraphs subsequent to 36. It will be important on two issues.
36.
36.
Yes.
Mr. Vikramjit Banerjee, learned additional Solicitor General as an officer of the court, has referred to two judgments. According to him, in both the said cases, the evidence considered of another case was different and not part of the other case. He therefore submitted that in such a situation, prejudice could be alleged by a suffering party, that he had no opportunity for that. Such evidence was impermissible. The first judgment is in
Dot Ali versus Muhammad Sayadul. In this case, also there were two separate trials, and the accused were convicted by the trial court in both the cases. The additional session judge heard both the appeals together as one case and made up his mind that there were two contradictory stories, and on that basis he allowed one appeal and dismissed the other. Rankin CJ, in his judgment, observed that the duty of the learned judge was to keep each appeal absolutely separate and to deal with it on its own merits, confining himself to the evidence given in that case and in that alone, and accordingly remanded the matter to the appellate court for a fresh decision in both the cases. The other judgment relied upon by the Banerjee in Pedda Venkatapati versus State. This case also had similar facts where the appellate court, that is the session judge, had used the evidence recorded in one case against the other accused in another case and vice versa. Relying upon Dutali, the learned single judge of the Andhra Pradesh High Court set aside the judgment of the Sessions Court and directed for rehearing of the two appeals. The submission of Mr. Banerjee is that in these two judgments, as the evidences were different and it had been read and relied upon, the accused could allege prejudice, but in the present case, as the evidence is the same in both the cases, no prejudice can be alleged. Same evidence, no prejudice could be alleged. Whether prejudice or not, kindly mark this, my lord. Whether prejudice or not, the fact remains that the High Court committed an error of law in dealing with the evidence of one trial for deciding both the appeals arising out of the two separate trials. That is what the learned judge has done it. Now kindly go to paragraph 40, my lord. My lord, kindly skip about 9 sentences from the top.
Yes.
The role of each accused, the role of each accused cannot be said to be the same. The same witnesses could have deposed differently in different trials against different accused, differently depending upon the complicity or culpability of such accused. All these aspects were to be examined and scrutinized by the appellate court while dealing with both the appeals separately and the evidence recorded in the respective trials giving rise to appeals. We cannot proceed on the presumption and assume that everything was identical word to word. We are therefore not inclined to accept the submissions of Mr. Banerjee, and in fact, both the judgments relied upon by Banerjee, having similar facts as the present case, lay down the same proposition of law that the evidence of one trial cannot be read only for the purpose of the accused tried in that trial, can be read only for the purpose of accused tried in that trial, and cannot be used for any accused tried in a separate trial. The view taken by the Calcutta High Court in 1928, expressed by Rankin CJ, has been appropriately followed and accepted and is the correct law. The provisions of law and the essence of case laws, as discussed above, give a clear impression that in the matter of a criminal trial against any accused, the distinctiveness of evidence is paramount. In the light of the accused, it is the right to fair trial, which encompasses two important facets along with others. Firstly, the right of the accused to cross-examine the witnesses. These facts are, of course, subject to exceptions provided under law. In other words, the culpability of any accused cannot be decided on the basis of any evidence which was not recorded in his presence or his pleader's presence and for which he did not get an opportunity to cross-examine, unless the case falls under the exceptions of law as noted above. But this last paragraph will be very, very important. Have a look at this paragraph 46 and 47 for a second. There is one more angle to be considered, that is whether, these are the first submission which I made. There is one more angle to be considered, that is whether to remand one case to the High Court for first decision. That is a case in which the evidence was not considered, and we may proceed to decide the other case here. We find, as in this case, if my lord were to decide these appeals, ಅಲ್ಲಿ ಅವರು ಡಿಸೈಡ್ ಮಾಡಿ ನಮ್ಮನ್ನ there is no illegal extraction ಮಾಡಿದ್ರೆ what would be the fate of this case? ಅಷ್ಟೇ, ಅದಕ್ಕೋಸ್ಕರ was not considered, and we may proceed to decide the other case here. We find if we adopt such a procedure, there is no fruitful purpose would be served, and in fact it would be an exercise resulting in complications and contradictions and even conflicts. If you proceed to hear one appeal wherein the evidence has been considered by the High Court and we agree with the same, then it would influence the High Court in deciding the other matter and remand. Further, even if hold back this appeal and avoid the decision of the High Court in the matter, which we remand, then also the High Court would be able to take an independent decision and would be influenced by the judgment as we would be entertaining one appeal. Moreover, if we allow one appeal, which we are holding back, then nothing may remain for the High Court to decide. There is another reason why we are inclined to send back both the matters to the High Court, which is fundamental. We find that the learned single judge of the High Court has apparently not adopted the correct procedure prescribed under law, and therefore the judgment of the High Court needs to be set aside. Once a common judgment is set aside for one appeal, it can't be upheld for the another appeal. There can't be a severance of the judgment, particularly when it arises in a criminal case, where the rights of the accused are as important as the rights of a victim. Therefore, it will be in the fitness of things and in the interest of parties that the matters are remanded to the High Court for a fresh decision in accordance with law and in the light of discussions and observations made above. Both the matters were sent back. Well, at a division bench of this honorable court, this is what it would say in paragraphs 14 and 17. In criminal appeal number 750 of 2015, connected with other appeals, Balaji versus State, where my honorable friend Mr. Hasmat Pasha represented the appellant. Kindly turn to paragraph 14 and 17. Internal page 20, Milad?
Yes, I am.
Internal page 20. Perusal of the materials, including the judgment and order of conviction passed by the Laurent Session Judge, on looking into the charges framed in respect of accused number 1 to 7, it is an admitted fact that even according to the prosecution, no charge is framed under section 143 and 147. Therefore, the Laurent Counsel so and so is justified in making the submission. The procedure is as contemplated in section 464 of the CRPC, firstly would come into play in the case. But looking to the judgment and order of conviction, accused number 1 to 7 are also convicted for offences punishable under section so and so, for which there is no charge framed at all. In the first accused year, 379 conviction, 420 conviction, there is no charge. Namagana 379 and 420 matra, 379 and 420 do not get attracted, does not get attracted in view of the charge framed against the first accused for an offence under section 409. Well, now kindly go to, it is an important irregularity and illegality committed by the Laurent Session Judge. Kindly go to paragraph 17 for a second, it is a very small paragraph. Hence, we allow the appeals, set aside a judgment and order of conviction passed by the trial Laurent Session Judge. The matters pertaining to all the accused persons are remitted back to the concerned Sessions Court with the direction to the said court to frame the charges afresh against the accused persons and record their evidence afresh without looking into the evidence already recorded. Illustrated conviction case is relevant. Conviction came to be 302. Conviction came to be set at not 302 murder case. Conviction came to be set at not. Proceed to frame a charge afresh, hold a fresh trial is the direction which came to be given. But illi ಇನ್ನೊಂದು judgment Laurent coordinate bench of this honorable court, Honorable Justice Sandesh. But paragraph 27, have a look at paragraph 27 for a second. At page 18, internal page 18 of the judgment. The other contention of the Laurent Counsel for the revision petitioner is that no authorization to file a complaint, etc. Kindly go to skip about 4 sentences from the top. When charge has not been properly framed, my lord gets it. When charge has not been properly framed and conviction and sentence is passed in respect of the violation of the provisions of the Act, it is appropriate to set aside the judgments of both the trial court as well as the first appellate court by keeping open the other contentions. The Laurent Counsel for the revision petition and remand the matter to the trial court for framing appropriate charges and consider the matter afresh. If need arises, the trial court shall also permit the prosecution as well as the revision petition to reduce evidence before the trial court, since proper charge has to be framed and an opportunity has to be given to the revision petitioner to meet the case of the prosecution. And unless the charge is specific, meeting the case of the prosecution by the defense is also very difficult. Hence, the judgment and sentence passed by the trial court as well as the first appellate court is not legally sustainable in the eye of law and it requires fresh consideration. Accordingly, my lord, the revision came to the lord, and the matter was committed by setting at naught the judgment of the trial. And even the Supreme Court also in 2023, if proper charges are not framed, my lord, it culminates in failure of justice.
Soundararajan.
Soundararajan.
Prevention of corruption.
Yes, ma'am. We must deal with another argument.
Para 14.
Para 14. And 17.
Yes. This I am aware.
Yes. We find that in this case, the charge has been framed very casually. But this word which my lord has also used.
Most of the framing of charge is not a frolicsome act. Yes.
It doesn't depict application of judicial mind. It's an incidental observation which came to be made by my lord without even hearing the other side. Your lordship may even change it also. That is only a temporary.
Oh, correct. That is there.
Casually.
This I told on the first day itself.
Yes. The trial court ought to be very meticulous when it comes to the framing of charges. In a given case, any such error or omission may lead to acquittal and a long delay in trial due to an order of remand, which can be passed under section subclause 2 of section 464. Apart from the duty of the trial court, even the public prosecutor has a duty to be vigilant, and if proper charges is not framed, it is a duty to apply to the court to frame appropriate charges. Appeal allowed, judgments are quashed, set aside, appellant is acquitted. And ultimately, because of improper framing of charges, the appellant would get the benefit of a judgment of acquittal at the hands of. This is a case of conviction by the trial court as well as by the High Court under the PC Act.
PC Act.
The first point I submitted to your lordship while inviting my lord's kind attention was the copy paste, cut and paste. In all the cases it is same. I have prepared a chart.
With compilation.
With compilation.
From volume 1.
Volume 1 yeah.
Volume 1 total 5 volumes.
The only change we will
All
see.
6 cases.
The only change we will see is if at all there are any exhibits to be marked in that particular case, I exhibit number matra change avena baki dalla.
ಸ್ವಲ್ಪ ನಂಬರಿಂಗ್ ಆಚೆ ಈಚೆ ಆಗಿದೆ.
We have given
ಇದು copy paste chart.
Copy paste exhibit chart. We have already given the evidence chart. Exhibit same.
Exhibit same. Evidence same. Excepting one case nalli exhibit one adre innond case alli ade exhibit number matra change agutte. Exhibit same. Number matra change agutte. The evidence given by the IO also same in all the 6 cases. My lord, I don't know whether how far your lordship would is persuaded to accept my submission, but in all the 6 cases, judgment also cut and paste, excepting the exhibits. Every para is same. My lord, if my lord is persuaded to accept my submissions,
common evidence chart.
probably my submissions would lend little credence to Nagendra Naik.
It is common evidence chart.
ನಾನೊಂದು ಪ್ರಾವಿಷನ್ ಮೇಲೆ ಒಂದು 2 ನಿಮಿಷ ಒಂದು 10 ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ ನಂದು. Lashme kindly have a look at section 220. Yes. If in one CRPC.
Well, 386 subclause B nalli. Your lordship gets, the appellate court gets
the power to send it back.
Reverse the finding and sentence.
Yes.
Either acquit or discharge the accused or order him to be retried by a court of competent jurisdiction subordinate to such appellate court committed for trial. 386.
Yes.
Your lordship gets jurisdiction.
218 speaks about separate charge for distinct stop. Here, my lord, my case is it is a single offense, part of the same transaction. Section 2.
You are appearing for A1.
If A1, because I am accused in 9 cases, my lord, I am facing number of cases, highest number of cases. Lord, 218 exception is 219, 220, 221 and 223. Because 218 speaks about separate trial for distinct offences. 220, Lashma can say, if in one series of acts so connected together as to form the same transaction, more offences than one are committed by the same person, he may be charged with and tried at one trial for every such offence. Lashma, kindly have a look at the judgment. Lord, how the Honorable Supreme Court has described this same transaction definition.
Amit Shah.
One Amit Shah. Lord, the second judgment is, Lord, at page number Mohan Baita, that is page number 37. Adralli, what should be the last paragraph, Lord, page 354 alli, bottom in the one the line mele, G, note G nalli. It may be noticed that under section 220 of the Code of Criminal Procedure, page number 41.
41.
41 last bottom.
Note
G nal Bharat.
Yes, yes.
It may be noticed that under section 220 of the Code of Criminal Procedure, offences of more than one committed by the same person could be tried at one trial if they can be held to be in one series of acts so as to form the same transaction. The expression same transaction from its very nature is incapable of an exact definition. It is noticed intended to be interpreted in any artificial or technical sense. Common sense and the ordinary use of the language must decide whether on the facts of the particular case, it can be held to be in one transaction. It is not possible to enunciate any comprehensive formula or universal application for the purpose of determining whether two or more acts constitute the same transaction. But the circumstances of a given case indicating proximity of time, unity or proximity of place, continuity of action, and community of purpose and design are the factors for deciding whether certain acts form part of the same transaction or not. Therefore, a series of acts, whether are so connected together as to form the same transaction, is purely a question of fact to be decided on the aforesaid criteria.
Yes.
Lord, based on that, the further judgments are passed. Lord, in this case, the Lordship may kindly see, the first date of FIR is on 15th, that FOC 17. And that is the single FIR. Thereafter, crime number 189. CBI also registered the same one FIR. While filing charge sheet, they split into 9 charge sheets. My submission here is, my lord, it is according to them, it is a single conspiracy with accused number 1, with a common purpose to export the seized goods.
So all of them ought to have been accused in one single
case. One single case. Therefore, my lord,
the crime is 189 of 2010.
Yes, my lord.
Single crime.
Single case.
But while filing charge sheet, multiple charge sheets.
They filed multiple charge sheet in same. Even in CBI FIR also one FIR.
One FIR.
One
charge
FIR.
sheet or multiple.
Charge sheet is multiple FIR. Now, your lordship may kindly have a look at the prejudice caused to me now. Lord, the initial merger my senior has read it, which was conducted on 20th. There is no specific identity of the heaps that were seized. They conducted 5 mergers. Lord, one notes I have prepared. For convenience, I have given the documents also. Lord, page number 4 only, I have given the FIR numbers and mergers also. Lord. There are 5 mergers the prosecution has conducted. ಅದರಲ್ಲಿ ಒಂದು COD-ನವರು ಮಾಡಿರೋದು, ದಿ ಲಾಸ್ಟ್ ಮಾರ್ಜರ್ 7/8/2010, ರಿಮೈನಿಂಗ್ ಫಾರೆಸ್ಟ್ನವ್ರು ಮಾಡಿರೋದು. ಈ 5 ಮಾರ್ಜರಲ್ಲೂ 4 ಮಾರ್ಜರಲ್ಲೂ ಕೂಡ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ, ಟು ಶೋ ದಟ್ ವಾಟ್ ಈಸ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಟು ಮೀ. ನಾವು
409 ಬರಲ್ಲ.
ಇಲ್ಲಿ ಈ 4 ಮಹಜರು ಕೂಡ ಸೇಮ್ ಮಹಜರ್ ಈಸ್ ಪಾರ್ಟ್ ಆಫ್ ಆಲ್ 9 ಕೇಸಸ್. And they rely on the same FIR, same Mahajar, and rely in 9 cases and to say that it is a distinct offense. Therefore, my submission is, it was the trial court ought to have considered these aspects and framed the charge under 220.
Yes.
Place of offense is common, design is common, purpose is common. Therefore, my lord, kindly have a look at the prejudice, my lord. Now, I have to face the punishment in 9 cases and separately. There is nothing to be tried in the rest of the 3 cases which is pending.
Because already done.
Already done. That is the prejudice.
Yes.
Lord, kindly have a look at one major. I will show how these majors also at fault. Lord, COD has conducted a major at page number 113.
ಅಲ್ಲ ಇವರು ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ಮೇಲೆ ಇವರು ಮಾಡಿದ್ರ
ಇವ್ರು ಮಾಡಕ್ಕೆ ಏನು ಉಳ್ಕೊಂಡಿಲ್ಲ ಬಿಕಾಸ್ ದೇ ರಿಲೇಡ್ ಅಪಾನ್ COD major.
Material was directed to be relied on.
ಅಲ್ಲ ಅಲ್ಲಿ ಮಟೀರಿಯಲ್ ಇದೆ. ಈ COD major ನಾನು ಇದ್ರಲ್ಲಿ ಒಂದು ಫ್ಯಾಕ್ಚುಯಲಿ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬಿಡ್ತೀನಿ ತಮ್ಗೆ. ಫಸ್ಟ್ ಮಹಾಜರ್ 15th ಆಗತ್ತೆ. ಅದರಲ್ಲಿ ಏನು ಕ್ವಾಂಟಿಟಿ ತೋರಿಸಲ್ಲ. ತಾವು ಸ್ವಲ್ಪ ಮಹಾಜರ್ ನೋಡಿ, ಪೇಜ್ ನಂಬರ್ 1 ಅಲ್ಲೇ ಇದೆ. ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ. ಎರಡು ಲೈನ್ ಓದ್ಬಿಡ್ತೇನೆ ಬಾಟಮ್ ಅಲ್ಲಿ. ನಾವು 4ನೇ ಲೈನ್ ಇಂದ, ನಾವು ಸಿಬ್ಬಂದಿ ಜನರ ಜೊತೆಗೂಡಿ ಬೇಲೆಕೇರಿ ಬಂದರು ಪ್ರದೇಶಕ್ಕೆ ದಾಳಿ ನಡೆಸಿ ಅಲ್ಲಿ ತಿರುಗಾಡಿ ನೋಡಲಾಗಿ ಅಲ್ಲಲ್ಲಿ ದೊಡ್ಡ ದೊಡ್ಡ ಗುಡ್ಡೆಗಳ ರೂಪದಲ್ಲಿ ಕಬ್ಬಿಣದ ಎದುರು ದಾಸ್ತಾನು ಮಾಡಿರುವುದನ್ನು ಖಚಿತಪಡಿಸಿಕೊಂಡವು. ಸದರಿ ದಾಸ್ತಾನು ಮಾಡಿದ ಜಾಗೆಯನ್ನು ಯಾರ ಆಡಳಿತ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುತ್ತದೆ ಎಂದು ವಿಚಾರಿಸಲಾಗಿ ಬಂದರು ಇಲಾಖೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುತ್ತಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. ಇದರಲ್ಲಿ ಕ್ವಾಂಟಿಟಿ ಇಲ್ಲ, ಏನು ಮೆನ್ಷನ್ ಮಾಡಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ FIR ಆಗ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು ಮಾಜರು 20ನೇ ತಾರೀಕು ಮಾಡ್ತಾರೆ. 20ನೇ ತಾರೀಕು ಮಾಜರು ನೋಡಿ, ಪೇಜ್ ನಂಬರ್ 7. ಇದರಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ ಬರೀತಾರೆ 2 ಲೈನ್ ಇರುವಾಗ, ಅಂದಾಜು ಪ್ರಮಾಣದ ಬಗ್ಗೆ ಸ್ಥಳದಲ್ಲಿದ್ದ ಬಂದರು ಸಂರಕ್ಷಣಾಧಿಕಾರಿ ಹಾಗೂ ಇತರೆ ಬಂದರು ಸಿಬ್ಬಂದಿಗಳ ಜೊತೆ ಸುಮಾರು 5 ಲಕ್ಷ ಟನ್ ಅಧಿಕೃತ ವಿವಿಧ ಗ್ರೇಡಿನ ಕಬ್ಬಿಣದ ಅದಿರು ದಾಸ್ತಾನು ಇರುವುದಾಗಿ ಹಾಗೂ ಕಬ್ಬಿಣದ ಅದಿರಿನ ಮೌಲ್ಯ ಪ್ರತಿ ಟನ್ನಿಗೆ ಸುಮಾರು 3,000ರಂತೆ ಸುಮಾರು 150 ಕೋಟಿ ಅಂದಾಜು ಅಂತ ನಿರ್ಧರಿಸಲಾಯಿತು. ಅಂದಾಜು 5 ಲಕ್ಷ ಅಂತ ಬರೆದ್ರು. ನೆಕ್ಸ್ಟ್ ಥರ್ಡ್ ಮಾಜರ್ ತಾವು ನೋಡಿ, 886, ಅದು ಪೇಜ್ ನಂಬರ್ 9. ಇಲ್ಲಿ 7 ಹೀಪನ್ನ ನಾವು ಮಾರ್ಕ್ ಮಾಡಿದೀವಿ ಅಂತ ಬರೀತಾರೆ ಈ ಮಹಾಜರಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಮಹಾಜರಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ, 8, 9ರಿಂದ 24 ಹೀಪನ್ನ ನಾವು ಸೀಸ್ ಮಾಡಿದೀವಿ ಅಂತ ಬರೀತಾರೆ. ನಾವು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಲುಕ್ ಅಟ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ಸ್. ನಾವು ಒಂದು ಪಿಂಕ್ ಕಲರ್ ಬುಕ್ಲೆಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಅಲ್ಲೇ ಇದೆ ಟೇಬಲ್. ಇದರಲ್ಲಿ
ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ.
230 ಕಂಟಿನ್ಯೂ.
ಎಸ್ ಪಾಟೀಲ್ ಸರ್.
He has not assumed the charge anta madidire. Day before yesterday he has taken charge and there is some mistake in the judgment also. Vaishali Agade amel Nishant ಅವರ ಹೆಸರೆಲ್ಲ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಆರ್ಡರ್ ಇಲ್ಲ, ಯಾವ್ದು ಕೊಡಿ
ಸ್ವಲ್ಪ ಮಿಸ್ ಆದ.
ಯಾವ್ದ್ರದ್ದು ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಇದೆ ಕನ್ವಿಕ್ಷನ್ ತರ ಆಗ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ, ಫಾಲೋಯಿಂಗ್ ಆರ್ಡರ್ ಅಂತ ಮಾಡಿದ್ರೆ ಆ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಪ್ಲೀಸ್ ಟು ಸೇ ದಟ್
ರೀಲೋಡ್ ಇಟ್ ನೌ. ನಾನು ಬರೀ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ನಾಟ್ ಅಸ್ಯೂಮ್ ಚಾರ್ಜ್ ಅಷ್ಟೇ ಕರೆಕ್ಟ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದೀನಿ, ಮತ್ತೆ ಅದನ್ನೇ ಹಾಕಿದ್ದಾರೆ. ಎನಿವೇ ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ.
ಅಸ್ಯೂಮ್ ಚಾರ್ಜ್ ಅಂದ್ರೆ ಚಾರ್ಜ್ ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ ಹ್ಯಾಸ್ ಟೇಕನ್
ಆರ್ಡರ್ ಯಾವತ್ತಿಂದು?
31:10 your lordship.
ಮೈ ಆರ್ಡರ್
ಮೈ ಇಸ್ ಎಸ್ಟರ್ಡೇ ಆಫ್ಟರ್ನೂನ್.
ಯಾವತ್ತು ಅಸ್ಯೂಮ್ ಮಾಡಿದ್ದಾರೆ ಚಾರ್ಜ್?
5th your lordship. ಅದು ನಮ್ದು ಎಂಟೈರ್ಲಿ ಡಿಫರೆಂಟ್ ಕೇಸ್. Interim order granted by this honorable court, we could not proceed with the elections because of the interim granted by this honorable court. Yes, your lordship. Please.
Lord, serial number 25, may I make a mention, Lord? Serial number 25. Lord, senior counsel is engaged in this matter, Lord, for the petitioner.
Bangalore list.
Lord. Bangalore list.
25.
Lord, date was fixed on 30th. Objections are filed now. Lord, senior counsel has expressed some inconvenience today. May I request for, Lord, another date?
Vikram Huligoda.
Please.
At the request of objections ಹಾಕಿದಾರಾ?
Please, Lord, objections ಹಾಕಿದ್ದಾರೆ.
Rejoinder ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, Lord, rejoinder ಹಾಕಿಲ್ಲ.
Counsel appearing for the petitioner seeks 10 days time to file rejoinder to the objections filed by the respondent number 2 to 5.
Please.
List the matter on 20th. List the
Interim
matter.
order.
1 minute, sir. List the matter on 20th at 2:30 p.m. for further hearing. Interim order subsisting will continue till the next date of hearing.
Deeply
My lord, may I make a mention? Serial number 20 in the Bangalore list. My lord, the interim order is subsisting, my lord, in that case.
It will be extended, sir. Innu reach ಆಗಿಲ್ಲ ಅದು wait, yes. You want time ಬೇಕಾ?
ಅಲ್ಲ ಅವ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ಗೆ.
ಎಲ್ಲಿ ಕೇಳಿದ್ರು?
ಅಲ್ಲ ಅವ್ರು ನನಗೆ ಫೋನ್ ಮಾಡಿದ್ರು ನಿನ್ನೆ.
ನೀವೇ ಕೊಟ್ಬಿಡಿ ಹಂಗಾದ್ರೆ. ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ wait.
Please.
Your Lordship,
Yes, Abhinay.
Serial number 19 and 22. May I request your Lordship to kindly have it next week, your Lordship?
We'll take it on 27th.
27th.
Yes.
Not 27th, my lord, any other day, the
19 and 22.
19 and 22. 19 is the list of connected matters. 22 is the one which your Lordship had posted for dictating orders, where I've sought re-investigation.
Either 26 or 28, my lord.
Yes, sir.
ಜಗದೀಶ್ ಸರ್ ಯಾವತ್ತು ಬೇಕು?
26 or 28, my lord, any other day than Thursday.
20? ಯಾವತ್ತು 26th ಬೇಕಾ?
26 ಹಾಕಿ, my lord.
26th ಆಗ್ಬೋದಾ?
Yes, my lord.
26. Yes, Vijay Kumar sir.
Please,
Ah.
I'm appearing on matter before my lords. It's at serial number 7. My lords, please.
Advocate.
Please, my lords. My lords, at 2:30 on matter spilled over, my lords, to the afternoon session. I request my lords to kindly have it on Monday or Tuesday, my lords, please.
Monday I am not sitting. We'll take on Wednesday.
Please.
Inform the other side.
Please, I will. Much obliged.
My lords, end of the list, 2 matters, my lords.
Beka.
Yes, my lords. Tender has been cancelled unilaterally, my lords.
Give it.
Please, my lords.
ನಾನು ತಗೊಂತೀನಿ ಇಲ್ಲ ಹಾಕ್ಸೋದು ನಿಮ್ ಜವಾಬ್ದಾರಿ.
Please, my lords, I'll comply. ತಗೊಂಡ್ ಬರ್ತಾರೆ ನೀವು ಬರ್ಕೊಟ್ರೆ ನಾವು ಪಟ್ಟ
Court officer? Court of,
Sir, ಹೇಳಿ sir.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಏನಾಯ್ತು ಮೇಡಮ್?
9. ಒಂದು ನಿಮಿಷ sir.
ಬೆಂಗಳೂರು ಲಿಸ್ಟ್.
ಪಾಸ್ ಓವರ್ sir.
ಪಾಸ್ ಓವರ್. ಅಯ್ಯೋ. ಆಯ್ತು. ಎಸ್ ಮೇಡಮ್, ಆಯ್ತು. ಥ್ಯಾಂಕ್ ಯು.
Okay sir.
Court officer? Court officer, am I audible to you?
ಬರ್ತಾರೆ ನೋಡೋಣ. ಈಗ ಓಪನ್ ಮಾಡ್ತಾವ. ಬೇಗ ಮಾಡ್ರಪ್ಪ, ಅಯ್ಯೋ ಪುಣ್ಯ ತಂದ್ರ.
Yes, the so and so are present. The learned AGA, on instructions of the two present here, would submit that two of the seven accused have been arrested. The learned counsel submits that two of the accused have been granted regular bail. Counsel for the petitioner submits that the regular bail granted to the two of the accused is also set aside. Therefore, there is no bail in favor of those two accused. Remaining three accused, the learned AGA submits that the law and order situation has gone haywire in farmers' protest, and therefore in the next 24 to 48 hours, the arrest would be made. The submission is placed on record. List the matter on 12th at 2:30 p.m.
Please.
In the event the order would not be complied, the superintendent of police was directed to be present today shall be present on the next date, failing which appropriate orders would be passed.
Obliged.
Yes.
Obliged.
Then 2:30, criminal matter. No. Reporting settlement. Please, please. Settlement.
There are no instructions about the
No
settlement.
instruction.
No.
Bless the matter after 2 weeks. Yes.
Blessed.
55 ಆಯ್ತು.
Lordship on submission.
ಕರೆದವರು.
That serial number 7, Lordship. Request, my lord, I am pressing for interim order.
Not interim order ಅದರಲ್ಲಿ. We'll do it.
Ala, AGP is already there, my lords. He is appearing. Now
Don't
what
worry, if it is arbitrary, we'll put you back for the entire term. All right? If I hold it to be arbitrary, you will be back.
Please, much obliged.
Yes. ತಗೊಂತೀನಿ ಬಂದ್ಮೇಲೆ ಹೇಳಿ. ಗಂಗಾಧರ್ ವಿದ್ಯಾವತಿ ಮೇಡಮ್ ಅಲ್ಲಿ ಇಲ್ಲ ಏನ್ ಸ್ಟೇ ಆಗಿದೆಯಾ ಇಲ್ವಾ? ಸ್ಟೇ ಆಗಿಲ್ಲ ಅಂದ್ರೆ
ಸ್ಟೇ ಆಗಿಲ್ಲ
ಆಗಿದೆ ಅಂತ ಇದಾರೆ, ಆಗಿಲ್ಲ ಅಂತ ಏನಿದೆಲ್ಲ?
ಕೊಡಿ 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 ನಮಗೆ ಕಾಪಿ ಕೊಡಿ ಕೊಡಿ ಕಾಪಿ
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. ತಡೆಯಾಜ್ಞೆ ನೀಡುತ್ತಿದ್ದೇನೆ.
ಒರಿಜಿನಲ್ ಫೈಲ್
ಕಾಪಿ
ಫೈಲ್ ಅವ್ರ ಹತ್ರನೇ ಇರುತ್ತೆ. ಅದ್ರಲ್ಲಿ ಯಾವ್ ತೆಗಿತಾರೆ ಯಾರು ಬಿಡ್ತಾರೆ ಗೊತ್ತಾಗಲ್ಲ ಗೌರ್ಮೆಂಟ್ ನ.
Original file idilva.
This is the sealed by DRCS office and also signed by the DRCS.
If this is the ploy that
Yes,
the
this is-
DRCS is adopting, he will face it, I'm telling
Yes,
you.
this is serious things, my lord.
This is really serious.
Yes,
It's very
Either of the
serious
ways it is serious.
that learned
What is all
advocate,
this?
learned additional advocate general.
Office, ಅಲ್ಲ original records ಅಲ್ಲಿ ತೆಗೆದುಬಿಟ್ಟಿದ್ದೀರಾ? Order ನೇ ತೆಗೆದುಬಿಟ್ಟಿದ್ದೀರಾ original records ಅಲ್ಲಿ? What is this?
ಏನಾಗಿಲ್ಲ. Learned additional advocate general is more loyal than the king. I don't know to whom
No.
he is appearing. State is not a party. If he is
Patil sir.
appearing for DRCS.
Patil
Yes,
sir.
is also state.
ಗಂಗಾಧರ್ ಮೇಲೆ ಅವೆಲ್ಲ ಏನ್ ಬೇಕಾಗಿಲ್ಲ. That's
I am supporting the cause of
whatever
the petitioner,
whatever
my
it
lord.
is, yes, he is making.
It is not cause.
Very unfortunate.
No,
I am
this
supporting-
court would not entertain anything against him. It's not correct. He is doing his job. We will see what order has to be passed. We will pass.
I am supporting the cause of the petitioner. I said, as an officer of the court, this require investigation.
No, he has been one of the excellent officers of the court, sir. I have, that may not be correct. Attributing certain things to him may not be correct. Yes.
Lords, what is
And
very conspicuous.
I don't endorse that at all. Yes.
If I were to just
But
say this,
He happens to be a very good personal friend of mine. But as regards the matters, sometimes these things happen.
Lords, can I just say this, my lords?
Allah, idu Ravi Shankar sir.
Lords,
That we will take care of all that. But look at it. The order is here. Seal is here. Original records ali order is missing.
my lords, now what I wanted to submit is conspicuously the writ petition does not make an averment regarding the filing of this appeal, section 29C, or there being an interim order for the first time, my lords. The reason why I am submitting this is,
Where is the
because if
appeal
your lords
memorandum?
is were to see
Appeal memorandum ali.
It is already recorded in the earlier writ petition and in the order of the earlier writ petition.
Lords, so far as 29C is concerned, it is not part of any of the observations of this honorable court. That's not an accurate statement. It's not even a single line in the entire writ petition. We're not saying that this is an appeal filed or that there is an interim order. We really do not know how this came about, because that is the basis on which they can come before the court. If it is not state, they can't come to the court.
Earlier order ಯಾವುದು? This is Suraj ಅವ್ರದಾ?
Error Sahib road.
ಎಲ್ಲಿದೆ? Page. Page.
ಆ ಕೇಸ್ನಲ್ಲಿ ಆರ್ಡರ್ ಕಾಪಿಯನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇವೆ.
Which case? ಯಾವುದು ಕನೆಕ್ಟೆಡ್
ಅವಾಗ ರವಿಶಂಕರ್ ಅವರು ಇಂಪ್ಲೀಡ್ ಆಗಿರ್ಲಿಲ್ಲ, ಅದಕ್ಕಾಗಿ ಗೊತ್ತಿಲ್ಲ ಅವರಿಗೆ.
ಇಲ್ಲ, ಇದು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಮೇಲೆ
ಅದೇ ಪ್ರದೀಪ್ ಸಿಂಗ್
ಪ್ರದೀಪ್ ಸಿಂಗ್
ಅದ ವಿದ್ಯಾವತಿ ಮೇಡಮ್, ಅದು ಎಲ್ಲಿದೆ ಆರ್ಡರ್? ಕಾಪಿ ಯಾರು ಇದೆಯಾ, ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ ಕೊಡಿ. ಈಗ ಸೂರತ್ ಸಾಹೇಬ್ರದ್ದು ಯಾವ್ದೋ ಇದೆ.
Annexure D, my lord, page 36.
Please, madam, this is the order.
That was writ appeal, and writ appeal went to Supreme Court.
Correct. That is different.
In that order, they are telling that.
ಈ ಪಿಟಿಷನ್ ಎಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿ ಸ್ಟೇ ಹೆಂಗ್ ಮಾಡಲ್ಲ ಅವರು? ಡೇಟ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ನಾಗಿಲ್ಲ, ಪಿಟಿಷನ್ ನಾಗಿಲ್ಲ.
ಆರ್ಡರ್ ಬೇರಿಂಗ್ 26/5/25 ಏನ್ ಆರ್ಡರ್ ಅದು? ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್
26/5/2020.
The disqualification order is dated 2/6/2025.
That is
2/6/2025, correct?
26/5/2000.
26/5/2025.
That is the order passed by the JRCS to staying the calendar of event.
Correct.
Lords,
And order 29C order is on 2/6/2025. And it is stayed on 36/2025 after issuance of the calendar of events.
Heard the learned
a whisper
senior
at least. There
No,
should have been a
well-
whisper at least in the writ petition.
I will have, no, earlier writ petition. The,
My lords, even the earlier writ petition, what your lordships is referring to, my lords, says on the basis of the order of 26/5/2025, when their second respondent stayed the election. My lord, that was considered, my lords, in WP number 103377 of 2025. By orders dated 27/5/2025, my lords,
Appeal
what
memo.
was questioned or was considered was the order dated 26/5/2025. Not, we are speaking about the disqualification orders dated 2/6/2025. 2/6/2025, my lords. There is not even a whisper in the writ petition, present writ petition, or that there is an interim order which has been granted. Lords, I should concede, my lord, that I am not aware of the previous proceedings if there is any reference. But on instructions, I am stating there is no reference to such orders. For the first time, they are saying, my lords, by producing this copy. If your lordships were to see, my lords, the order passed by this honorable court, the very coordinate bench, my lords, on 10/6/2025.
no, that is which went to the Supreme Court.
Yes. In that, if your lordships were to see, my lords, paragraph number 7.
No,
Okay,
now,
okay.
I'll tell
Well,
you,
two
what has
submission.
to happen, will happen, will
10/6/2025.
remain subject to the result of the petition. We will take care of all this.
Two submission, madam. My statement of this is the first round of litigation, madam. My lordship has directed to hold the election. My lordship judgment only in respect of the same
Correct.
society. Hold the election following the 13D2A.
Correct.
Against the said order, they filed a writ appeal.
Correct.
That is pending before the consideration.
Oh, writ appeal is pending.
Writ appeal pending. So meanwhile, the returning officer, why there is a returning officer proceeded with the election, that was interrupted by the Joint Registrar of Cooperative Society. That was questioned before this honorable court. So initially, this honorable court.
Supreme Court directed
Please,
results
please,
to be announced, elections
Please,
to be
please,
conducted.
please, madam. That petition also still pending. So meanwhile, my lord, when the matter was reserved before this honorable court, before my lord, this disqualification order came to be passed. That was filed along with the memo before this honorable court. This honorable court said, no, this is, did not entertain that memo, saying that since in the view of the pronouncement of the main judgment, it has been not entertained. So this disqualification is in respect of not holding up the election. Not holding up the election, 29C order has been passed against the entire board. But the disqualification which present we are talking is because that he ceases to be the director.
What is the last date you ಹೇಳಿದ್ದು?
But the elections was he was
17th last date ಅಂತ ಹೇಳಿದ್ರು.
17th is the last date to send a delegation from the third respondent society to the Milk Federation Bengaluru.
For ಅದು ಒಟ್ಟಿಗೆ
working. The two admitted facts, my lord. 5/1/2025, he ceases to be the director. And regarding the ceases to be director was not stayed by this honorable court. The election was declared, result was declared pursuant to the order passed by this honorable court in the month of October. From the month of January to October, there is a vacuum for the post of directorship. By operation of law 18B, he ceases to be the director. This is the one type of disqualification. The disqualification which alleged to be stayed by the officer is in respect of the entire board members. That is nothing to do with this disqualification. This disqualification is individually attached to the second petitioner. My lord, one more thing, as officers of the court, my lord, I never indulge in any type of the malpractices the senior counsel is talking about.
Don't worry about it.
My lord, what is the file given by this? That is the reason why, my lord, the deputy registrar of the cooperative society.
This is a serious matter.
Yes, my lord,
there is an order and that is.
I openly said this require this serious investigation by the concerned officers. Why there is an order is not there in there? Why the order is in the hands of the petitioner, or if any person removed the order from this file. So that is the reason why I directed the deputy registrar of cooperative society to present before this honorable.
He is a DRCS.
He has a DRCS. So earlier DRCS has transferred. The present DRCS is there. He is the custodian of the file. Yes, my lord, I request this honorable court kindly pass an appropriate order, especially in these types of the cooperative society cases.
All right. 17th last day.
17th is the last date to send the delegation from the third respondent.
I'll post it on 12th and dictate it.
Please.
Yes. Let the record be here with.
Please, please.
Yes. List on 12th.
My lord, I request this, let the earlier Deputy Registrar of Cooperative Society file an affidavit and the present Deputy Registrar of Cooperative Society also file an affidavit.
ಅವರಿಗೆ
petitioner be directed to
ಡಿಸಿಪ್ಲಿನರಿ
file an
ಎನ್ಕ್ವೈರಿನ
affidavit.
ತಮ್ಮಲ್ಲಿ
Let them
ಮಾಡೋದು
state on
ಬಿಟ್ಕೊಂಡು ಕೋರ್ಟಿನ ಕಡೆಯಿಂದ ಮಾಡಿಸೋದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
No, no, we will direct.
Or direct the concerned officer of the state to hold the inquiry on this matter.
That's not the one challenged here.
We'll take it on 12th.
Well,
Yes.
Lord,
List
let
on
there be a
12th.
direction for the petitioner to file an affidavit regarding that order copy. So also from the state, because
Order
it's a
copy
serious
illa
issue.
idile avare kodta idare. Yes.
Lord, that's the reason why I said let it come on record on under oath, Lord, that this is the order copy which has been
affidavit
secured by
haki.
them.
They will
Let
file
them
an
file the
affidavit.
affidavit.
Even earlier also, my lord, this honorable
ಅದೆಲ್ಲ
court made
ಪ್ರೊಡ್ಯೂಸ್
an.
ಮಾಡ್ಬೇಕು ಮೇಡಮ್.
Please.
ಇದರಲ್ಲಿ ಎಲ್ಲ ಅದು ಕನೆಕ್ಟೆಡ್
We have produced in earlier.
ನಿಮಿಷ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಅದು ಬಂದ್ರೆ ಎಲ್ಲ ಸರಿ.
We have produced it before the learned.
It is not, let them make that statement also on oath, because I'm making a statement on instructions, it was not so. Let them not be caught.
Amar, tag this petition along with sounds. List on 12th.
Please.
Morning, I will dictate 12th morning.
Please.
Please, Milords. Milords, your lordships may direct them to file an affidavit, Milords, so that your lordships can
I
handle appropriately.
don't know why all that, my lord.
Lord, there is a
The
reason.
matter
A
which is
statement is made across the bar
before the
that-
court is of a different type.
ಹಾಕಿ ಮೇಡಮ್.
ಅದ್ರದ್ದು ಬೇಕಾಗಿಲ್ಲ ಇದು.
Already in earlier matter, my lord, we
Tag
have
again.
filed
Don't
along
go.
with
That too at the
affidavit.
instance of
We
a
have
person
filed
who is
along
yet
with
to be
affidavit.
implemented.
And observation is also made in the
List
interim order.
list the matter on 12th. Yes.
Please, Milords.
Earlier petition tag ಆದ್ರೆ ಎಲ್ಲ ಬರುತ್ತೆ ಅದರಲ್ಲೆಲ್ಲ ಇದೆ.
ಅದು ಟ್ಯಾಗ್ ಆಗೋದು ಬೇಕಾಗಿಲ್ಲ. ಈ ಕೇಸ್ ಬೇರೆ, ಆ ಕೇಸ್ ಬೇರೆ.
That is, there is a direction.
ಪುಟ್ ಅಪ್ ಮಾಡಿಸ್ಕೊಂಡು ವೆರಿಫೈ ಮಾಡ್ರಿ, ಬಟ್ ಟ್ಯಾಗ್ ಮಾಡಿ ಹಿಯರ್ ಮಾಡೋದು ಅಲ್ಲ.
ಆಯ್ತು ಸರಿ.
ಪುಟ್ ಅಪ್ ಮಾಡಿಸ್ಕೊಂಡು ಹಿಯರ್ ವೆರಿಫೈ ಮಾಡ್ರಿ. We have no objection.
ಅದು ಬರ್ಕೊಳ್ಳಿ. List
ಅವ್ರು
matter.
ಟ್ಯಾಗ್ ಮಾಡಿ ಹಿಯರ್ ಮಾಡ್ಬೇಕು ಯಾಕೆ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ಆ ಕೇಸ್ ತಗೊಳ್ರಿ, ಇದನ್ನ ಈ ಇಲೆಕ್ಷನ್ ಇದೆಲ್ಲ ಮುಂದೆ ಹೋಗ್ಲಿ ಅಂತ.
Number ಬರ್ಕೊಳ್ಳಿ. List the matter on 12th along with so and so, not tagging but in seriatim. Yes.
Please.
Please, Milords.
ಈಗ ನಾಗೇಂದ್ರ next. 5 minutes. You get back.
Lord, I was referring to the-
ಏನಿತ್ತಲ್ಲ? Simple.
Simple, Lord, to conduct the election of the office bearers.
Yes, correct. 5 ನಿಮಿಷ. I'll take.
Please.
Before raising, I will pass an order.
But I was referring to the merger only for the limited extent to show that, my lord, it is interconnected. Morning, I gave a small note along with that certain documents.
Yes, sir.
In that, my lord, page number 13, your lordship kindly. This merger is dated 7th August 2010. After registration of 189/2010. But after 31st of May 2010, there is no export from this port. This merger is drawn by the COD. Lord, kindly have a look at page number 17. One or two examples I will show that page number 17 nalli. A merger, last 4 lines, first paradalli. ಈ ಕಂಪನಿದ ಗುಡ್ಡೆಯು ಸ್ವಸ್ತಿಕ್ ಸ್ಟೀಲ್ ಹೊಸಪೇಟ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ಗೆ ಸೇರಿರುತ್ತದೆ. One or two examples just I am showing. Lord, finally, your lordship kindly see, there are other companies also. Last paragraph, your lordship, page 54.
Yes.
ಈ ಎರಡನೇ ಪರದಲ್ಲಿ ಬೇಲೆಕೇರು ಬಂದರ್ ಪ್ರದೇಶದಲ್ಲಿ ದಿನಾಂಕ 7/8/2010 ದಿನಾಂಕ 9/8/2010 ಜರುಗಿಸಿದ ಮಹಜರ್ ಪಂಚನಾಮೆಯ ಕಾಲದಲ್ಲಿ ಅದಾನಿ ಎಂಟರ್ಪ್ರೈಸಸ್ ಲಿಮಿಟೆಡ್ ಕಂಪನಿಗೆ ಸಂಬಂಧಿಸಿದ ಜಾಗದಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ರಿಂದ 34 ಒಟ್ಟು 34 ಕಬ್ಬಿಣದ ಎದುರುಗುಡ್ಡೆಗಳು ಮಲ್ಲಿಕಾರ್ಜುನ್ ಶಿಪ್ಪಿಂಗ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ರವರಿಗೆ ಸಂಬಂಧಿಸಿದ ಜಾಗದಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 35ರಿಂದ 50ರವರೆಗೆ ಒಟ್ಟು 16 ಕಬ್ಬಿಣದ ಅದಿರುಗುಡ್ಡೆಗಳು. ಸಲ್ಗಾಂಕರ್ ಮೈನಿಗೆ ಕಂಪನಿಗೆ ಇಂಡಸ್ಟ್ರೀಸ್ ಮತ್ತು ತುಂಗಭದ್ರಾ ಮಿನರಲ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ಗೆ ಸಂಬಂಧಿಸಿದ ಜಾಗದಲ್ಲಿ 51ರಿಂದ 54ರವರೆಗೆ ಒಟ್ಟು 4 ಕಬ್ಬಿಣದ ಅದಿರುಗಳು ಗುಡ್ಡೆಗಳು ಮತ್ತು ರಾಜ್ಮಲ್ ಸಿಲ್ಕ್ ಕಂಪನಿಯಿಂದ ಸಂಬಂಧಿಸಿದ ಜಾಗದಲ್ಲಿ 55ರಿಂದ 56 ಒಟ್ಟು 2 ಕಬ್ಬಿಣದ ಅದಿರುಗುಡ್ಡೆಗಳು ಇದ್ದು ಒಟ್ಟಾರೆಯಾಗಿ 56 ಕಬ್ಬಿಣದ ಅದಿರುಗುಡ್ಡೆಗಳು ಇರುತ್ತವೆ. ಇಲ್ಲಿ ಏನಕ್ಕೆ ನಾನು ಈ 4 ಮಾಜರ್ ತೋರಿಸಿದೆ ಅಂತಂದ್ರೆ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಆಫ್ 24 ಐರನ್ ವರ್ಗೆ ಹಿಪ್ಸ್ ಸೀಸ್ಡ್ಗೆ ಎಲ್ಲೂ ಕೂಡ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ. ಇಲ್ಲಿ ಕೈಂಡ್ ಹ್ಯಾವ್ ಲುಕ್ ಎಟ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ನಂಬರ್, ದಿ ಪಿಂಕ್ ಕಲರ್ ಬುಕ್ಲೆಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ವಿಚ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಫಾರ್ ಟ್ರಯಲ್.
ಪೆಂಡಿಂಗ್ ಫಾರ್ ಟ್ರಯಲ್.
ಪೆಂಡಿಂಗ್ ಫಾರ್ ಟ್ರಯಲ್.
ಯಾವುದು?
ಆ ಒಂದು ಪಿಂಕ್ ಕಲರ್ ಸ್ಪೈರಲ್ ಬೋರ್ಡ್ ಕೊಡಿ. ಪೇಜ್ ನಂಬರ್ 63 your lordship may kindly have a look. ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಅಕ್ಯೂಸ್ ಗ್ರೀನ್ ಟೆಕ್ಸ್, ಸೆಕೆಂಡ್ ಅಕ್ಯೂಸ್ ಅಜಯ್ ಕರ್ಬಂದ, ಥರ್ಡ್ ಅಕ್ಯೂಸ್ ಇಸ್ ದಿ ಅಪಲೆಂಟ್ ದಟ್ ಇಸ್ ಮಹೇಶ್ ಬಿಳಿಯಾ, ಫೋರ್ತ್ ಅಕ್ಯೂಸ್ ಕ್ಯಾಪ್ಟನ್ ಸಿ ಸ್ವಾಮಿ, ಫಿಫ್ತ್ ಅಕ್ಯೂಸ್ ನರೇಂದ್ರ ಜಿ ಹಿತ್ತಲ್ಮಕ್ಕಿ and Chandrakant Govind Naik. Kindly see the allegation, my lord, page 75 against them.
70?
75.
70?
75. 75.
Charge.
Third parak state bandbidthe. Sorry, second parak. On 23/2010, CG Naik RFO A6 with other staff and panchas visited Belakere port and prepared a panchnama and seizure report showing seizure of iron ore on approximately 5 lakh metric ton. After the seizure, Chandrakant Govind Naik, the investigating officer of the forest, case number 17/2009/10, handed over the seized iron ore as his various visits to Sri Mahesh Jibulia, Port Conservator Belakeri, port number so and so, dated 23/2010 for safe custody. It is pertinent to mention here that during the relevant period, Mahesh Jibulia, Deputy Port Conservator Belakeri, was holding charge of the port officer Belakeri. He has issued all letters correspondence assuming himself as a port conservator Belakeri. As such, all reference of the port conservator Belakeri hereinafter would mean Sri Mahesh Jibulia, Deputy Port Conservator Belakeri Port. The Narendra G. Hittalmukhi, Chandrakant Govind Naik A6, along with other forest officials and panchas, visited Belakeri Port on 26/3/2010 and 29/3/2010 and marked 24 heaps of iron ore. Out of about 60 heaps has seized and drawn the panchanama showing the quantity of the marked heaps as approximately 5 lakh metric ton. Leaving out the remaining unmarked heaps as seized, and although no documents were checked in respect of these unseized iron ores. I will not go further, my lord. I am reading this for specific purpose. Lordship may kindly see, the entire 6 cases are based on the Mahajar and FIR by these accused number 5 and 6. Now, after putting 8 cases against me, in 9th case, they make these 2 people are again as accused. Now the question is, who has to identify the seized iron ore, seized heaps? In total 9 case, totally there are 16 heaps which is subject matter of the 9 charge sheets. Remaining 9 heaps, it is nobody has identified what happened to that. It is not there. Now the question is, COD files an application before the very same court to auction the iron ore seized under this Maja dated 7th August 2010. Therefore, my submission is, my lord, these are all mixed facts which has to be tried in a single case. Lord, CBI may contend, there is one judgment, Lord, earlier during FIR stage, they went to the High Court. Ratnakala. Adralli, that contention is, they have withdrawn.
No. Prayer bere. Nodi. What his lordship would say is,
Nandralli hakidin, nan compilation last hakidin, because they will refer to that.
What I have withdrawn is something different. Prayer bere. There are 2 prayers. Have a look at the prayer.
Wash the charge sheet and order sheets produced on SLF.
Prayer number 2 was withdrawn. Not
prayer number 2. Clubbing it is.
First prayer A, my lord gets it at page 5 of the order. Issue a writ of certiorari or any other order or direction in the nature of certiorari, quashing special CC number so and so,
The charge sheets and the order sheets for which are produced at Annexure F to Annexure are pending disposal. That is if A. B is issue a writ of mandamus or an order or direction in the nature of mandamus directing the respondent to treat the charge sheets in FS number so and so, Annexure so and so, charge sheets filed in special CC number so and so as an additional charge. That's it. I have not sought for clubbing of the case.
ನಾನು ಅವಾಗಲೇ ನೋಡ್ಬೇಕಾದ್ರೆ ಇದು ನೋಡಿದೆ.
Supplementary charge sheet and that prayer also next paragraph ಅಲ್ಲಿ at this stage we will not consider ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದೆ.
Let the CBI come up with
ಅಷ್ಟೇ. ಅಲ್ಲ
treated as supplementary charge sheet ಅಂತ ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ. ನಾನು ಕ್ಲಬ್ಬಿಂಗ್ ಕೇಳೇ ಇಲ್ಲ ಇದರಲ್ಲಿ.
ಹಾಗಾಗಿ ಆಮೇಲೆ page 81 ನಲ್ಲಿ
I have withdrawn prayer B regarding to treat this additional supplementary charge ಅಷ್ಟೇ.
page 81 your lordship.
Page
81 ಅದೇ ಬುಕ್ಲೆಟ್ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಿದ್ದೆ.
ಈ ಕೈಯಲ್ಲಿ ಇಲ್ಲ ಇದರಲ್ಲಿ. ಎಸ್
ಅದರಲ್ಲಿ
ಹೇಳಿ.
ನಾನೊಂದು ವಿಟ್ನೆಸ್ ಲಿಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ ಹೌ ದೇ ಆರ್ ಕಾಮನ್ ಅಂತ ತೋರಿಸೋದು. ಬೆಳಿಗ್ಗೆ ಒಂದು ಸ್ಟಿಚ್ ಮಾಡಿರೋದು ಅದಲ್ಲ ನಾನು ಬೆಳಿಗ್ಗೆ ಅದಲ್ಲ ಬುಕ್ಲೆಟ್ ಈಗ ಮಾಜರ್ ತೋರಿಸಿದೆ. ಮಾಜರ್ದು ಅದೇ ಬುಕ್ಲೆಟ್ ಮಾಜರ್ ಜೊತೆಲಿ ಅದರಲ್ಲಿ page 81 ನಲ್ಲಿ how the witnesses are interconnected ಅನ್ನೋದಕ್ಕೆ ಕಂಪ್ಲೀಟ್ ಒಂದು ಚಾರ್ಟ್.
ಸಿಂಗಲ್ ಟ್ರಯಲ್.
ಸಿಂಗಲ್ ಟ್ರಯಲ್. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯಾವ ಕಾಮನ್
Let's see what they say because more than one instance is indicated that it should have been a single trial. And the appellate court can send it back for doing that. Then we'll hear the CBI.
My lord, I have some submission, my lord.
Pasha sir, separate ಏನಾದ್ರು ಇದೆಯಾ ನಿಮ್ದು?
Yes, my lord. Our appeals are different, my lord. Totally on different ground, not on that ground, my lord. Oh, it may be.
Allah, if that is to be heard on merit, we will see.
Not
First,
on
let
merit,
this-
your lordship. Not on merit says the same technical point, my lord. If your lordship satisfied, my lord, then judgment is to be set aside. My lord, one aspect your lordship may kindly see. My lord, by order dated 7/9/2009, my lord, Supreme Court directed for investigation by CBI in respect of illegally exported iron ore to the extent of 50 lakhs 79, my lord. 50.79 lakhs, your lordship.
Yes.
CBI in pursuance of this order, my lord, registered 4 FIRs, my lord.
Yes.
4 FIRs, my lord, RT 13A to 16A registered, my lord, investigation was commenced.
Yes.
In the same order, my lord, there was an order that also to investigate in respect of removal of iron ore to the extent of about 5 lakhs or 8 lakhs. This figure, my lord, little changes it is.
Yes.
Which were stored in the Belekere port and they were in the teeth of seizure order passed by the Honorable JMFC Ankola.
Yes.
My lord, this is also to be investigated. Kindly, my lord, that this defense, my lord, our case, my lord, our appeal, my lord, pertains to special CC 53/2016, my lord. 53/2014, my lord. Out of this 7 cases, 1 case, my lord.
Yes.
53/2014, accused number 2 and 3, my lord.
Yes.
Accused number 2, my lord, is Sri Lakshmi Venkateshwara Minerals, your lordship. Accused number 3, my lord, is K. Mahesh Kumar alias Karpuri Mahesh Chand. My lord, against these 2 persons, my lord, the allegation is the firm, my lord, accused number 2 had sold 108,000 and odd metric ton of iron ore to accused number 4, a company, my lord, by name SMSPL, my lord, my learned senior advocate, my lord, Mr. Nagesh is appearing. My lord, here, what the role of our accused, my lord, is they sold 108,000 metric ton of iron ore on the strength of contract.
Interruption. If he is arguing the matter on merits, my lord, since we have not argued,
not
that may
on
be dealing.
Not
That may be dealing.
Not on merit.
Pasha sir.
Merit is maybe separated.
1 minute. Pasha sir. I'll take this on 27th in Bangalore itself.
One nimsha, it will be clarified. Nothing to hurry it is.
Merits
Maybe our matter may be heard separately. We are not that.
ನಿಮ್ಮ ಮ್ಯಾಟರ್ ಸೆಪರೇಟ್ ಆಗಿ ಕೇಳ್ತೀನಿ.
ಈಗ 1 ನಿಮಿಷ ಇಲ್ಲಿ ಹೇಳ್ಬಿಡ್ತೇನೆ, ಅದು ಬೇಕಾಗಿ ಬೇಡ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ.
ಆಯ್ತು. ಎಸ್.
ಇದರಲ್ಲಿ 108,000 metric ton of iron ore that was sold, my lord, is already covered in RC 16A. My lord, what we have sold, my lord, is to be tried, my lord, in RC 16A. My lord, our role, my lord, is on FOR basis. My lord, a contract, my lord, which is marked Exhibit P82. Exhibit P82 is the contract between accused number 2 and accused number 4. My lord, our role is only to deliver to the Belekere port. Once it was delivered, my lord, it is the ownership, my lord, is of accused number 4. My lord, our role is to, my lord, comes to end on delivery. As on the date of seizure, we forest officer, we are not owning anything. Kindly see, my lord, that 15/3/2010, my lord, forest officer seized the iron ore material. As on that day, FOC was registered. 23/2018, my lord, and 8/6, my lord, Ankola police registered FIR in crime number 89, my lord, 189. As on that day, the material was not belong to us. It was belong to accused number 4. Question is, who had removed it? Another question, my lord, that in support of that A4 itself, Lordship may kindly see, A4 is facing trial in RC 16A in respect of the same material. In respect of same material, my lord, trial is pending. Suppose in that trial, my lord, he gets an acquittal. Suppose in that trial, our accused also gets an acquittal. This trial will not take place, your lordship, because they will be the owner. They will not be the thief. They will not be liable for offense of either thief or cheating anyone. This is the, my lord, the crux of the matter here. My lord, unless 105 is tried, my lord, this trial cannot be tried. We urge before the trial court. In spite of it, the trial court, my lord, has hurriedly passed this judgment. We do not know that why it was. In spite of cross-examination is all it is demonstrated. And it was shown to the judge also at the stage of investigation officer. We requested that please hands off this judgment till the disposal of 105. That is when special CC number 105, where legality or illegality is questioned. It is for the CBI to prove it. If it is illegal, my lord, then, my lord, continuation of this offence, whether it is offence or not, it is. Suppose if the accused number 4 SMSPL is the owner of this iron ore, my lord, exporting is not illegal. It's only, my lord, that the order of the Honorable JMSC, permission should have been taken. That has not been taken. That my lord, may be at best, my lord, as a contempt of court, a disobedience of the order. But charge, my lord, for 379 and 420 does not apply. Yes. But so far as our accused is concerned, my lord, our role ended on delivery. It was delivered, my lord, as on before seizure. That is, my lord, before 15/3/2010, my lord, our role of accused number 2 and 3 was ended in delivery of iron ore material. We were no longer owner or in possession, and we did not remove it. Therefore, none of the charge sustains.
All right. We'll hear you again on CBI counsel, I think.
Yes, with respect to documents, my lord, I will show you, Lord, particularly.
Heard the senior. ಇನ್ನು ಎಕ್ಸ್ಟ್ರಾ ಇದೆಯಾ ನಿಮ್ದು ಸೀನಿಯರ್ ಹೇಳಿದಲ್ದೇನೆ?
ಅಲ್ಲ ಅವರು
not on merit, sir. We are all the submissions are on the periphery. It is not going deep into the appeal. Sir is cleared then so much. Mat peripheral ಮತ್ತಿನ್ನೇನಿದೆ?
I'm sorry, kindly bear
with 27 ಕೇಳುವ. ಅವತ್ತು CBI ಕೇಳಕ್ ಮುಂಚೆ ನಿಮ್ಮನ್ನ ಕೇಳ್ಬಿಟ್ಟು ಕೇಳ್ತೀನಿ.
Please, my lord. Because remand should serve some useful purpose, my lord, by virtue of the contention.
ಅಂದ್ರೆ remand will not serve useful purpose ಅಂತ ಹೇಳ್ತಿರೋದು.
Acquittal ಆದ್ರೆ ಇಲ್ಲಿ appeal allow ಆಗುವಂತ ಕೇಸು ಅಂತ ಅನ್ಸುತ್ತೆ ನನಗೆ. Looking at the case.
ಹೌದು. It is our case that some of the accused are entitled for acquittal on technical grounds.
On the face of it. The second thing is, my lord, what happened is, my lord, our alleged export is part of the main case, as pointed out by my
first argument made the senior.
So therefore, no, there is no point in connecting all these 9 charge sheets.
27th will.
If at all, my lord, I may have to be tagged with that worst situation. If at all, not 9 and one trial.
First we will hear you and then hear the CBI.
Strictly speaking, now 379, 420 ನಮಗೆ acquittal ಆಗಬೇಕು. ಅದಕ್ಕೆ ಥೆಫ್ಟ್ ಇಲ್ಲ, ಚೀಟಿಂಗು ಇಲ್ಲ ನಮ್ದು.
ರಿಮಾಂಡ್ ಮಾಡ್ಕೊಂಡು
ಇವ್ರಿಗೆ 9 ಕೇಸ್ ರಿಮಾಂಡ್ ಯಾಕೆ ಬೇಡ ಅಂದ್ರೆ ಅವ್ರು ಇರೋದು ಒಂದೇ ಕೇಸಲ್ಲಿ ರಿಮಾಂಡ್ ಆದ್ರೂ ಆಗದೆ ಇದ್ರು ಏನು ವ್ಯತ್ಯಾಸ ಆಗಲ್ಲ.
ಅಲ್ಲ, in the fitness of things, my lord, I only.
Again, I will have to undergo the ordeal. That's the concern.
ನಮಗ್ ಚಾರ್ಜ್ ಎಲ್ಲಿದೆ 379?
In
Oh, and
respect
9
of our
ಆಗ್ಬಿಟ್ಟು
case,
ಅಲ್ಲಿಗೆ.
in respect of our accused, my lord, charge itself should not have been framed. My lord, we objected it during cross trial also objected, but still my lord, trial went on. We hope that, you know, at least at the judgment, my lord, we will gain acquittal. But my lord, trial court wrote 120B.
Heard the learned senior counsel C.V. Nagesh, learned senior counsel Hasmat Pasha, learned counsel R. Nagendra Nayak, learned counsel Ravi appearing for the petitioners, appellants in all these cases. Awaiting the submissions of the CBI, list this matter on 27th. 27th I'll be sitting there only.
Lord, I may be permitted to
Condoning
make.
my absence on that day, my lord.
No problem. ನಾವು ಆಗಿದೆಯಲ್ಲ ತಪ್ಪು. CBI ಮಾಡ್ಲಿ.
ಬಿಜಾಪುರದಲ್ಲಿ ಭೀಮಾ ತೀರದ ಹಂತಕರು.
Yes.
Sunil wants me there.
Yes, yes.
On that day, my lord, I may be permitted to make.
Your advocate on record is all over now.
ಮತ್ತೆ 27ನೇ ತಾರೀಕು ಅದಾದ್ಮೇಲೆ if my lord feels that reply is needed, kindly accommodate us.
No, definitely. I'm in no hurry.
Lord, insofar as.
I'm in no hurry like the hurry of the concerned court.
I may be permitted to address
Yes,
my arguments.
yes.
Grateful.
We'll produce the judgments along with the memo.
ಎಲ್ಲ ಈಗ ಇನ್ನೊಂದು
Yes, I'll do
ಪೇಪರ್ ಬುಕ್ ಇರುತ್ತೆ. ಈಗ ನಾಗೇಂದ್ರ ನಾಯಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಒಂದು ಕನ್ವೀನಿಯನ್ಸ್ ಕಂಪೈಲೇಷನ್ ಓನ್ಲಿ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ವಾಟ್ ಎವರ್ ಸಬ್ಮಿಷನ್ಸ್ ಆರ್ ಮೇಡ್, ಅದನ್ನೊಂದು ರೆಡಿ ಮಾಡಿ ಕೊಟ್ರೆ.
And I'll will give
15.4 ಅಲ್ಲಿ ನಾವು appellant presence ಮೇಲೆ
ಅದೆಲ್ಲ ಬರ್ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ ಪ್ರೆಸೆನ್ಸ್.
Great.
27th.
Interim orders to extend.
That will absolute ಇಲ್ಲ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತಿಲ್ಲ, ಅಬ್ಸಲ್ಯೂಟ್ ಇದೆ ಎಲ್ಲದರಲ್ಲೂ.
Oblige.
Yes.
My lord, serial number 9, your lordship.
9 Pasha sir.
Please, your lordship.
ಒಂದು ನಿಮಿಷ ತಾಳಿ, I'll get back to that, wait. ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಜಗದೀಶ್ ಅವರು ಬರಕ್ಕೆ ಹೇಳಿ. AGA. Yes, now Raghavan sir.
Forest area or not. Detailed survey in the result of the notification.
ಇದು ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಟ್ರಾವೆಲ್ ಆಗುತ್ತೆ, ಯಾವ್ಯಾವ ಕೋರ್ಟ್ ಕವರ್ ಆಗಿದೆ ಎಲ್ಲ ಬರುತ್ತಿದ್ದಾರೆ.
Too much of echo, my lord. Can't hear anything here. 50% of what was said was not being. 50% of what was being said not audible at all here.
I am also trying to set it right. It is even worse. Each change ಮಾಡಿ. It's terrible. Imagine our plight. What to do?
I know, man.
ಎಲ್ಲಿ petitioner? ನಂದಕುಮಾರ್ ಸರ್ ಎಲ್ಲಿ? OS ಸರ್.
ಅವರು BC ಇದ್ದಾರೆ.
He is here.
Any other persons other than
the echo my learned senior friend's submission on echo. That's why I kept myself on mute.
No. He was saying Nandakumar argues, it echoes.
Steps has to be taken.
The submissions are that strong that it keeps echoing.
Yes.
That's what he was telling.
Yes.
Yes, sir. Let me also hear that. Heli. I think you had to submit.
Yes.
Locus you have submitted.
No, madam. I just started. I have to
because ಅವರು ಹೇಳಿದ್ದಾರೆ. On locus you said you want to submit.
Yes. My lord, our principal contention, my lord, apart from the merits, is to point out your lordships, my lord, that the petitioner has no locus in the present. Kindly see the prayer in the writ petition. Kindly see page 29, my lord. issue a writ of such a RI or any other appropriate writ, order or direction, quashing the impugned letter dated 7/2/2025, bearing number so and so, issued by respondent number 1. Issue a writ of such a RI or any other quashing the registered subleased deed dated 20th of March 2025, Annexure A,
Yes.
executed between respondent number 2 and respondent number 3, being wholly illegal, arbitrary, and violation of 11A and other material provisions of the lease cum sale agreement dated 7/6/2007.
Yes.
Issue a written as a mandamus directing respondent number 1 to forthwith take all steps as warranted in law, including initiation of proceedings under 34 and 38 against respondent number 2 for breach of the terms and conditions of the lease cum sale agreement dated 7/6/2007. Principally, my lord, therefore, what is sought to be challenged is a communication that has been issued by KADB to the company. Under that letter, my lord, your lordship may kindly see that letter, my lord. It has been produced at page 124 of our statement of objections. What is it that the KADB did? All that the KADB has done is, having regard to the provisions contained in clause 11A, we grant you permission to sublease the property. This is what has been done. Now, my lord, our submission is, who is the petitioner in this case? Petitioner, my lord, admittedly, he is not a shareholder. Admittedly, he is not a creditor. Admittedly, has no other interest. But he claims, which he did in the earlier round of litigation, to have an inchoate right. That is his case. Now, the question, my lord, is as to whether a person who claims an inchoate right can be said to be a person who is aggrieved for the purpose of filing a writ petition seeking a certiorari. This, as between the parties, is no longer open to debate, is my respectful submission.
Yes, Hemant Chandan Gowda.
Exactly, my lord, his lordship has gone into it in full detail. And in earlier round of litigation that your lordship may kindly see, my lord, your lordship may kindly see what was challenged. In the first round of litigation came up before your lordships, my lord, what was questioned was that KDB is not taking any action because the allottee, namely my client, has committed certain violations of the terms of the lease cum sale agreement.
That is why we held it to be entertainable.
Exactly.
Because
in fact, my lord, I must
know if you say, sorry.
I'm sorry,
KADB, I held it to be maintainable because KADB was a party to the agreement or whatever.
Yes.
Here also KADB has given it on.
No, my lord, there your lordships did not hold it to be maintainable. I'll show to your lordship that order. Your lordship said, having regard to the submission that was being made by KADB,
KADB said, action tagantivi.
They said, we will take action. And in fact, my lord, certain directions were issued by your lordships. In fact, your lordships did not hold, if I may say so, without any fear of contradiction. I showed your lordship the earlier order. Your lordships did not go into the question of locus at all. There is no finding in the first round of litigation. This is the third round of litigation. In the first round of litigation, there was no finding that petitioner has locus insofar as the present proceedings are concerned. There is no finding. Please look at that order, my lord, if your lordships are kind enough. Kindly turn to the order dated 16th of May 2023, which your lordships will find at page 150. In fact, my lord, KDB said, we will look into it. If there is a violation of any of the provisions of the lease cum sale agreement relating to mortgages, we will examine it. We will take action. Now, your lordships may kindly see, my lord, what your lordship said in that case. In fact, your lordships asked me on the last occasion, what happened to the finding that was recorded in the first round of litigation on locus? Was it set aside by the division bench? Answer to that, my lord, my respectful submission would be, there is no finding.
In
the first round.
There is no finding on locus.
No finding on locus. Therefore, the question of setting aside doesn't arise. Now, the finding on locus is clear and categorical in the second round of litigation. I will now show to your lordships, my lord, what your lordship said in the first round of litigation. If your lordships will kindly see, my lord, kindly turn to paragraph number.
No, I would only want this para 18 and 19.
Yes, my lord.
At page 178, 179.
Exactly, my lord. I'm coming to that. I'm coming to that, my lord. I'm very grateful to your lord.
Asks over the issue of locus.
Yes, my lord. Your lordships only said masks the issue of locus. Your lordships did not say, if I may say so respectfully, my lord, that the petitioner has locus. All that your lordship said was, well, there are some serious allegations relating to breach of the terms of the lease cum sale agreement. Therefore, that is something that has to be gone into. And in that context, your lordships also noticed the submission that had been made by the KADB, which said, we will look into it. Now, my lord, please see the final direction that we are given, which I may say so, my lord, has been watered down and
By the division bench.
by the division bench. Now, that order passed in the first round of litigation by your lordships and as watered down by the division bench in the first round of litigation has been extensively considered by in the second round of litigation. Now, the second round of litigation, my lord, is similar to this round of litigation. Because in the second round of litigation, what was questioned was again an action that had been taken by the KADB. My lord, first round of litigation, there was no action by KADB.
Yes, there was no
First
action.
round of litigation, my lord, was an allegation against me.
Allegation that KADB is keeping silent.
Exactly.
About your actions.
Exactly. Therefore, my lord, the charge was directed principally against me. In the second round of litigation, where pursuant to the direction issued by your lordships and the division bench as modified, action was taken by KADB, my lord, and they granted the extension. That was called in question. Similar, an action by KADB was called in question. That clearly, my lord, in the second round of litigation, the court said the petitioner has no locus. And in fact, my lord, the judgment relied upon, but if there's an illegality, what happens? That also has been considered. Today, my lord, and there is no stay order in the writ appeal which is now pending.
Against Justice Hemant's order.
Yes, ma'am. It is just pending. There is no stay order. They asked for stay order, they pressed for stay, no stay has been granted. All that, and in fact, very interestingly, my lord, in that, all that the learned division bench did was, your disputes are all pending in the OS, in the commercial OS. Do you want to go for mediation? Not to resolve the dispute that is pending in the present writ petition. With respect to your private rights contained and canvassed in that commercial OS, go to mediation. Mediation has failed. Now, my lord, the question would be as to whether this round of litigation is made. But now, therefore, my lord, please permit me to point out your lordships, my lord, what your lordships have directed. Kindly turn to para 19, my lord. Of page 178.
I'm there.
If the aforesaid facts, glaring enough they are noticed, what would emerge is that the board is silent on the alleged violation of its property that was leased to the second respondent for a particular purpose, albeit on consideration. The purpose is deviated and not stopping at that. Using the scheduled property, the land which belonged to the board, the second respondent has created several charges on the said property in violation of the terms of the lease. In such glaring facts, what is involved is inaction of the board, the estate under Article 12 of the Constitution, qua the property that belonged to the board, and the question of locus of the person who brings the constitutional court. Such illegality gets blurred as the issue that is brought before the court masks the issue of locus. This is, therefore, your lordship did not give a finding on locus. Your lordship did not come to a conclusion that petitioner has locus. Now, my lord, this order was carried in appeal. Would your lordships now please be kind enough to look at the order passed, my lord, by the division bench in the writ appeal that was filed. If your lordships will be kind enough to turn, my lord, to page 100 and, my lord, the order begins
93.
at page 189.
193 is the conclusion.
Yes, yes, respectfully, my lord. My lord, if I may just trouble your lordships to kindly see para 7 for a minute, page 191. At this juncture,
all of them are.
No, I'm sorry, my lord. If your lordship will kindly see para 6, para 6 at page 190.
Specific stand taken.
In view of the specific stand taken by the board to inquire into the matter regarding the violation of the terms of the lease on its own, the question of issuing mandamus would not arise. Therefore, my lord, the question of going into the right of the party did not arise at all. They said, well, they are agreeing, let's close this issue. And now, my lord, please see what happened to the other direction that were issued by your lordships, saying the petitioner must be heard. Because, my lord, your lordships,
petitioner should also participate is what was said.
Yes, your lordship said that. That has been set aside.
That I saw.
That has been set aside. Therefore, my lord, insofar as petitioner is concerned, the learned division bench was clear in its mind that he has no role to play. It is a matter between me and the board. And with respect to that, the court simply recorded the statement. And now, please be kind enough to turn to the last paragraph that your lordships are kind enough to point out to me. In view of the above, appeals are partly allowed by modifying the order of the learned single judge as under Clause 2 of the operative portion of the order of the learned single judge is modified, and respondent number 1 board is directed to initiate action against the respondent number 2. Needless to state, as per the provisions of the Act, for the alleged violation of the terms and conditions of lease cum sale agreement dated 7/6/2007, respondent board shall conclude the inquiry as expeditiously as possible and not later than 4 months from today, that is, date of the order passed by this court. Respondent board is at liberty to pass appropriate orders to protect its interests, needless to say, by adhering to the provisions of law. It is made clear that the respondent board shall carry out the exercise of inquiry into the matter without being influenced by the findings and observations made by the learned single judge in the impugned order. This, however, shall not affect the rights of the parties to seek appropriate remedy as may be available under law before the competent legal. This is the issue, my lord, relating to the locus. All that the court said was, my lord, when all this was done, and then kindly see, my lord, clause 3 and clause 4 of the operative portion of the order of the learned single judge is deleted. Yes. My lord, this particular sentence, however, shall not affect the rights of the parties to seek appropriate remedy as may be available under law before the competent legal forum, was in the context of the pending suit. You go and agitate your rights. If you are able to get it, well and good. If you don't get it, bad luck for you. And in this suit, my lord, just to recall to your lordship's memory, they wanted, my lord, a declaration that they are the shareholders of the company, relied upon an oral agreement.
That is dismissed.
Suit pending, IA for injunction dismissed, commercial appeal dismissed. I showed your lordship the order passed by the commercial court. Today, therefore, question as to whether he has a right or not is a matter which is still pending adjudication in the civil court. Now, my lord, all this was taken note of, and now your lordships may kindly see the order passed by his lordship, Justice Hemant Chandan Gowda, my lord, at page 245.
Yes.
Well, kindly see the KADB order now, my lord, which is subject matter.
After the order of the division bench,
yes,
what
yes.
KADB did?
Yes, 207. My lord, your lordship may kindly turn to page
196.
Yes, my lord. Please see, my lord. In operative portion is 207.
Yes.
This is what was questioned before in the second round of writ petition.
Yes, yes. Extended by 2 years. Lease was extended.
Kindly see page 207.
I've seen.
Yes. This was the order that was questioned. They gave us 2 years extra. Now, this is the reason why, my lord, we have some difficulty in this case. My lord, 2 years period from 3/9/2004.
No, now this is extended.
Yes, up to 2006.
Yes.
2 years for commencing construction.
2006.
I'm sorry, 2026. I meant to say 26. I meant to say 2026.
Yes, yes.
Well, 2 years from 3/9/2024.
Now, Nandakumar sir, if page 207 order, which was subject matter before Justice Hemant's order,
Yes, madam.
is for the same thing. What is now is only extension by 2 years and local.
No. Why now is a permission granted for us to sublease in terms of clause 11.
Sublease.
It's different.
It's the same.
Lease and
It's the
sublease.
same. This is one order passed, that's another order passed. All right, we have one difficulty, my lord. One of the reasons why we are a little concerned about this matter is this. Now, my lord, by virtue of the interim order that has been granted by this court, my lord, there is an agreement that has been entered into with an international company. My lord, they are a $50 billion company. They are a $50 billion company, and they are into manufacture of semiconductors. In fact, I'm given to understand, my lord, that every one of the smartphones that we have, or every one of the electronic gadgets, has
where is the KADB?
Has their semiconductor.
KADB is not present here.
KAB, my lord, I think the learned advocate general appears. I think he is.
All right, ನೀವು ಮುಗಿಸಿ ಮಾಡಿ. Yes.
With KADB. KADB.
My lord, they have this company to whom, my lord, the property is sought to be subleased called LAM Research. My lord, they have a market capitalization of $195 billion. And my lord, the whole difficulty, great opportunity for this country. My lord, that also must be taken into account by a writ court. My lord, that also must be taken into account. So difficult, my lord. I don't know how your lordships are able to manage this.
With the lordship's kindly, my lords.
Yes, I fully, sitting for few minutes, I realized it. I was telling my learned friend, I'm so grateful to vote for him.
Yes, yes.
Learned advocate general
Is
is there.
there? Well, I just wanted to know what's.
My lord, I just want to give your lordships, my lord, it may be a little aside, but I want your lordship to kindly take note of this public interest element also involved in this case. Of course, my lord. My lord, this lease that has been granted in favor of this lamb research is completely in public interest. Apart from whatever rights of the parties. My lord, can I give this small note to your lordships? Please see what is being done and how, my lord, all this interim order that has been granted comes in the way of it. My lord, Lam Research is a US-based Fortune 500 corporation, headquartered in California. It is a leading global player of innovative water fabrication equipment and services to the semiconductor industry. As a testament to its market dominance and financial scale, the company commands a market capitalization of approximately $195.7 billion as late as 2025. To put its technical position with context, nearly every advanced semiconductor chip manufactured in the world today, powering everything from smartphones and data centers that run artificial intelligence to advanced medical devices and defense systems, is built using Lam's proprietary technology. This leadership is not accidental. It is driven by a relentless focus on innovation, evidenced by a fiscal year 2025 R&D investment of $2.1 billion. One of the research centers is what is got to be done here. My lord, it is an infrastructure project. It is an infrastructure project which comes squarely, my lord, within the purview of the KADB Act. Taking into all this, if a permission is being granted, my lord. And now today, my lord, because of the interim order that has been granted, this huge investment that is going to come to the country has now been put in stake. But let us keep aside, my lord. Therefore, my lord, that's one of the critical aspects of your lordship. Against even according to them, an incoherent claim. I'm using that word because that is how it was contended before his lordship in the second round of litigation. And public interest on the other. Lord, what should prevail? I ask myself. And here, my lord, it is not, KDB is not acting as a quasi-judicial authority. Quasi is an administrative authority. They have passed an granting permission in terms of clause 11. If they have exercised a power under a contract, I ask myself, how is it written? At the instance of a person who has no right. Now, my lord, your lordship saw this. Please see some findings that have been recorded in the second round of litigation. My lord, if your lordships are kind enough to turn to page 245. I just want to draw quickly, my lord, to that. My lord, please be kind enough to see para 5. A coordinate bench wide order dated 16 para 5, my lord, at page 252. A coordinate bench wide order dated 16/5/2023 observed that respondent number 2 allotee had indeed violated the terms of the lease cum sale agreement by creating the 9 charges over the scheduled property without consent of KADB. Taking cognizance of the submissions of the respondent number 1 KADB to take appropriate action in accordance with law for the violation of the agreement and recognizing that the petitioners had highlighted KADB's inaction regarding the allotment of property. Single bench allowed the writ petition, permitting the petitioners to participate in the proceedings to be initiated by respondent number 1 under 34 and 30.
AG, nimdu mute ಮಾಡಿ.
Under 34 and 38 of the KADB Act. Agreed by this order. Now, my lord, his lordship is considering what is the effect of the division bench order. All that is concluded.
Forget para 15. Nothing is gone into on merits, but para 15.
Exactly. On locus itself, the court has said we are not going.
And para 30, 31, 32.
Yes. Your lordship may kindly see para 15. Kindly see, my lord, there is one very important observation that I want to show you. Kindly see, my lord, para 19.
19?
Yes, my lord.
It is noteworthy.
It is noteworthy that the observation in the single benches order dated 16/5/2023, which stated that the question of locus standi of a party bringing an instance of state inaction regarding breach. Yes, my lord. Clarify, we're not necessary parties, etc. Now, my lord, accordingly, petitioner's locus standi, if any, was negated by the division bench of this court.
And this has become final?
This appeal is pending. No interim order. Now, my lord, I also want your lordship to kindly see, my lord.
Now, one more clarification.
Yes.
Have these petitioners got anything to do with lease of this particular property or the sublease or the KIDB?
None. Petitioners, none.
No,
petitioner.
No, petitioners have nothing to do with this.
No, my lord. It is a pure transaction between the company and KIDB. Petitioners claim that they don't even say they are shareholders. There is an agreement in the year 2004. That is why they filed a suit.
That is the one which I had seen in my order.
Yes.
2004.
Yes. That is pending in the civil suit where they sought for an injunction. Injunction refused. My lord, kindly see that incoherent right, my lord, which I want to point out your lordship.
Incoherent right.
My lord, their case is, it is an incoherent rate, right? 9.1, my lord, if your lordships are kind enough. My lord, please be kind enough to turn to page 254. Now, kindly see 9.2, my lord. Furthermore, the learned counsels argued that the scope of the present petition is limited to protecting the incoherent rights of the petitioners. That is their stand. They don't have a right, and today incoherent.
No, that's why I wanted to ask, what is the relation in transaction between the petitioners, you, board?
Between petitioners and board, none. Between
You
petitioners,
and board, you have a private agreement.
I have an agreement. Petitioners and me, they claim that not. In fact, even there, my lord, the entire thing is opposed to fundamental principles of corporate law. It is a shareholders dispute, or they're not even a shareholder. I ask myself, does a shareholder have an interest in the property of the company? The answer is no. That was the first thing that we were taught, my lord, in college, that a shareholder is independent of the company. And kindly see, my lord, how the civil suit is also dealt with by, kindly turn to page. Yes, my lord. Which one? My lord, if I may, I want to point out your lordships. Kindly see, my lord, paragraph 26 at page 266. After having referred to a lot of case law, in addition to the negation of the locus standi of the petitioners herein, by the order of the division bench dated so and so, the Honorable Apex Court has held in the case of so and so that rights of shareholders in the company does not amount to more than a right to participate in the profits of the company, and that it does not stretch to having any share in the property of the company.
Rudimentary.
Two elements. And today, what is being done? We entered into a contract with them. It's all in large public interest. A big company is making a huge investment here. And at the instance of a person like this, and interestingly, my lord, the learned judge in the second round of litigation makes a very, very caustic statement against the conduct of the petitioner. I want your lordship to be kind enough. Kindly see para 31, my lord.
That's what 31 is.
In conclusion, where the locus of the petitioners herein who are disputed shareholders of the allotee before the proceedings of the KIDB against allotee in respect of violations of the lease comes agreement negated by virtue of the order dated 26/7/2023 passed by the division bench of this court, petitioners herein do not have locus standi to lay a challenge to an order passed in pursuance of the order dated 26/7/2023 under the garb of espousing public interest by calling attention of the court to state inaction qua unjust indictment. Furthermore, it is well settled that interest persons are not entitled to file public interest litigation. Now, last paragraph is very important, my lord. A bare perusal of the order impugned herein, which grants an extension of period of 2 years from the date of obtaining the plan sanction to implement the project development of the scheduled property, reveals that it inures to the benefit of the petitioners herein, provided they succeed in the pending litigations. It may thus be reasonably inferred that the instant petitions have been preferred by the disputed shareholders of the allotee entity solely to gain unfair advantage, settle personal scores, and coerce allotee. My lord, such a person. And this interim order is coming now. We have only 2 years. My lord, the candle is burning. It's melting. My lord, kindly see also, my lord, a statement of objections at page 48.
Whose objections?
Yes, my lord. Our statement of objections. We have produced, my lord, the copy. My lord, I don't think I want to take your lordships to the merits of the order passed by the trial court, which has been affirmed by the.
Let us not get into all that.
Let's not get into all that. That's exactly. And that was, in fact, if your lordship will kindly see the order that has been passed by the division bench, my lord. If your lordship will kindly see, my lord, the order at page 310. Please see how carefully the division bench has passed the order.
That I saw. Which division bench?
Division bench in their writ appeal against the order of his lordship, Justice Hemant Chandran.
ಅದರ ಮೇಲೆ ಆಗಿದಾರ?
ಅದರ ಮೇಲೆ ಹಾಕಿರೋದು. No, there's no stay.
Page.
Page 311. Today there is no appeal that is pending with respect to the first round of litigation.
That is disposed.
Over. Where, my lord, it was modified, it's all over. Now, as against the order in the second round of writ petition, appeal is pending. In that appeal, I want your lordship to kindly see, my lord, page 311, what was the order? The court had occasion to pass an order on 20th of January 2025, observing that having regard to the nature of the disputes involved in these appeals and the subject matter thereof, the parties may take instructions.
Mediation agilla.
No, my lord, what is important is mediation queer the dispute pending in the civil court.
Civil suit.
Only that. Not with respect to anything else.
OS 234.
Exactly. What more remains, I ask myself, my lord. And this interim order is seriously hampering the development. Okay.
Yes, Nandakumar, sir.
No, I thought the learned advocate general was waiting to make some submission.
No. You locust aitu. ನೀವು ಹೇಳಬೇಕು.
Let him reply, my lord.
I pay for the third respondent, not the sublessee. Of course, not.
ಅಲ್ಲ ನೀವು ಯಾರಿಗೆ?
Lamb.
For the sublessee.
Lamb.
Anything the advocate general has to say?
My lord, it actually looks like a pure private dispute to which KDB has been roped in. They have to settle their scores somewhere else, my lord. It looks like more like a suit for recovery of money or settlement of dispute through invoking 226 jurisdiction by challenging, even assuming what ultimately, my lord, your lordship judgment in division bench has held, they have no locus, my lord, and they have no right to be heard.
Yes,
and second thing, my lords, what we have done is annexure R1, page 107, in terms of the lease deed, we have given it to the respondent, my lords. Only two documents, annexure R1 and
that
page 107 of.
I will take it on.
Just a couple of submissions, my lord, before.
1 minute.
Kumar.
Srinivas Raghavan, sir. I'll take it on 12th.
Yes.
Because 10th and 11th I'm not sitting. Otherwise I would have taken.
Yes.
I'll take it on 12th.
Yes.
We'll finish.
Yes, but I'll come. I'll come. No.
Is 13th a possibility, my lord, instead of?
No. We'll finish it on 12th. 12th or 13th, only 2 days. Beyond that, illa.
No, 13th.
My lords, I'm sorry, my lords, I'm interjecting. I was patiently.
12th in the afternoon, have a part-heard matter. That's the only request.
Idu part-heard matter, sir.
I understand that. Before this week, I'm requesting.
Please don't extend the interim order. Let it come up any day.
I understand. Between 12th and 13th, court is asking for 12th. I requested for 13th. I don't know why my learned friend would.
My lords, I hope I'm audible.
Yeah, audible. Yes.
Yes, I'm sorry, my lords. I'm sorry I interjected. My lords, I was patiently hearing Mr. Raghavan. I have quite a few answers, my lords, to place before your lordships.
Correct.
I would request, my lords.
I'll hear you on the 12th.
May I, subject of course to your lordship's leave, may I request the 13th, my lords, if that is possible?
12th and 13th, both the days we'll hear and finish it. Whoever wants to finish on 12th, finish Madi. 13th will finish, close this.
I will only have about 5-10 minutes, but nothing more. Only to support what is
You're the Mugudre.
The lamb follows the lion, my lords. The lamb may not have much to say.
Nothing, but I'm only in support of what Mr. KG Raghavan has.
Mr. Raghavan will support Mr. Raghavan, my lord, on a lighter note.
If it's possible, otherwise you can appear, not a problem at all.
No, my lord. I didn't realize it was so bad, my lord. It was so bad.
Last time, adake you come.
Correct. I am extremely grateful. Because with
Well,
this is causing
permission,
us-
I'm only on the locus. I am,
I will make good locus.
we have not got into the merit of the matter. If there is,
Absolutely, my lord.
if
Much
I
as
hold you
this-
have locus, then merits. If I
No.
hold you have no locus, then petition goes.
Absolutely, no difficulty about it.
Yes.
My lords, I will make my submissions on locus. If at all they are casting a doubt, they are casting a doubt on locus because that's their best point. On merits, my lords, it's rock solid against them. And I will make good a case on locus.
All right. All right. So you'll submit on 12th or 13th?
My lords, I would request the 13th, my lords. I would request the 13th.
physically, Manoj.
13th ತಗೊಳ್ಳೋಣ.
13th.
13th.
Can we?
2:30. 2:30. That day, even if it is late, we'll finish.
Very well. Very
Welcome.
great.
Can I request Manoj Sajjan to come physically, Manoj?
ಯಾರು? He must be in London.
ಯಾರು ನಮ್ಮ Sajjan must be in London, my lord.
But now
No,
I
my
must point out, I see what looks like a room heater next to my learned friend, so London may well be correct.
Sorry, this is why.
Interim order may please be extended, my lord.
When the DG said brought some private issues being, therefore request to Sajjan to come.
No. Background is that Mr. Raghavan, when he was in New York, it became viral. So that was the.
Nandikumar, what you are saying, 50% is not audible.
I'm sorry, my lord. What I was saying was not very important. We'll say it on the 13th.
13th. Very.
Yes, 13th.
Interim order may please be extended, my lord.
I thought till 13th we'll do. 13th will close.
13th. Yes. Great.
Definitely.
Great.
Very grateful, my lord.
Great.
2:30. Yes.
Grateful to Manoj.
All right. ಎಲ್ಲರಿಗೂ
My lordship, may I make a submission, my lordship? Serial number 9, my lordship, Jagdish sir is held up in another court. I've informed the senior counsel also. Kindly the matter may be taken up on 14th, my lordship.
all right. 13th, not 14th.
13th Thursday, my lordship, special court will be there. Kindly, I've informed the
All
senior
right.
counsel.
14th. Yes.
Much obliged, my lordship.
Monday, 10th and 11th, I'm not there. Other days, yes, 14th. Yes.
Please,
13th,
madam.
books,
Much obliged.
whatever time we'll finish it.
Great.
ಅಲ್ಲಿ ಎಲ್ಲರದ್ದು ಅಪಿಯರೆನ್ಸ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಶೀಟರ್ ಇದೆ ಯಾರ್ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅದೆಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಆನ್ 13th.
14th, your lordship.
Interim order subsisting will continue to the next date.
Grateful.
Srinivas Naik. ಎಲೆಕ್ಷನ್ ಮಾಡ್ತೀರಾ ಯಾವಾಗ?
Sunday, my lord. Sunday, my lord. Any
Possible?
Possible.
The learned AGA on instructions, learned counsel appearing for the respondents, including the learned AGA, would undertake that the election should be held. Calendar permits ಯಾವಾಗ issue ಆಗಿದೆ?
Already it was issued and twice, my lord, it was adjourned.
ಮತ್ತೆ
Now it
can
is
we
it is-
resurface the same calendar of events?
No, only for practical purpose. Tomorrow they have to issue and fix the date for, my lord, election.
ಮತ್ತೆ ಅದಕ್ಕೆ calendar of events ಪ್ರಕಾರ ಅದಕ್ಕೆಲ್ಲ ಆಗ್ಬೇಕಲ್ಲ, whatever is to be done.
No, only thing is,
Nomination or etc. all that.
nominations will be filed on the same day. It will be, my lord, accepted or, my lord, rejected
We'll see.
on the same day, my lord.
The learned counsel for the respondents, including the learned AGA in unison, would submit that the elections to the subject society would be held on Sunday in accordance with law.
Please.
The submission is placed on record. List the matter on 17th.
Please.
17th ಬೇಡ, ಒಂದಿನ ಮುಂದೆ ಹೋಗ್ಲಿ.
Any date.
Which Sunday? This Sunday. ಅಂದ್ರೆ 17th ಬರ್ಲಿ. List the matter on 17th. The results.
No, they have
ಇದೇನ್
to,
ಸಂಬಂಧ ಇಲ್ಲ.
they
Dispose
have to announce it.
ಮಾಡ್ಬೋದಲ್ಲ?
They have to announce it on the same day.
ಅಲ್ಲ, dispose ಮಾಡಿ ಇಟ್ಕೋಬೇಕಾ?
ಮಾಡ್ಬಿಡಬಹುದು, dispose ಮಾಡಬಹುದು.
The petitioner is before this court seeking the following prayer heard so and so. The grievance of the petitioner is that the calendar of events were issued twice over and elections were deferred by the returning officer. The learned counsel appearing for the returning officer, the learned AGA and the proposed respondent.
3 and 4.
3 and 4 would in unison submit that the elections would submit that if elections are directly to be held, the same would be held on the ensuing Sunday. The learned AGA and the returning officer would submit that in accordance with law, the election should be held on the ensuing Sunday. It is made clear that the returning officer, the learned AG, as undertaken by the learned AG, and the returning officer shall hold the election strictly in consonance with law after following all the nuances. The aforesaid observation and recording the undertaking of the respondents that the election should be held on Sunday in accordance with law, the petition stands disposed.
Sunday means your lordship may mention
Sunday
it as
date akudi.
9th, my lord.
9th.
Please. Great. Sure.
In the light of the disposal, the IA for impleading would not be necessary to be considered.
Please.
Jagdish Patil sir. ನೋಡಿದ್ರಾ ಅದು ನೀವು ಮುಂಚೆ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಅದೇ ನಾನು ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ ನೆನಪು ನನಗೆ, ಅದಕ್ಕೆ ಇವ್ರೇನೋ ತಗೊಂಡ್ಬಂದ್ವಿ, ಅದಕ್ಕೆ ಮುಂಚೆ ಅವ್ರು ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೋದು.
Mine is entirely different. Annexure
ಬಟ್ ಈಗ ಇದೆ. ಬಟ್ ವಾಟ್ ಯು ಟೋಲ್ಡ್ ವಾಸ್ ಹಿ ಇಸ್ ಆಲ್ರೆಡಿ ಅಸ್ಯೂಮ್ ಚಾರ್ಜ್ ಅಂತ. ಬಟ್ ನಾನು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಈಗ ಮತ್ತೆ ಮಾಡಿಫೈ ಮಾಡಿದ್ರೆ ನೀವು ಬೇಕಾದ್ರೆ ಯು ಸೀಕ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಆರ್ ವಾಟ್ ಎವರ್, ಯು ವಿಲ್ ಪಾಸ್ ಸಮ್ ಆರ್ಡರ್. ಇದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡೋದು ತಪ್ಪಾಗುತ್ತೆ. ಅದಕ್ಕೆ ಅದು ಮಾಡಿದ್ದೀನಿ.
application and file.
ಹಾಕಿ ಅದು ಮಾಡಿಬಿಡಿ, ವಿಲ್ ಕರೆಕ್ಟ್.
Yes, sir. But Monday, your lordship.
ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ನೈಟ್.
Yes, sir.
ಅದಕ್ಕೆ ಆರ್ಡರ್ ಮೂವ್ ಮಾಡಿಬೇಕಾದ್ರೆ ಕ್ಲಾರಿಫಿಕೇಶನ್.
Yes, sir.
With my lord's kind permission, if my lords permit, my lords.
Yes, sir. Really?
Bench matter, my lords, the CRP, my lords.
Really, sir.
Please, my lords. My lords, in this matter.
Which is that?
I appear for the petitioner in this case.
Wait. Yes, which is that judgment?
My lords, Abraham Memorial Education Trust, my lords, passed in June. My your lordships had rendered this judgment in June, where my lords have recognized that the clear bar against revision or revision petition or application against interlocutory application further strengthens this court's conclusion that emphasis is on quick and early disposal of cases. My lords, this is insofar as maintainability, my lords. May I just make two submissions only, my lords, insofar as the merits are concerned. The sole ground, my lords, based on which the petitioner the petitioner is urging before this honorable court is that a counter claim against a co-defendant is not maintainable, my lords. And for this, they canvass this legal position. My lords, the Supreme Court, Honorable Supreme Court, my lords, in Rajul Shah has very clearly laid down that solely against a co-defendant, a counterclaim is not maintainable. However, if it is filed against a plaintiff and also a co-defendant, then there is no bar to such maintainability of a counterclaim at all, my lords. If my lords permit me to just read out, my lords, just para 21 of this judgment, para 20 of this judgment, which
20 and 21, Rajal Manoj Shah.
Please, my lords, I need not labor further. It refers to the earlier decision of Rohit Singh, my lords, which is also very clear on this particular point.
Rohit Singh is clear. Rohit Singh is 2006 12 SEC, sir.
Please, my lords. Certainly,
that is relied on by the Apex Court in 1958 2025 SEC online SC. That is Rajul Manoj Shah.
I'm grateful, my lord. I'm grateful. Therefore, the position is very amply clear. My lords, the only other thing that they say in their petition, which again they're trying again to misconstrue a decision and misrepresent a legal position, they say, my lords, that there is a decision of Ashok Kumar Sharma versus Rakesh Kumar Sharma, my lords, which they cite in their petition as well. And they're saying that this distinguishes the Supreme Court decision, but what they have not disclosed, this I am reading from para 10 of their CRP, my lords. Para 10 of their petition, they say, trial court misapplied the law, misconstrued the judgment and Ashok Kumar Rakesh Sharma, which clarified that the judgment of Apex Court in Rohit Singh had not considered so and so. My lords, I pause here. Rohit Singh, as my lords just now mentioned, is a judgment of the Honorable Supreme Court. This judgment that they're relying upon, Ashok Sharma versus Rakesh Sharma, is of the Honorable Punjab and Haryana High Court, my lords.
Yes.
And they've not even set out the citation very conspicuously in their petition. Therefore, my humble submission, my lords, is this. Insofar as legal submissions, their submissions are contrary to the legal position. That apart, my lords, if I could please say this, my lords, that I am
yes.
Lords, I appear for the respond number 2 in this matter, my lords.
Wait, Manjunath Mukspidli.
Please.
May please, my lords. My lords, I am the defendant number 2 in this case. Defendant number 1, my lords, files a counter claim, making, my lord, certain claims against the defendant number 2 and the plaintiff.
Yes.
I filed an application under Order 7 Rule 11 seeking rejection of the counter claim. saying, my lords, that the counterclaim as against a defendant, as against a co-defendant would not be maintainable, my lords. My lords, I relied on Ashok Kumar Sharma, and my lords, the defendant number 1 relied on Rohit Singh. If my lords would kindly peruse, I have produced the judgment of Rohit Singh as well as Ashok Kumar Sharma, my lords, before my lords. If my
Yes,
lords would
yes.
kindly come to Rohit Singh, my lords, for a moment.
Yes. Para
My lords,
21 of Rohit Singh, sir.
much before that, my lords. What
No,
was actually...
the crux is in para 21, just see.
Yes, my lords. Yes, my lords. My lords, but what was that the Supreme Court dealt in Rohit Singh has to be considered, my lords. If my lords should kindly, my lords, as this judgment of Rohit Singh, my lords, the memo of citations that I have produced on 19/9/2025, for a moment, please, my lords.
Yes.
Para 64.
Of?
Sorry, page 64, my lords.
Page 64, yes.
Yes, yes.
Yes, sir.
Page 64 of my memo of citations. Para 17 of the judgment of Rohit Singh, my lords.
Yes,
This
sir.
was the issue what was dealt by the Supreme Court, my lords. This is, my lords, a suit for injunction, my lords, where under, my lords, defendant number 2 and 3 did not even raise a counterclaim. They made an amendment to the written statement, my lords, and that amendment, my lords, was held to be a counterclaim by the trial court, which was later, my lords, the Supreme Court says it is not maintainable, and it was only on the aspect of whether there was a cause of action or whether this amendment can be construed as a counterclaim was the subject matter of adjudication before the Supreme Court. That, my lords, will find it at para 17. We shall may please, my lords, may I read?
Yes.
Yes, we shall first consider whether there was a counterclaim in the suit in terms of Order 8, Rule 6A of the Code of, in this case, the suit was filed against the Divisional Forest Officer and the State of Bihar as defendant number 1 and 2 on 26/2/1996 by respondent. After the written statement was filed by the defendants, issues were framed and the suit went to trial. On 3/6/96 and 6/6/96, the evidence on the side of the plaintiff was concluded. On 14/6/96, the evidence on the side of the defendant was completed. The judgment was pronounced and it appears that the judge was subsequently transferred. Therefore, on so and so, arguments were heard again by the successive judge and judgment was reserved. So, my lords, the whole issue, my lords, was whether there was a counterclaim as stipulated under Order 8, Rule 6A was the matter of adjudication before the Supreme Court in Rohit Singh. And at para 21, my lords, the Supreme Court holds like this, my lords, that my lords would find at page 66. Normally, a counterclaim, though based on a different cause of action than the one put in suit by the plaintiff, could be made, but it appears to us that a counterclaim has to be necessarily to be directed against the plaintiff in the suit, though incidentally or along with it, it may also claim relief against the co-defendants in the suit. A counterclaim directed solely against the co-defendant cannot be maintained. By filing a counterclaim, the litigation cannot be converted into some sort of an interpreter suit. So, my lords, this was never the subject matter of dispute which was adjudicated by the Supreme Court, and that was never a res integra, my lords. The Supreme Court dealt with whether there was a cause of action to file the counterclaim. It did not consider the aspect of whether a counterclaim can be filed against a co-defendant or not. Now, my lords, if my lords should kindly peruse the Punjab and Haryana High Court judgment, my lords, which I had relied upon, if my lords should kindly come to...
That considers Rohit Singh also.
That considers Rohit Singh, distinguishes Rohit Singh, and also says as to how Rohit Singh cannot be made applicable, my lords. That, my lords, will find it at para 22, my lords.
Yes.
May I please, my lords, page 7 of my the citation memo, my lords.
Yes.
Para 22 of the judgment of the Punjab and Haryana High Court.
Yes.
para 22. However, it is pertinent to mention that the Honorable Supreme Court in the subject case, that is Rohit Singh's case Supra, had held that it appeared to them that the counterclaim as necessary to be directed against the plaintiff in the suit, though incidentally or along with it, may also claim relief against co-defendants in the suit. However, perusal of the dictum of the Honorable Supreme Court reveals that the question as to whether the defendant can file counterclaim against co-defendant was never as such considered in that case, as the moot question before it was with regard to the counterclaim having not been properly filed in that case. It was at that stage at which counterclaim can be filed, which was in dispute. Looking at this in Soma Devi's case Supra, it has been observed that this judgment is that is Rohit Singh's judgment is not the precedent on the point that the defendant as a matter of right can file counterclaim against co-defendant. As an independent remedy, and it was also observed that Honorable Supreme Court having held that the counterclaim as necessarily to be directed against the plaintiff in the suit, it was only so said while considering the counterclaim against the plaintiff that the court can grant an incidental relief against a co-defendant also. May I please request my lords to kindly peruse Order 8 Rule 6. This is also been dealt by the Punjab and Haryana High Court. That my lords will find it at para. Starts at para 17, my lords, of the very same judgment, Ashok Kumar Sharma. My lords, the entire Order 8 Rule 6A has been reiterated, my lords. Para 18 at page 5, my lords. From the aforesaid provision, it is evident that a counter claim can be filed against the claim of the plaintiff, and it can be filed against regarding a cause of action accruing to the defendant against the plaintiff. However, in the light of the aforesaid provision, there is no question of a counter claim being permissible against a co-defendant by a defendant in the suit. Now further, my lords, still further perusal of the provision contained in Rule 6A3.
No, the provision itself is clear.
Yes, the proviso Rule 6A3, Rule 6B, Rule 6C, 6H, sorry, 6F and 6G, they all my lords give remedy only to the plaintiff.
See, the only issue, Manjunath, is if it is a counter claim simpliciter,
please,
against the co-defendant, it is definitely not maintainable, no doubt. But what the co-defendant is trying to say is, it is the counter claim against the plaintiff also.
Yes, yes, very well. No, my lords, as regards the
then what happens is that semblance of maintainability springs in. That I will consider. Yes.
Please, my lords.
That is all the issue in this. If it is simple, defendant versus defendant counterclaim definitely is not maintainable.
Correct. No, even this aspect has been dealt with. 1 minute. I'm sorry, my lords. This very aspect has been dealt with by the Punjab and Haryana High Court, and it says that even incidental reliefs also cannot be sought.
We'll see. We'll answer that.
Because Rule A, Rule C,
with all due respect, my lords,
nor Rule 6C, nor Rule 6F.
Haryana High Court, with all due respect,
sorry,
my lords, when the language of the honorable,
I have heard you. Wait. Yes.
Let me complete, sir.
I'm sorry.
I'm sorry. My lords, if my lords should kindly permit me to just go through the provision again. My lords, if my lords should kindly see Rule 6B. It says, my lords, where any counter claims to be stated, where any defendant seeks to rely upon any ground as supporting a right of counterclaim, he shall in his written statement state specifically that he does so by way of counterclaim. Now please come to 6C, exclusion of counterclaim, where a defendant sets up a counterclaim and the plaintiff contends that the claim thereby raised ought not to be disposed of by way of counterclaim, but in an independent suit, the plaintiff may at any time before issues are settled in relation to the counterclaim apply to the court for an order that such counterclaim may be excluded. Now this remedy, my lords, is available only to the plaintiff and not to the defendant, not to the co-defendant. Similarly, Rule 6 F 6E, my lords, default of plaintiff to reply to the counter claim. If the plaintiff makes default in putting in reply to the counter claim.
That's the only issue to be answered. I will answer.
Yes.
Yes.
All that I say is
One submission, my lords. I keep
Order
it very short, my
I've
lords.
heard you, Matteno.
only to the plaintiff
One
only.
day, please, my lords. This is something on not on legal submissions at all, my lords. What is happening, my lords, because of this fight between the co-defendants, my suit is stayed, and if at all, my lords, they are to seek an independent.
Yes, we'll answer it.
Milords.
Anything to
Milords,
say?
I have only two submissions, my lords. My learned revision, my friend's submission that, my lords, Punjab and Haryana High Court interpreted Rohit Singh will fall to ground, my lords, in the light of a very recent judgment what Honorable Appellate Court has interpreted. That's number one, my lords. And secondly, my lords, a typical issue what is involving in these facts is in page 52 of the revision petition, which is indicative of the judgment, my lords, the factual scenario, what the relationship between the three parties has been very clearly called out in page 52. My lords, if I take my lord's kind attention to that page 52.
No, the issue is only this, whether counterclaim is maintainable or not. Let us not go into the facts of the case.
My lords, tripartite
As
agreement.
against a co-defendant, whether it is maintainable or not.
My submission is that, my lords. My submission is that, my lords. Order 6 rule says counterclaim, my lords, not against the party, claim of the plaintiff. The plaintiff's claim is not just against the defendant number 1. It is against defendant number 1, 2, 3, all of them. Now, my lords, for that aspect, the trial court very clearly considered the facts and held it. Page 52, my lords, it is observed. In the present suit, it is to be noted that I am reading, my lords. I may be permitted. In the present suit, it is to be noted that the plaintiff, first defendant and defendant number 2 have entered into tripartite agreement dated 25/4/15. There are numerous obligations to be performed by each party as per the document. Those obligations are mutual and ancillary to each other. As per the document, each party is entitled to seek performance. Admittedly, defendant number 2, who is a revision petition, has sold the subject flat to the defendant number 3, who is another purchaser. It was not sold. Even the defendant number 2 could have sought for specific performance against the plaintiff and defendant number 1. Milords, the court is very clearly acknowledging even rights of the second defendant for against the first defendant. That is the factual matrix under which
this is a legal question that has to be answered.
Please,
We'll answer.
Please.
Reserved.
Other things, is already covered. Rohit Singh
Interim order may kindly be
Interim
extended.
order will continue to the next date. Yes. Heard reserved. Yes. And 230 matter. ಎಷ್ಟಿದೆ ಕೊಡಿ ವಿಶ್ವನಾಥ್ ಹೆಗಡೆ ಎಲ್ಲಿ ಇಲ್ವಾ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ ಟ್ಯಾಗ್ ದಿಸ್ ಪೆಟಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಸೋ ಅಂಡ್ ಸೋ ಸೇಮ್ ಆರ್ಡರ್ ನಂದೇ ಆರ್ಡರ್
ಹೌದು ಅಲ್ಲಿ ಜಿಎಂ ಟೆಂಡರ್ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ, ಇಲ್ಲಿ LBRS ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ನಾ ಡಿಸೇಬಲ್ ಬಿಫೋರ್ ದಿ ರೋಸ್ಟರ್ ಬೆಂಚ್ ಮೇಲೆ ಮಿಲಡ annexure G and H ಮಿಲಡ
ಸೇಮ್ ಆರ್ಡರ್ ಟ್ಯಾಗ್ ಸೇಮ್ ಆರ್ಡರ್ ಆಮೇಲೆ
ಮಿಲಡ ಮೇ ಸೀಕ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮಿಲಡ
ಈಗ ನಾನು ಐ ವಿಲ್ ಸೈನ್ ಓನ್ಲಿ ಅಂಡ್ ಗೋ ಅನ್ಪೂರ್ಣ ಇದು ಮಾಡ್ಬಿಡಿ
ಪ್ಲೀಸ್ ಮಿಲಡ
ಸೇಮಾ
ಹೌದು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಗವರ್ನಮೆಂಟ್
ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ 2:30ಗೆ ಯಾವ್ದದು
ಅದೇ ನನ್ನ ಪರವಾಗಿ ನಾನು ಇದ್ರಲ್ಲಿ ರೆಡಿ.
ನೀವು ಎಂಗೇಜ್ ಬೇರೆ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಇದ್ದೆ, ಅದಕ್ಕಾಗಿ ಪ್ಲೀಸ್ ಸಾರಿ. ಅದು R1 ಮೇಲೆ ಗವರ್ನಮೆಂಟ್ ಮೇಲೆ 2 and 3
ಅದರಲ್ಲಿ ಹೇಳಿದ್ದೀನಲ್ಲ.
ಇಲ್ಲ, ಅಲ್ಲಿ ಈರನ್ಗೌಡ ಕಬ್ಬೂರ್ ಅಂತ ಹೇಳಿ ಆಗ್ಬಿಟ್ಟಿದೆ.
R1 AGA 2
ಈರನ್ಗೌಡ ಕಬ್ಬೂರ್ 2 and 3
ಈರನ್ಗೌಡ ಕಬ್ಬೂರ್ 1 ಮಾತ್ರ ಗವರ್ನಮೆಂಟ್.
ಎರಡರಲ್ಲೂ
AGA ಎರಡರಲ್ಲೂ ಸೇಮ್. ಅದು ಮಾಡಿಬಿಟ್ರೆ ಸೈನ್ ಮಾಡು. ಅಯ್ಯೋ ಸ್ವಾಮಿ ತಗೊಳ್ಳಿ ಸೀರಿಯಲ್ ನಂಬರ್. ಕಂಪ್ಲೇಂಟ್ ಇದ್ದಾರಾ? ಓ ಸೀನಿಯರ್ ಇದ್ದೀರಾ? ಇದೆ ಸರಿ, ನಾನು ನೋಡಲಿಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಇದ್ರಲ್ಲ ಇಲ್ವಾ? ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಹಿಯರ್.
ಇಲ್ಲಿ ಬಂದಿಲ್ವಂತ.
ಇಲ್ಲಿ ಬಂದಿಲ್ವಾ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಯಾರು ಇದಾರೋ ಗೊತ್ತಿಲ್ಲ.
ಹಾ ಎಸ್ ಸರ್.
ಲೆಟ್ ಮಿ ಮೇಕ್ ಎ ಬಿಗಿನಿಂಗ್ ಅಟ್ ಲೀಸ್ಟ್.
ಬಿಗಿನಿಂಗ್ ಅಂದ್ರೆ ಆಗಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಕ್ಕೆ.
ಬೇಡ.
ಇದು ಇನ್ಸಿಡೆಂಟ್ಲಿ ಮೆಲಡ್
ಡೈರೆಕ್ಷನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಅದನ್ನೇ. Incidentally, presumably questioning the legality and correctness of the order of stay that has been granted by this honorable court. It appears they had filed a special leave petition before the honorable Supreme Court.
Interim order in this case?
Yes, my lord. And then that petition had come up this day morning. Adali, they wanted an expeditious disposal and all that, vacation of stay. And when the honorable judges expressed some drastic this one, then they withdrew the petition and got it dismissed. Dismiss, withdrawal, I may be permitted to dismiss, withdraw the petition, therefore dismiss as withdrawn. A special petition number ಕೊಡಿ.
ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ ಇದ್ರ ಮೇಲೆ?
Not yet uploaded.
ಅಲ್ಲ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ.
No, I think
12 ಗಂಟೆನಲ್ಲಿ.
Interim order was detail ಅನ್ಸುತ್ತೆ ನಾನು.
Detail
order ಅಲ್ಲ. ಸಾವು ಮಾಡಿರೋದು detail order. My lord's order is a detailed order.
Cost charge. It is a 4-page order.
My lord, kindly recall to your lordship's memory, my lord, your lordship's judgment and also a coordinate bench of this honorable court would say
went to Supreme Court
various institutions, Juvenile Justice Act, ಆಮೇಲೆ ಒಂದು ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ, and that order came to be upheld by the Supreme Court. ಎಲ್ಲ ಆಗಿದೆ ಅದರಲ್ಲಿ.
No, this is ನಾನು ಯಾವ್ದು ಬರೀ one line order ಬರೆದು ಬಿಟ್ಟಿದೆ ನಾನು ನೋಡಿದೆ ಆಮೇಲೆ.
ಇಲ್ಲ ಸ್ಪೆಷಲಿ ಪಿಟಿಷನ್ ನಂಬರ್ ಕೊಡಿ.
It's clear. In that light, the offenses, the order upload ಆಗಿದೆ ನೋಡಿ. That light, the offenses that are all quashed in the charges so framed in the aforesaid case should necessarily endure with benefit. So SP Sons, ಇಲ್ಲಿ ನಾವು quash ಆಗಿರೋ ಚಾರ್ಜ್ ಎಲ್ಲ ಚಾರ್ಜ್ ಇದೆ ಇದರಲ್ಲಿ. On the face of it, it should go.
In diary number 52072 of 25 today.
ಅದು ಬರ್ಕೊಳ್ಳಿ ಅನ್ಪೂರ್ಣ.
52072 of 25.
Diary number 52072
of 25.
720 of 25.
The bench headed by Justice Vikramnath dismissed the petition as withdrawn. But many times we argue for some time, and then having read the mind of the court, or the court would suggest, why do you invite some problem or the other?
That is their withdrawal.
That has been the practice in court. Then the court having made certain serious observations against the conduct of the person who had approached and the persons who are behind it and all that, they said, if you are not going to, you want that it is order of dismissal on merits, or you are going to withdraw the petition, then I am told that they withdrew the petition as dismissed.
So
because my lord posed a question to me.
14/10/2024 order was questioned.
My lord questioned me whether there is any
direction ಇದೆಯಾ?
direction.
ಇದೆಲ್ಲ ಹೋಗ್ತಾರಲ್ಲ ಅಲ್ಲಿಗೆ. This 14/10/2024 order was challenged.
And then they have the Supreme Court has permitted them to move this honorable court either for early hearing or for vacation of stay.
ಹಾಗಾದ್ರೆ 27 ತಗೊಳ್ಳೋಣ.
As my lord pleases. ಅಲ್ಲ 27 ಬೇಡ.
28.
ಅಲ್ಲಿ 26, 27, 28 4 ದಿನಕ್ಕೆ
3 ದಿನ ಇರಲ್ಲ ಅಂದ್ರೆ.
4 ದಿನ 26, 27 either little early my lord or little later ಅಷ್ಟೇ.
21ಕ್ಕೂ ತೊಂದರೆ ಇಲ್ಲ.
ಅದೇ if my lord is sitting in Bangalore, I will
doubt 27, 28 I'm there. So 21st ಹಾಕಿರ್ತೀನಿ. Appear online.
If for any reason my lord I have any inconvenience, I will renew my request of requesting the lordship to adjourn the matter.
Direction ಇದೆಯಾ ಅಂತ ಕೇಳಿ.
ಇಲ್ಲ
ಬೇರೆ ಏನೋ ಬಂದಿದೆ.
ಇವತ್ತಾಯ್ತು. DG today in the morning at 12 o'clock. Dismissed.
Yes.
Idalli, I have raised one very, very serious and important legal, apart from the merits of the matter, my lord, probably it may warrant a judgment at your lordship's hands. My lord, Child Welfare Committee is there.
Yes.
In every state, my lord, in every district, there is a Child Welfare Committee.
Yes.
The child would go to Child Welfare Committee through one source or the other.
Yes.
We are not concerned with the source. What are the duties and obligations of the Child Welfare Committee? My lord, according to me, the duty and obligation of the Child Welfare Committee is only counseling, number 1.
Yes.
Number 2, my lord, giving the child a support.
Yes.
Number 3, my lord,
taking care of the child. Number 4, a rehabilitation. ಅಷ್ಟೇ ಅವ್ರ ಪವರ್ಸ್, ಇನ್ನೇನು ಇಲ್ಲ ಅವ್ರ ಪವರ್ಸ್.
ಇದರಲ್ಲಿ ತುಂಬಾ ಜಾಸ್ತಿ ಮಾಡಿದೆ.
They can't record the statements of witnesses and all that.
No, unless that is clarified.
Yes, my lord, probably kindly have a look at
going on.
No, in every case they do like this. But kindly just now that your lordship has little time for me.
Yes, yes.
Have a look at section 24, 25 and 26 of the POCSO, my lord.
Good POCSO.
This is serious and I am supported by any number of judgments of various other courts other than our court.
Then we will hold it.
Adukosra probably your lordship have to lay down the law anta. Illi chapter 6 alli section 24, recording of statement of a child. The statement of the child shall be recorded at the residence of the child or at a place where he usually resides or at the place of his choice, and as far as practicable by a woman police officer not below the rank of a sub-inspector. Kodi. Court officer, then Kodi. The section 24, chapter 6.
Yes, yes.
The police officer while recording the statement of the child shall not be in uniform. The police officer making the investigation shall, while examining the child, ensure that at no point of time the child come in contact in any of the no child shall be detained in the police station in the night for any reason. The police officer shall ensure that. So section 24 places an obligation, legal obligation only upon a police officer to record the statement of the witnesses. Now kindly go to section 25. Recording of the statement of a child by a magistrate. Well, at par with section 164 of the CRPC. Then kindly go to section 26. Additional provisions regarding the statement to be recorded. The magistrate or the police officer, as the case may be, shall record the statement as spoken to by the child in the presence of the parents of the child or any other person in whom the child has trust or confidence. Wherever necessary, the magistrate or the police officer, as the case may be, may take the assistance of a translator. The magistrate or the police officer, as the case may be, in the case of a child having mental, etc., etc. Illi CWC ನವರಿಗೆ jurisdiction ಎಲ್ಲಿದೆ statement record ಮಾಡೋದಕ್ಕೆ.
And they have recorded the statements in this case.
Have a look at some of the couple of judgments of decision bench judgments. First is kudi. Well, it is only an academical interest.
No, see, those corrective things have to be done.
Every day it is happening.
No, what to institutional, I was hearing an LOC challenge to the LOC. What this person against whom LOC is there goes before the trial court, does not divulge proceedings pending before me, and gets the LOC quashed. Magistrate. LOC executive order quashed by the magistrate, and he flies off. Tomorrow I am asking, bail is cancelled, is already gone.
Magistrate has done it.
Magistrate order court is flown out of the nation. So I have now ordered that no magistrate will touch challenge to the LOC.
No, that could be done only by a constitutional court.
Constitutional court, it's an executive order, it can't be done.
They have to file a writ petition, seek for quashing of LOC.
How can a magistrate quash LOC? He has quashed. LOC is hereby quashed, you are free to go.
Have a look at this division bench of the Delhi High Court.
Yes, sir. Yes.
The Honorable Chief Justice.
Yes.
Well, kindly go to last page of this judgment.
Yes.
Page 39, madam.
Yes.
ಯಾವುದು ಇದೆ ಇಲ್ಲಿ 87 ಇದೆ. ಏನು ಸರ್ ಇದೆಲ್ಲ ನಿಮ್ದು. Question number 1. What is the legality of recording a statement or version of the incident enumerated by a victim of sexual offense by an NGO or a private counselor and filing of such statement or counseling report along with a charge sheet before the trial court and section 173? A statement under the POCSO Act can be made only to a police officer or a magistrate, although they don't make a reference to CWC here. Yes. The answer is a statement under the POCSO Act can be made only to a police officer.
So CWC has no power to
No,
record
next to
statements.
no judgment. CWC power say illa anta ಹೇಳ್ತಾರೆ ಬೇರೆ ಕೇಸುಗಳಲ್ಲಿ. Provisions of POCSO Act or the Juvenile Justice Act do not contemplate any report to be made by a counselor. It further makes it explicitly clear that counseling this report / notes of the counselor, as well as any person or expert recognized under the POCSO Act and rules of 2012 and the JJ Act are confidential in nature, and the same cannot be made a part of the charge sheet or otherwise on the trial court record.
Yes, sir.
Blood. Next judgment of this court is this is in 2023, my lord.
Yes.
Kindly go to para 55. Incidentally, I thought of inviting my lord's attention.
No, it's necessary.
In fact, strictly speaking, my lord, I was telling my colleague, the statement that is recorded by CWC is in my favor. Still, my lord, even then, I shall invite her statement also before CWC, which is in my favor, 100% in my favor. That is the earliest statement of the victim. Earliest statement of the victim. Then my lord 161. Then my lord 164. Again 164 is in my favor. Nothing has happened. My lord, kindly go to paragraph 55.
Yes.
This is directly the power of CWC. CWC, while creating the report,
investigations,
has to be conscious of the scope and limitations of its jurisdiction. The CWC report is not part of the investigation made by the police into the offense. The report cannot be equated with the statements of the victim made under the relevant provisions of CRPC. Number of judgments are there because all of them are South India judgment court judgment. Probably it warrants a judgment at your lordship's hands.
Yes, we will definitely in this.
Then I thought I should, despite the fact.
Now that there is no, tearing hurry there is no direction by the apex court.
ಇವತ್ತು ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಡೈರೆಕ್ಷನ್ ಕೇಳಿದ್ರು ಅದು ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ.
This is generally why sometimes a detailed order is needed.
Kindly recall to your lordship's memory, in this very case itself, 2 crimes.
Yes.
One is 448 against me. 445 is against the person who is behind the screen and his wife and this called victim in this case itself. Police would file a charge sheet. Charge sheet ಹಾಕಿದ್ದಾರೆ. ಏನಂತ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ on the strength of the evidence which they would collect, including the telephonic conversation of the victim with one of her teacher. Kindly recall to your lordship's memory, the teacher would even come forward to say, you make a false statement against Swamiji. No, I don't want to make a false statement. It will be a sin which I would be committing. It is going to affect my future educational career, matrimonial career and all that. When she says it is matrimonial career, don't bother about it. I am going to marry you. Say that false statement that Swamiji did like this. But that forms part of the record of this case pursuant to the direction which my lord has issued in a criminal petition that had been filed by the accused in this case. If that were to be read.
There was one more filed 311 application there on the recent time. Same.
That was in relation to first case, which was passed in the.
That was in relation to the first case, minute.
Whatever. That's become final. Supreme Court goita.
Supreme Court lo the your lordship's order came to be confirmed. Crashing my lord all those charges.
Crashing 311 application. Tave appear adre adrallo Hasmat Pasha sir bandralla adrallo.
Recall of Baswaraj also.
Yes.
Idralli evidence is tape recorded version evidence is there, and she says yes, I did make a false statement. It is my voice at the 164 statement.
Heard the learned senior counsel Sri V. Nagesh appearing for the petitioner to hear the complainant list the matter on 21st. 21st is Friday, 2:30 mela.
Please.
Any other idea? 20. ಇನ್ಯಾವ್ದಾರು ಇದೆ ಸರ್?
ನಾನು ಕೋರ್ಟಲ್ಲಿ ಯಾರು ಇರೋದು? ನಾನು
21st ಹಾಕ್ಬಿಡಿ ಎಲ್ಲ. ಇದು ಪ್ರಕಾಶ್.
ಪ್ಲೀಸ್ ಕಲೋಡ್ ಸರ್. ಎಜಿ ಅವರು ಏನೋ ಇಲ್ಲಿ ತಾವು ಇಲ್ಲಿಗೆ ಬಂದಾಗ್ಲೇ ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಬಂದಿದ್ದಾರೆ ಸರ್ ದೇವದಾಸ್ ಸರ್.
ಆಯ್ತು ಸರಿ.
28 ಆಗ್ಬೋದು.
Very well.
ಅದಿಲ್ಲ. ಇಲ್ಲ ಒಂದು ನಿಮಿಷ ತಗೊಳ್ಳಿ ಇದು. ಸೀರಿಯಲ್ ನಂಬರ್ 24, 28 ಆಯ್ತಾ. ಆಮೇಲೆ ಇನ್ನು ಉಳಿದಿದ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಇದೆ. 20, 23, 24, 3, 28 ಆಯ್ತಲ್ಲ.
In serial number 48, my lord, I will kindly request up in 13, my lord, because in 17 out of station.
13 ಆಯ್ತು.
48 minutes.
Court officer.
Court officer. Madam, Bangalore list serial number 20.
2811.
Thank you.
23, madam. Bangalore list serial number 23.
Bangalore list 2811, madam. 23.
Okay, thank you.
Madam, serial number 14. Bangalore list serial number 14.
142111.
20.